Appellate side mentioning means please mention when you take up the appellate side matters. But we directed it to be written in the list that we'll be taking up original side matters first. That was missed out by our officers, by my PA. This morning, that's why we have announced that we'll take up after the original side.
Well, this is my application.
Yes, Mr.
It's an application for two purposes. One, that an order was passed on 11th of October 2023 by the earlier bench. My lord, this is IP faculty
Yes.
in the division room, where my lord had directed the receiver to execute a deed of conveyance in respect of the Charity Bazaar property in favor of the respondents, some of the respondents. And my lord, we were given the liberty because there was a problem with the stamp duty valuation, because the property is, the sale agreement was of 1952, and ultimately in 2021 the decree was passed as to how the property is sold. And
The suit was for what?
suit was for specific for, there were two suits.
Right.
Well, I have prepared a list of that.
Just an indication.
Suit was for, there was a one suit in 1957 which was decreed. Then in 1959 another suit was filed challenging that decree, saying that Muralidhar Saraf cannot take the entirety of the property. So that second suit was ultimately first decreed in 2003. Thereafter, my lord, execution proceedings started. Proceedings were filed under section 47, which was allowed. Then an appeal was filed. In the appeal, a terms of settlement was filed, and in 2021, on the basis of another terms of settlement, a decree was passed, stating that the property will be sold to the respondent numbers 1 to 8 through a receiver. However, the terms of settlement provided the ratio in which the property will be sold. Once the property is sold, how the transferees will have shares.
Interstate the transferees.
Interstate the transferees. How in that, the respondent number 2, there was no share. So ultimately, that some time was taken in having the deed of conveyance finalized. The appellants filed an application for expedition. That was allowed. In that, an order was passed ultimately on 11th of October 2023 that the receiver who was appointed under the decree of 2021 will sell the property, execute the deed of conveyance, and we shall present.
You are the?
I am the respondent.
One of some other.
1 and 3 to 8.
All right.
4 to 8. This application is by respondent numbers 4 to 8, but I was representing the respondent numbers 1 and 3 to 8 earlier. That we shall present the deed for registration,
yes,
with stamp duty on that disclosed valuation of 2 crores, and then 47A procedure will start, and if we cannot justify our valuation, then we were to undertake to pay the balance court stamp duty and registration fee ultimately. Now, once then the respondent number 2 raised an objection before the receiver that his name is not mentioned.
Respondent number 2 was a party to the compromise?
Yes.
All right, then?
He was party to the compromise.
Then?
That, so within the time frame, we could not get the
deed executed
or presented. Hence, we filed this application.
This application is praying for?
Praying for twofold. One is for extension of the time which was given by my Lord Justice Mukherjee's division bench.
Yes.
And for the receiver to execute the deed which is annexed to the petition.
One other aspect, respondent number 2, by way of a written objection, had taken an objection by way of
he had filed a letter. He had filed a letter before the receiver.
All right.
So receiver did not execute because of that objection. So we came to the court. Now his objection is that respondent number 2 and respondent number 3 are two HUL. Now they are, the members are heirs of late Muralidhar Saraf. Now they are saying I have a right in the immovable property because of that first decree of specific performance, which was passed in 1959.
But that merged into the compromise.
That marked the compromise. Later on, there was a company proceeding in respect of a company called Ganesh Properties Limited, which was there since 1951 as a lessee of crediting order. Now, this company is also closely held by the parties here. In a proceeding, company proceeding, it was in 97, an order was passed as to how the company, the shares in the company will be. And in that order, it was also directed that even when the property is purchased, it will be purchased in that fashion. At that point of time, there were three groups. The Saraf group consisting of respondent numbers 2 and 3, the Jajodia group, and the Arya group. Acharya. Now, however, then Saraf group had 44%. But when the terms of settlement was filed in 2021, the where the respondent number 2 was also a party.
The company court order was prior to the 20.
Right. That was in 97. Then, my lord, the decree came of 2003, and then the execution proceeding, and finally the decree of 2020.
No challenge has been preferred to that decree. This is no. That's correct.
There is no challenge. And so we are saying that when we prepared the deed of conveyance, because
you want an extension of time, and for a direction to execute the deed.
Yes, that is what I want.
Now, respondent number 3 has is one of the beneficiaries of the deed. 2 is the
one who
you are for 2. What is your condition?
Will kindly come to me of the application.
Yes. Mr. Ganguly, you can take your seat. I mean, let me hear them. Let us hear.
Before he takes my lord.
Yeah, computer. Very.
My lord, these are the two list of dates.
And may I file the supplementary evidence which was directed to be filed by Justice Mukherjee?
When you argue file it, we have given copies.
Yes, copy service.
Check up. That nod is not very convincing. Yes.
Now, my lord will kindly come to page 70.
No, I will come, but let them. Mr. Ganguly finish. Take your seat. Let him finish.
Between the 2003 decree and my lord the.
Yes.
Oh, it's coming now.
Now you are giving a copy.
I mean, it was real
done. This bench is not a regular bench.
May I then consider this and come back? I don't know what is here.
Consider and come back whenever you take up these matters.
It was actually released once, so at that point of time.
Is there any reason we can release? I mean,
no.
Pandya has some reason we
I hope not, my lord. It went to Justice Sen.
The impugn order was by Justice Sen sitting in single bench. So he has to release.
No, anyway,
consider this and come back.
Very well. Act order record. Learned counsel appearing for the respondent number 2. Learned counsel appearing for the respondent number 2 seeks to use a supplementary affidavit which I believe is granted, and the said affidavit is taken on record. Next para. In order to enable the other parties, who are only served with a copy of the same today, to prepare themselves on the said affidavit, the matter is adjourned till November 20, 2024, when the matter shall next be listed.
Lordship, I appear on behalf of the appellant, madam. May a copy of
I will not give him because he has
definitely give him.
No.
The learned advocate on record for the respondent number 2 is directed to circulate copies of the supplementary to all the parties to the present litigation.
And in the event I need to respond, my lord, I shall file with him. And
all the parties. You also have to serve yourself. You are included in all the parties. At 10:30 copy dorkar.
That I have handed over.
No.
Done.
Will not record that. So that they can raise a dispute. Why didn't you want to give a copy to them?
He is appeared for the first time. The fight is now between respondent number 1. Before that, we have never exchanged anything.
Bad attitude. Yes.
Second number two.
Two. Yes.
তাহলে এসে বললো আমি দিইনি।
Return of the Mohicans. বিড়লালো তো আমি যতদিন বেঁচে থাকবো ততদিন সংস্কৃত থাকবো। এইটা একটা বিড়লালো যা বিড়লালো Yes.
My lord, your lordship's division bench, my lord.
Till I am in this code, I mean, it's assured.
My lord, the impugned order, my lord, is, my lord, an ad interim order of 21st of June 2024. My lord, we filed an appeal, my lord, within 3 or 4 days of the impugned order, but it wasn't taken up. No,
1 month.
1 month.
After a month.
No.
July.
No. 25th June we filed, my lord. But my lord,
Yes.
could not, my lord, be taken up.
Ad interim injunction refused.
Yes. Now, my lord,
What happened to your voice, Susan?
I have to see, my lord, a specialist. It's something.
Oh,
July, stay petition 23rd July.
petition.
Stay petition 23rd July, that affirmation.
My lord, memo of appeal, my lord, was.
appeal was filed on 25th.
Now, my lord, I must indicate to your lordships,
Yes.
my lord, that, my lord, subsequent to this,
Hmm.
my lord, the main interlocutory application, my lord, an affidavit has been filed by the respondents. My lord, we have not filed a reply. And after the meeting, my lord, where, my lord, limited protection had been given to us, my lord, to raise our grievance before the scrutinizers.
Before the
Scrutinizers, my lord, of the annual general meeting
Hmm.
with regard to, my lord, voting rights.
Yes.
My lord, with regard to, my lord, voting rights exercisable by petitioner number 4. My lord, scrutinizers did not, my lord, entertain that. We have, my lord, made, my lord, another application which is, my lord, also appearing before the learned single judge today. My lord,
we should await the outcome of that,
my lord, kindly, my lord,
or we can dispose of the appeal by.
my lord, I would like, my lord, this to be, my lord, I won't press for an interim order. Your lordships, my lord, kindly, my lord, adjourn, my lord, the appeal, or, my lord, if
We
my
can
lord-
express a hope that the learned single judge will, formally.
My lord, I'll tell your lordships what might happen. My lord, there is one particular finding, my lord, prima facie, of course,
Yes.
my lord, which, my lord, can change, my lord, also, my lord, after filing of affidavits. But, my lord, it's an issue concerning the exercise of voting right
Hmm.
in respect of petitioner number 4. My lord, if your lordship just sees the cause title once,
Hmm.
my lord, the respondent number 3, my lord, is a joint venture company.
Mhm.
Respond number 2, my lord, is a joint venture company. My lord, it has a foreign, my lord, shareholder, which is respond number 3,
Hmm.
and an Indian group of shareholders, my lord, which are petitioners numbers 1 to 4.
Hmm.
My lord, petitioner number 1, 2, and 3 each hold, my lord, 10%,
Hmm.
and my lord, 20% is held by petitioner number 4.
Hmm.
So the Indian promoters, my lord, had 60%, foreigner had 40%.
Hmm.
Uh,
20,
sorry,
20.
sorry, my lord, 20. My lord,
20.
no, my lord, 10, 10, 10, and 20. So, my lord, that's 50-50. My lord, not 60-40. If it was 50-50, my lord, joint venture. Now, my lord, the shareholding of petitioner number 4, which is, my lord, 20%,
Petitioner number 4. Petitioner number. Yes.
petitioner number 4,
Hmm.
which was 20%, my lord, amongst, my lord, the 50% shareholding held by the Indian promoters.
Yes.
My lord, voting right, my lord, was exercised,
Yes.
my lord, by respond number 1, who, my lord, we say, my lord, by virtue of a resolution and, my lord, the my lord, rules and, my lord, the bylaws of, my lord, the society, my lord, 4 is a society, was not entitled to, my lord, exercise voting rights. And, my lord, by virtue of that, my lord, certain appointments have been made, my lord, in the board of directors. My lord, this is, in short, my lord, the issue. The learned judge, my lord, has held that there was nothing, my lord, barring the respondent number 1 from exercising those voting rights.
All right.
And, my lord, that is one of the grounds, my lord, on which, my lord, the interim injunction, my lord, was refused. My lord, nothing has been shown. My lord, that was. Now, my lord, our specific cases, my lord, before, my lord, the learned judge, there were, my lord, the rules and bylaws of the society, as also an order passed by this honorable court of, my lord, a coordinate bench, which, my lord, showed, my lord, that, my lord, is the resolution of the trustees which have primacy, and, my lord, a resolution of the managing committee on the basis of which, my lord, respond number 1 exercise voting rights.
Were all these annexed to the injunction
Yes,
application?
yes, yes. My lord, that is, my lord, the only.
Mr. Mukherjee, but if you exhaust your energies here, I mean, the matter is fixed before the learned single judge
My
tomorrow.
lord, that's what I'm saying, my lord. Kindly don't, my lord, dispose of the appeal, my lord, because I don't want any finality, my lord, coming into the issue, my lord.
Whatever is passed, whatever order is passed tomorrow, that will again, that will entail
My
another
lord,
appeal.
no, my lord, that will be at least after affidavits. My lord, it will be before your lordship, my lord. My lord, that's why I'm saying, my lord. Otherwise, my lord, it would amount to, my lord, that will be, my lord, you've gone up on appeal and this point you have not succeeded. My lord, I don't.
May I just say
Yes.
this, Milord, central issue is, Milord, petitioner number 4.
Huh.
I say, Milord, that I am authorized to appear for the petitioner number 4. And, Milord, Mr. Mukherjee's advocate on record is not authorized to appear because the person who has executed Wakalatnama is not entitled to execute. It's part of the same issue. Whether, Milord, respondent number 1 can, Milord, that group can authorize, etc.
By the same
So-
logic.
Yes, yes, yes. So, Milord, I would say, Milord, that this whole challenge should only be from the petition numbers 1 to 3 and not the petition number 4. But, Milord, that can also go back, Milord, before the learned.
Disjointed does not
That's
vitiate
actually in
the
another suit, but yes, Milord, that's a point which
disjointed. I mean,
remains
1
open.
to 1 to 3 have a cause of action. I mean, then we can
But,
take up the
Milord,
appeal.
the principal issue is whether the petitioner numbers voting rights were correctly, Milord, exercised. So,
My lord,
Milord,
that's a point taken there as well.
Here also, obviously, yes.
so that will also be decided by the learned judge, Milord, tomorrow.
Yes, Mr. Mukherjee, what's the use of keeping them at a pending? I mean, we don't understand that. I mean, suppose whatever order is passed, that will be a new order. I mean, something will be decided. So we'll keep that open. I mean,
My lord,
whatever
kindly
points you have
keep that
taken here,
open, my lord.
all points will be kept open to be taken.
In any event,
Kindly,
ad
my lord.
interim order-
Clarify that we are not going into the merits. One.
Very well.
Secondly, all
Milord,
points are
kindly
kept open. Yes.
Milord, in any event, ad interim order, Milord, is not binding at, Milord, the interim stage.
True.
So,
true.
Milord, that is not even necessary.
No, but since they have preferred an appeal, there's a
Yes.
difference between not preferring an appeal at all and preferring an appeal and that being dismissed.
It's
So we'll
not-
clarify that situation. I mean, that's at order. The matter is fixed tomorrow before the.
No, no, it's one of the matters, my lord, today it's appearing, my lord, in the cause list. Item 45, my lord, before the learned single.
When the matter is taken up for hearing, comma, it transpires that the main injunction application and connected applications, comma, against the refusal of an ad interim order in connection with which the present appeal has been preferred, comma, is fixed today for hearing before the learned single judge who passed the impugned order. Full stop, next para. Hence, comma, we are of the opinion that if at this juncture we enter into the merits of the present appeal, comma, the same might have a bearing on the adjudication before the learned trial judge, comma, more so considering that the present appeal has been preferred only against an ad interim order. Full stop, next para. In such view of the matter, comma, we are inclined to dispose of the appeal and keep it open for the parties to urge all points taken in the present appeal before the learned single judge in connection with the main injunction application and connected applications. For next para, accordingly, APOT 240 of 2024 and AGA1 of 2024 are disposed of without entering into the merits of the matter. Full stop. It is made clear that all issues urged in the present appeal shall be open to be argued by by all the parties before the learned single judge in connection with the main injunction application. No orders to cost.
Pleasure.
Appeal for report number 1, allegations not admitted in the state.
Since no affidavits have been invited, comma, nor has the appeal been formally admitted, comma, it is deemed that none of the allegations made in the memorandum of the appeal and or the connected application are admitted by any of the respondents.
Pleasure. Shortest matter.
Thank God. Yes. Yes.
You can shift from that side to this side.
Yes. And Mr. Banerjee is added now as a necessary party.
But also from an ad interim order. This order is passed on 7th
The
of
matter is
November.
fixed today in this matter.
Yes, this was the one which was
Before the
mentioned.
trial court, it is fixed today.
No, no, no. This was
Oh.
7th of November.
Bad luck for us. Yes. Yes.
Madam, this we filed the appeal on the very same day and moved the file stay petition on the same day.
Right.
The 3-4 days gap is because of the one bench releasing and assigning and usual
Better, yes.
Birla matter because as it happened. But here, Madam, this concerns the 5 core companies. Lordship may recall, Lordships know everything. There are 5 investment companies. There are 2 investment companies in which Mrs. Birla has majority shares, and through a cross holding, there are 5 companies which is virtually controlled by Mrs. Birla's estate. In fact, the APL's case is that 100% shares are held by the estate in these 5 companies.
Controlled by the shares directly or the controlling interest?
Two companies,
companies
majority shares, and amongst those companies cross-holding,
Yes.
5 companies whose shares are admittedly, if I may say so, that there is absolute majority control in the estate, because the estate controls 2 companies and those 2 companies have subsidiaries like that. So also 5 companies. Lordships, while and in fact the APLs have also treated those 5 companies in a separate category. And even my Lord's division bench judgment, Chief Justice and my Lord's judgment, Lordships have categorized them a bit differently. Lordship has specially categorized these 5 companies where the legal control was with Mrs. Birla will be treated differently, as in the APLs through their nominees will be functioning to look after the interest of the estate. It is like the owner. This is not a charitable company. This is a business. This is a business concern. They do it for the maximization of profit. The owner was Mrs. Birla. If I succeed in the probate, I mean, these 3 plaintiffs will step into the shoes of Mrs. Birla and have absolute control, DHO's society, DHO's influence in these 5 companies. Now, what has happened, cutting the matter short, I'll come straight away. These companies have no business. They have only investment. I have annexed their balance sheets, have no running business.
All the 7 companies.
All the 5 companies.
Those 5, yes.
These 5, that is defendant numbers 8 to 12 here, have no running business. I have annexed the balance sheet. They have only interest and dividend income. So these companies never had a office, elaborate office space separately. These 5 companies always had their space on a very nominal rent on the 4th floor of Birla building. 3rd and 4th floor of Birla building in R.N. Mukherjee Road, that side, it is owned by Birla Corporation Limited. And these 5 companies are 14% shareholder altogether. And also they are shown as part of the promoters group in Birla Corporation Limited. In fact, the APL stand was, 2 of the APL stand was, Birla Corporation is also part of the estate, which illusion has been undone by
The corporation is the owner of that building.
2 floors, 3rd and 4th.
The relevant floors.
Yes. And the other floors are by my other side, the Birlas. Now, this is how it was always, a very nominal rent, some 60,000 rupees per annum or so is the rent which was there. And this was the position with Mrs. Birla's time. Before that, during the time of Justice C.K. Thakkar as 3rd member, Justice Ravindran, Justice A.P. Shah, all throughout. But this was never, even before the present APL committee, this was never an issue. My Lord, what happened is, my Lord, division bench judgment was delivered, dissociating that you don't have any influence and you can't control through influence. And then came Justice Shampa Sharka's judgment in May 2024, from which Lordship was hearing the other appeal, where those decisions taken by the APL committee on 4th of March 2021 on the basis of influence to take control of the societies, all the societies, was negated, saying that those have become inoperative by virtue of the division bench judgment. That my lords are hearing. So come after that, my lord, the triggering event happened. Suddenly we find in the month of October, on 25th of October to be precise, 25th of October, 23rd of October, 25th of October, we get a mail from the third APL, who is our nominee, Mr. Sharma. Addressed to all concerned, including, and sorry, it is addressed to Justice Shah, the third APL member, and to all others, both sides, that on 23rd of October, a resolution was passed at a board meeting on 1 day's notice, board meetings of these 5 companies, to take on lease 1800 odd square feet on the 7th floor, owned by Birla Buildings, at a rental of something like 69 lakhs per annum, plus renovation costs at some 75 lakhs, plus a 3-year lock-in period in their lease once they sign, etc., some deposit, etc. And Mr. Sharma's letter says the reason given was, we don't feel comfortable like in this Birla Corporation's flow. I'm putting it as legally, as forensically as possible. Now, so Mr. Sharma informed. So immediately on the 30th, we moved the vacation bench.
7th floor is owned by who?
Birla Buildings Limited, my Birla Building, that is the
Birla Buildings Limited is a separate company.
separate company. We have made them all parties. So separate, we have made Birla Buildings parties, Birla Corporation also parties by abundant caution. Now, separate company, but no agreement has been signed as yet, thankfully. So we came on 30th of October immediately and we moved the vacation bench. No caveat, but they intervened. Matter was heard.
The suit, what is the relief sought in
The
this?
suit is challenging the decision to shift this to take this space on lease on really 2 premises. Well, the assets, monies of these 5 companies are really assets, monies of the estate, because these 5 companies.
Mr. Mitru, isn't the suit a bit premature? Because we are telling why. Because this is a resolution by a board. You can challenge the resolution before the appropriate forum.
Well, I cannot change that. That's the whole problem. That's the other. That's the issue which I have addressed, because I'm not a shareholder. Admittedly, the estate holds the shares.
If an agreement is executed, maybe you have a cause of action.
Yes, but once the agreement is executed, there'll be a 3-year lock-in period. That is why, my lord, I am saying, otherwise you'll have to commit. I'll have to ask the commit to renege an agreement with a third party. So I want to stop the execution of the agreement. Well, I'm basing my case like this.
Birla Buildings is not a party to this suit.
This suit I made them party.
They are.
This suit I made them.
They are one of the 5 companies.
No. Birla
That-
Buildings is the
It's one of those outer.
no.
The
Not
lower
our group.
tier companies.
Not our group at all. This is the Birlas.
All right.
My opposing
Birlas as in Birlas.
Birlas as in Birla, not MP Birla group.
All right.
Birlas. This is my defendants group. So, twofold I came. I said these companies, if today one of the appeals or 2 of the appeals on the board decide to donate the money of these companies, the companies are holding huge funds because this is dividend earning company. They don't have any
So
expenditure.
these 5 companies, what is the nature of control of these 5 companies in Birla Building?
Nothing. Because we are, this is BK Birla Group. Kumar Mangalam Birla
What was the premise of what is the sanction they have against Birla Building? And is Birla Building Limited bound by this resolution?
No, Birla Building is not. But my 5 companies will now act on these resolutions. There is a proposed agreement between Birla Buildings Limited, which was apparently placed before the board meeting, and which I have also disclosed. Proposed agreement. Our 5 companies, which really is under the control of my lords, because the majority shares are in Medio with my lord's officers, and which gives legal control. These 5 companies want to enter into an agreement with the opponents in the probate proceeding. That's one aspect. And take the records shift the records to the 7th floor, which belongs to Birla Buildings Limited, with which MP Birla Group, not 3rd tier, 4th tier, nowhere near. That is admittedly admitted position. Outside the MP Birla Group, that is. And my lord, the best part is, this would entail an immediate, the moment the pen is put to paper, these 5 companies sign the agreement with Birla Buildings Limited, they'll be committed to 3 years lock-in period. And I really don't have a cause of action against Birla Buildings Limited.
What
Because-
is the apprehension? The papers will be physically moved there or what?
And 2 crores of
Agreement
rupees,
is entered
well,
into.
well, it's 70 lakhs of rupees annually will have to be paid for this 1800 square feet. And well, now I'm coming to the 1800 square feet, which is the estate's money. I am saying this way because these companies, more than majority shares are held by the estate. And if these companies' funds are dissipated,
How will an agreement, I mean, entering into an agreement, payment of rupees 70 lakh, do you say that it's not commensurate with the actual rate payable there?
that I'm coming. Well,
Otherwise, you have to have something independent. Otherwise, just
it
that
is
they belong
not
to enemy
commensurate-
camp,
Yes.
so-called. I mean, the companies cannot have any enemy camp as such. Yes, you say yes, because of your control.
I will show two, 3 paragraphs
Enemy
from
camp is more sentimental than legal.
no legal because they are
What
defendants
will
of
happen?
the
Then
TS
the jural relationship will be created. Even then,
created and
that
the
will be
liability
governed by the law.
governed by the law. So governed by the law. So the estate will have to really fork out 70 lakhs of rupees a year.
They would have to do that if the landlord was someone else also.
No, that's the next question. That's the next point. When this matter was heard, since we make Birla Corporation also a party, and Birla Corporation, the issue came up before the learned judge that is it a commercially viable rent? So Birla Corporation was asked, since they have got the 3rd and 4th floor on the whether they can offer a lower rent because they got 3rd and 4th floor. Mr. Bachawat said, I need to take instructions for 1 day. The matter was made 4 orders and kept 3 or 4 days later. Mr. Bachawat mentions with a supplementary affidavit forwarded to all the parties before the order is passed, I think on the 6th of November, saying that Birla Corporation Limited is willing to give the similar space of around 1800 square feet on the 3rd floor at almost half the rent. The figures are given in the supplementary affidavit, which I will show had been forwarded to all the parties, including my client, and mentioned by Mr. Bachawat upon notice of mentioning. So Birla Corporation Limited offered, if at all there is a requirement of additional space. Suddenly, why there is a requirement of additional space? It's a question mark. If at all there is a requirement of additional space, when in the same building, there is offered a space of similar at a half or
3rd and
almost
4th, you are already occupying more space. There is more space on the 3rd floor.
Yes, because Birla Corporation Limited registered office is there.
More
Yes.
space equivalent to that on
Yes,
the 2nd.
that is the supplementary affidavit of
So-
Birla Corporation Limited, which
Yes.
Mr. Pachawat had mentioned to court. The court said, since I have, after hearing this, since I will not go into that anymore.
Do you have any issue? I mean, do you have any ground that that resolution was otherwise invalid? Because
Resolution
did
was,
they not have the power to take that resolution?
no, but legal power
You are
on
not-
that because
just
I am
the
not a
chap-
director.
Yes.
So I'm not a shareholder, so I know, so I don't know.
Shareholder.
No,
Oh, what are you? Controlling share? Controlling?
well, I am the sole. I'm the universal legatee of Mrs. Birla's estate. Universal legatee of Mrs. Birla's estate. These shares,
Very remote connection.
well, these shares are in medio with the estate, with my lord's offices, lordship. I will just take your lordship to the division bench judgment and what
That
because
it would be more appropriate to approach the probate court probably for that. I mean, if
that's
it's
the
prejudicial to
issue
the
came up.
probate issue.
That is well, we are open to.
Civil court, we don't. The civil court does not have any
Well,
authority.
we are open
How
to.
can we enter
Well,
into
I have no difficulty because this is one
the
courtroom. Or
internal decision of a company?
But the only difficulty with the probate court is the division benches is that the division bench's judgment on where saying that these the lordship kindly comes to yes kindly comes to well we did not annex the trial court record, so we had gravely this is the entire trial court records. Lordship kindly comes to 2 paragraphs from the page coordinator.
Volume 4 of that.
Division bench judgment starts at page 394. It is relevant portion is 394 of the mention again. Paragraph
Number you can say.
108,
Yes, in our copy it's 394.
394. Yeah.
So I
You
put
kindly-
it here. I tried to put it here. It went down and it was on the YouTube. Then I put it here. It went down. Just lack of accuracy, and it went on the YouTube. I had to answer to my friends who are not part of the judicial system and who are already. I mean, we are already a matter of an object of ridicule to other people. Stop. No. They'll get bored, tired, like Parliament. Now, we are waiting when you will start throwing things. I mean, that will create a. It will be more interesting, exciting than this. Than the Tillaluda matter. At least. We don't know what we are coming. We are all against YouTube.
Appearing to work.
So many people are against YouTube. also.
I don't think Muller is. Can't be Muller a source of entertainment. Muller for anything.
That's the core, that's the issue, Lordship. Paragraph 108.
10.
108, page number now. 394 is what?
394. Yes.
394. Lordship kindly comes. So we have no preference between two courts.
ওটার জন্যই তো
108.
yes.
The learned senior advocate appearing for respondents had relied upon several decisions of the Honorable Supreme Court as well as the other high courts to support their contention that the injunction can be granted by the Court. On going through the facts of each of these cases, we find that in all these cases, orders of injunction were granted pending appointment of APL, which in the light of the judgment of the division bench of this court in Otula Baladash. Thus, having taken note of the above legal position, the next issue to be considered under this head is whether the probate court can pass orders against third parties. We need not labor much on this issue as the learned judge, as the learned judge has rightly noted the proposition of law in this regard and held that the companies not being the parties, they are not amenable to the jurisdiction of the probate court. While considering whether the companies can be joined as a party defendant, the court held that the noticee companies can neither be joined, nor can any order of restraint be passed against such companies who is not a party to the proceedings. Further, the court held that it cannot extend its jurisdiction to a person who is not a party to the present proceeding. Further, the probate court cannot extend the jurisdiction over a person or entity who is not a party to the proceedings. Further, it was held that the noticee company be not the party to the proceedings, no order can be passed against it. This, coupled with Lordship kindly sees, the civil court jurisdiction will be ousted if only I can go to the company court under section 241. Here, it is an admitted position by the defendant numbers 5, 6, 7 that 100% shares are held by the estate. That is by the court. I'm just pushing my case very high. The court is the owner because this is in medio. Now, Lordship, similar directions.
100% shared in which company?
In these 5 companies. I will just now show it. This is the finding of the APL committee, and also Lordship kindly comes 573. 573.
But the appeal committee could have approached the court. Appeal committee is not.
That's my point. But that's my next point, because that is my next point. Lordship kindly comes in this judgment straight away to. That's my point. APL committee should have, and in fact, there are 2 findings in my lord's judgment, twice over. The third member is to act really as an arbiter, as an umpire, if the 2 APLs are not ad idem. Mr. MK,
the third the arbitrator who is dissenting, that arbitrator, that person,
APL.
APL, that person has communicated this to you, but the communication regarding a resolution which has actually been taken. So the communication by one of the APL members does not.
No, it is addressed to Justice Shah saying that I am objecting to this.
Yes, but the resolution is taken. You are challenging the
Resolution is taken.
resolution, basically.
Resolution is taken. Resolution is taken by the board, who are all nominees of these two APLs, because the entire board was changed. Mr. Lodha and all were removed or not re-elected, and the entire board was changed. And these 5 companies had new set of directors who are nominees, which your lordships also
And the APL has the power. The APL has the power to do so, Mr. Mukherjee.
That's the whole point, lordship. Lordships have said APL has the power, but if an officer of the court is the party finds that the officer of court is not acting in the interest of the list or the subject matter of the list, he has to come to the court only. Now, which is testamentary court or civil court, that is, I don't want to be caught in that quagmire. And especially in this case, when your lordship's decision is that he'll act as an umpire, and in case he finds there's a difference, and according to him it's a major decision, he should refer the matter to the testamentary court. Twice over, lordships. But here, what the learned judge has held, that since the third member, that situation didn't arise, because third member, as on the board, he also joined the other member, I mean, Mr. Chakraborty, and said, I also supported the additional space. There also, lordship, your division bench judgment is that the third member especially is not supposed to be involved with the internal affairs. He's supposed to be more as an arbiter. Lordship, may I just show 2 paragraphs from my lord's judgment?
Since there's a difference, then he has.
No, there was a difference at the board meeting, because Mr. Sharma's letter records that at the board meeting he objected, and this was.
Third member may lend his weight to one of the decisions, one of the other APL member decisions.
As an arbiter, as an umpire.
Whatever, I mean, as an arbiter, obviously, but he has lent his given his force behind the decision of one of the.
So
can do that. Otherwise, there will be a standstill.
So if he can do that, and if he feels that this should not be referred to the
this is a decision taken by the APL, which they have authority to do. Otherwise, man, you are a legatee. I mean,
I am a legatee, so I am the plaintiff in the suit.
Yes,
I am saying
Locus standi to challenge that.
But what I am saying, if
how will the estate be, I mean, affected?
Because
only apart from the monetary consideration, that Birla Corporation itself is offering
at half the price.
That is
so
one
that I will show. And secondly, my lord, also, my lordship, look at it another way. The estate is the promoter. The estate is through these 5 companies, hold 14% shares in Birla Corporation Limited. That's the legal right. And they are described as promoter group. When the promoter, they'll
have more control on the landlord.
Well,
they'll have more control on the landlord.
They'll be acting in the interest of each other. Should be acting in the interest of each other. See, my promoter companies should be acting in the interest of each other. That's what I'm saying. So when so taking it and endeavor to take it out of the fold of the promoter of the flagship company or the MP Birla group, unless something is drastic has happened, some complaint, something, just by feeling that I'm not happy. That's my second point. My first point is, of course, the estate. So estate will be denuded of 70 lakhs of rupees every month. So, what Lordship kindly sees.
What is the current rent you are paying for that?
Well,
what is the current rent being paid for this third and
70,000 per annum. Now, Lordship kindly sees one more paragraph from this judgment. Lordship kindly comes to paragraph.
And that is 70 lakh per
annum, 100 times,
100
plus 75 lakhs renovation cost, plus 11 lakhs deposit. So So once it is signed, that's why we got an interim order on the first day for in the interest of justice, which was not continued on the 7th of November. On the ground that 2 grounds really, this is company and the company's internal affairs. And secondly, there's no other better rent. That's where my lord was. No other better rent that I can't.
Second ground, obviously, I mean,
I can show here. Or she kindly sees the role of the 3 APLs vis-a-vis this these tier 1 companies. Now she kindly see paragraph 199. Running page bolo. 451. They are to pay, after all, they are representing the estate. So they should be acting in the interest of this. And that's what exactly what your lordships have said. It is not a corporate democracy, really. How far it applies, lordship, this will.
Yes.
But it kindly comes to paragraph 199
Right.
of the judgment. In any event, the APL is not an adjudicating authority and cannot act so. There does not arise any question of the testamentary court delegating its power to it.
They're not adjudicating, they're taking
No.
a decision.
Next sentence. The APL shall strictly act in accordance with the observations above, limited to its role as shareholder with ancillary functions, including voting rights, which are to be used judicially to protect and preserve the interest of the estate during the pendency of letters.
Obviously, yes.
It is the estate. So, not that is their role. Paragraph 213, Lord, you kindly see after a few more pages, paragraph 213. Page 415 at 45, at 458, last two lines. Paragraph 213, 4 the nominees as such shareholders may participate in shareholders meeting and decision making process of the tier 1 companies and thus mold the course of action. Nominees, like may I please on the fourth line of paragraph 213. The APL through its nominees may very well decide which way the votes of the testatrix's shares should go and how they would exercise their voting rights. The nominees as such shareholders may participate in shareholders meeting and decision-making processes of the tier 1 companies and thus mold the course of action and business decisions of such companies. Since the said tier 1 companies are also shareholders of other companies in the secondary and tertiary tiers, the APL, through its nominees, may also decide how to go about asserting the interests of the estate of PDB in the secondary. So, interest of the estate of the PDB, that aspect has not been considered by the learned judge. Because here, this is not a case of a pure company's internal affairs being managed, internal affairs separated, divorced from the shareholders.
The board resolution of these companies was preceded by any decision, formal decision of the APL.
That's another point. Lordship kindly comes to the letter from Mr. M.K. Sharma, which is the genesis of the litigation, page 961. Sanket. 961, that is volume 7. Page. Oh, it's a compilation, so. 961.
Yes.
This is a letter on 25th of October from M.K. Sharma addressed to Justice Mohit Shah and to all others. Objections to leasing of additional space. I refer to the board meetings of Gwalior Webbing and East India Company and East India held on 23rd of October, where your good self and Mr. A.C. Chakraborty were also present as directors. An agenda was circulated approximately 24 hours ahead of the meeting about a significant proposal to lease additional space of 1852 square feet situated at the east wing 7th floor Bilda building, an exorbitant rent of 493 per month. For 1852 square feet will automatically increase 15% per annum at the expiry of 3 years. There is also a proposal to pay substantial deposit of 11 lakhs. To my specific query whether the companies will vacate the premises made available by Birla Corporation, it was clarified by Mr. A.C. Chakraborty that it is intended to retain the space of Birla Corporation and the new lease will be over and above space currently available. There has not been any material change in the size and scale of operation, which I will show from the balance sheets also, or number of staff members which may warrant leasing additional space. It appears to me to be a clever attempt on the part of the majority of the board members, including 2 of the other APLs who are aligned to Birla's opposite parties, to put them with funds for ulterior motives to enable them to pursue diverse litigation. I also stated at the board meeting that there were no competitive codes or benchmark used to determine the fairness of rent and revisions, even if there was a justification for it. I have therefore, for aforesaid reasons, dissented from the proposed resolution. In my respectful submission, shifting of the office, registered office of the company to the place belonging to the rival Birla Group is a clear attempt to hijack the investment companies and take the said companies out of the fold of MP Birla Group. There is no cogent reason given by the board, notably to two joint APLs, for shifting the registered office of the investment companies which have been operating from the fourth floor of the Birla building for the last several decades, spanning the lifetime of MP Birla and Mrs. Birla at a very nominal rent permissive usage basis. This also goes against the customary norms of functioning and operation of said investment companies, which are and are per se despotic. This is the only reason for the purported relocation of the registered office has been that our employees are feeling threatened. It is expressly false, concocted and misleading. There has been no complaint of any threat of any kind in the past which has ever come or been brought to the notice of the joint APLs. Even the office of the joint APLs is functioning from the fourth floor of the Birla building. Mr. P.S. Nair, the manager to the estate, and the secretary to the committee of joint APLs, also an employee on the payroll of one of the investment companies, have been attending his duty and sitting in the same floor, have never complained of any kind of threat or pressure. Taking on rent the office space at an exorbitant rate and spending money of 70 lakhs plus for renovation of the space at the cost of the investment company is a wasteful expenditure and will definitely amount to depletion and dissipation of the assets of the Birla, considering the fact that the two joint APLs are claiming that the investment company is to be part of the estate. The two joint APLs have already squandered that. I'm making a separate application for that. How much is on litigation they are spending, because the APLs are themselves appearing.
And you also have to satisfy us, Mr. Mitra, that there is no remedy in the company.
That I will, of course. That I have
that also.
So
this is basically against the interest of that of the five companies.
Of the five companies. Of the five companies. And Lordship sees the second last paragraph, before exercising the right. Before exercising, this is my lord's query. Before exercising the right as directors of the investment companies, which the two joint APs are coming part of the estate, the shifting of the register of the investment company should have been discussed and deliberated in the meeting of the joint APL. Surprisingly, without prior discussion and no intimation in the meeting of the joint APLs, that the said decision has been taken at the behest of the other two APLs. Well, here, in the board minutes which were produced at the hearing afterwards, this feeling threatened was not there. This was simplicity said that we need additional space.
So there are two components in this action, in the alleged action. One is the functioning of the APL itself, because two of the members have participated without taking a formal resolution. If it is a functioning of the APL itself, maybe you can go to the probate court on that count.
Maybe,
but there is another component where a resolution has been taken by the company in the board meeting.
So the companies come in. It is matter of same court.
So probate court simpliciter may not have jurisdiction in that sense. I mean, because
that's why, Balot, we came by abundant caution, because we could have made at the GA in the TS.
One of the grounds of the impugned order, you say, we'll go through the impugned order, but one of the grounds is that civil court does not have jurisdiction. Therefore, you have to satisfy us that the company court has jurisdiction or not.
Not said in so many words, because I showed one judgment, but then it says that you should have gone to the testamentary court. Something of that. So, Lordship kindly comes to the judgment straight away. The
judgment, and then
yes, Lordship. Then I'll come.
Then we'll go on to the company's.
Yes. Lordship kindly come to the judgment.
Next to the supplementary affidavit.
Is annexed to the supplementary affidavit, because when we filed the appeal, it was without the judgment. We took leave and filed. Yes, it is annexed to supplementary affidavit.
Page 7.
Lordship kindly comes. It starts from page 7. From paragraph 21, the order really starts after hearing the counsel.
Yes.
Paragraph 21.
It is page 15 of the supplementary.
Heard learned counsel for the respective parties, peruse the material available on record. The plaintiffs have prayed for an injunction restraining the defendants from giving any effect or further effect or acting in terms of the decision to obtain leasehold rights in favor of defendant numbers 8 to 12 with respect to the 7th floor of the Birla building. The plaintiffs are claiming themselves as universal legatees under the last will and testament of Premara Birla. A testamentary suit being TS number 6 is pending before the testamentary court for the grant of let's say administration of the last will and testament. In the said suit, appeals have been appointed. The defendant numbers 8 to 12 have taken a decision in the board meeting to take the 7th floor of the building on lease for the purpose of their offices. The main contention of the plaintiffs is that the defendant numbers 8 to 12 are already having their offices at 4th floor of the said building. Without any requirement, the defendant companies are taking the additional space at an exorbitant monthly rental of rupees so and so, an increase of so and so. The division bench of this court by an order of 14th December 2023 held that the very composition of the APL brews conflict of interests, since two of the members represent the two warring factions and have left no stone unturned to show their true colors in that regard. Thus, in view of the discussion above, the only way in which the APL can function effectively is for the third member, who is necessarily a retired nominated judge, to act as arbiter in case of conflict of decision between the two members of the APL. In case there is no resolution, the third member shall exercise veto power. In case of major decisions, which decisions are major for this purpose shall be decided by the third member. The APL may seek appropriate orders of the testamentary court. The APL must also keep in mind that it is not an adjudicating authority, but merely the representative of the estate of the deceased testatrix. Thus, the order of the learned signature is modified. Some have extended liberties to approach testamentary court, taking up if need be. Now, Lordship, paragraph 24. The defendant companies have taken a decision for additional space of it. The defendant numbers 5, 6, and 7 being the joint APLs have attended the meeting in capacity as directors, not. The defendant numbers 5 and 6 have agreed for the proposal, not an APL meeting, for the proposal, but the defendant number 7 has raised objection. But in the board meeting, with the majority, has approved the proposal of additional space. In view of the above, the contention raised by the plaintiffs that the decision of the additional space is a major decision and the joint APLs have to seek appropriate orders from the testamentary court does not stand. The companies have taken a decision for additional space as per their requirement. Neither the plaintiffs nor the defendant number 14 can raise any objection for additional space. In the minutes of the meeting, that's and so 31st of August, it is categorically mentioned that the rate being charged is in lines with the rental for commercial office in central business. Mr. Sharma says you'd have not compared with anybody. And the rents will be shared by the 5 companies as per ratio mentioned in the minutes dated 31st of August 2024. The shares held by the estate of Premada Birla are already available in the affidavit of assets of the testamentary suit. The plaintiffs cannot restrain the companies for their day-to-day business. Who's stopping? The plaintiff claimed that they are the universal legatees, and if the plaintiffs find any misappropriation of funds or alienation of the estate of the deceased, the plaintiff can bring the same to notice of the testamentary court, but the plaintiff cannot ask for an injunction against the company for their day-to-day affairs. As regards the contention, but this is not day-to-day affairs. This is not a running business company with any running business. As regards the contention of the defendant number 7, that the defendant company in the board meeting stated that the staff members of the investment companies, trust societies having their offices at the said space are being subjected to various types of intimidation and threats on daily basis. On daily basis, thus the defendant companies have approved the proposal for additional space, but the contention of defendant 7 is not correct. As per the said minutes of the meetings of the companies, the above matter was discussed, but that is not the reason for acquiring additional space at 7th floor. In the said minutes, it is categorically mentioned that it was also decided that, keeping in mind the growing need for additional office space, the management may also identify and finalize other additional suitable space for the office need of the company on rental basis. Thus, it cannot be said that the defendant companies are acquiring additional space only due to intimidation. Now, Lordship, I will come straight away. Before I come to the legal aspect, just 2 paragraphs, my lord, from the supplementary affidavit and the mentioning notice which was given by Birla Corporation. Lordship kindly comes to the stay petition. Kindly come. And the rent is paid up to 20, because they are leaving, they are not disputing. Lordship kindly comes to page 41 of the stay petition. Page 41. This is a mentioning notice given on 6th of, I think, 6th of, yes, November by Sinha Company. We are appearing on behalf of Birla Corporation, defendant number 14 in the above matter. Counsel appearing on behalf of our client will mention the above matter today. Matter today, 6th November, before the Honorable Justice, 6th November, at the first sitting of the court at 10:30 a.m. or so soon thereafter as the business of the Honorable Court permits, and shall pray for necessary direction kindly. And this is after the hearing was over, was over on the 4th of 5th, and this was mentioned thereafter upon notice to them. Or she kindly comes to to page 47 is the supplementary affidavit, paragraph 5 at page 48. At the hearing of the injunction application before His Lordship on 4th of November, an issue had been raised, especially by the counsel appearing by defendant number 9, that no tenanted portion was available at a rate lower than what is stated in the proposed lease agreement between 8 to 12 on the one hand and 30 on the other. On this issue being raised, a query was made to the senior counsel appearing by defendant 14 as to whether this one 14 was willing to let out similar space in Birla building at a lower rate. Senior counsel could not immediately respond to the query regarding available similar space, and that is why I prayed for time to take instruction. From the document disclosed in GA filed, it appears that the rent at the rate of 65 per square feet and extra facility charge 65 per square feet, that is 130, is proposed to be paid by defendant number 13 for super built up area 2833 square feet, carpet area so and so 7th floor. I say that the defendant number 14 is available space on the west wing of 3rd floor of Birla building, which can be leased, let out to any of the defendant 8 to 12, a gross rent of 80 per square, 130 versus 80, as per details given here in below. And also on deposit paragraph 8. This was brought to the notice of the court by Mr. Bachawa to mention on the 6th, because he could not respond immediately at the hearing. Could I actually 100% shareholding? Could I 100% shareholding? Now, Lordship, the 100% shares are held by the estate. That Lordship will be finding in the APL's minutes only. In these 5 companies, I think that is page 573. I think there were 5. Can you give me 1 minute, madam? Wait. Brief take. No, volume 4 today, page 573. I think it is. This is. It starts at page 536. The list of shareholders are given here. 536, it is the minutes of the decision of the APL committee. Minutes of the meeting of the APL committee, and the decision starts at, I think, page 548. Decision of the APL committee on issues arising out of. Kindly come to page 573. These are the 5 companies which we are concerned with. East India, Gwalior, Baroda, Punjab. Lordship, first one, East India Estate holds 72%, Gwalior 8.97%, Baroda 5.61%, 99.97%. Nothing is held by me. Gwalior Webbing 100, but estate itself, and then so on and so forth. So admitted
Shareholdings in Birla Corporation.
No, in the defendant numbers 8 to 12. Those 5 companies who are taking on lease the additional space.
Yes.
So, but
So estate has 100% share.
and I'm not a shareholder. I'm not a shareholder.
No, you are not a shareholder.
So, but can I come under the Companies Act for the internal affairs of companies? Here, I would say this is not a case where you can differentiate the internal affairs of the companies from the estate.
Yes.
But you kindly see section 430 and how it's been interpreted. 430 is 241.
430 is civil court's lack of
241.
jurisdiction. 241, yes.
So 241, this would be an affairs of the company. Justice.
Got both. Yes.
241, I admit, this could have been an affairs of the company. Any member of the company who complains the affairs of the company are being conducted or in the manner oppressive to him. So this is a member's action. Any member of a company who complains that the affairs of the company have been or are being conducted in a manner prejudicial to public interest, or in a manner prejudicial or oppressive to him or any other member. Here, by right, is an interest under section 104 of the company, of the succession act. 104, not a legal right as yet. 104 gives a 104 the essay of the succession act now. 104 does not give me a complete right
Succession Act.
of the succession act, because hereby I am not a member,
Succession Act দাও।
but
তলাটা একদম তলা। ওই আপনার হ্যাঁ।
104. Just Kumar has got, yes. Section 104. If a legacy is given in general terms without specifying the time when it is to be paid, the legatee has a vested interest in it from the date of the death of the testator. And if he dies, so I have an interest where once the assent to legacy is given, then it becomes interest. Now kindly comes to 244. 244. The following members of a company shall have the right to apply under section 241. 244 of the Companies Act. Yes, Kumar has got it. Yes. 244 of the Companies Act. Right to apply. The following members shall have the right to apply under section 241, 10% or 1/10. Now, we are coming under the proviso. Provided that the tribunal may, on an application made to it in this behalf, waive all or any of the requirements of clauses A and B so as to enable the members to apply under 241.
That still is confined to the members.
That has been interpreted by the appellate tribunal. Justice Bhushan's judgment is there that a
But-
non-member can't come and say that you can waive. This is
Yes,
very
it's
clear.
rather clear. Yes.
Clear. So, as a non-member, I
Relates
cannot.
back to the member.
So, if the probate was granted, my remedy would be the.
So, Mitra, if the probate court says, the appellate court, the division bench, Chief Justice division bench says that the probate court cannot interfere into third-party companies' matters, then can beneficiaries, universal beneficiaries, they claim, because they are claiming through the will ultimately.
Now,
If the probate court itself cannot, or the letters of administration court cannot, if that is the finding of the division bench, then whether the beneficiaries who are claiming ultimately through the will, they can jump the queue and they can have a local
then
stand.
of course, but then Lordship, I am making a distinction by paragraph 199 and 213. These 5 first-tier companies, these are being, Lordship, paragraph 213, they are saying that the nominees of the APLs are on the board. And the APLs through its nominees must act in the interest of the estate.
Difficulty there, Mr. Mitra, we are being very candid, because it's the learned single judge also says it's a majority decision of the shareholder, of the board of those companies. One. Secondly, now if you say that the Companies Act by specific exclusion chooses to exclude third parties apart from members from raising these disputes. So if the Companies Act, if the governing statute itself excludes you, non-members, then whether we as a civil court can exercise a right under section 9 of the Code of Civil Procedure or under section 34 of the Specific Relief Act and carve out such a right into the Companies Act, because the Companies Act chooses, the legislature chooses not to give you that right. Because it's the internal affairs of the company, ultimately it may collaterally, you may be a collateral damage, they state. It may be affected, yes, but it's collateral at the end of the day.
I am trying to
The company is deciding its own affairs by its majority decision.
majority board decision.
Majority board decision. So if that be so, how can the civil code carve a right into the Companies Act, which is not there in the statute?
We'll consider it only from this aspect, my lord. Here the civil code, maybe in testamentary division, but then it is that the civil code.
This is a clearly a civil code. I mean, you have approached a civil code.
So civil code.
Suit.
Yes, suit code. Having testamentary also after it becomes a contested cause becomes a.
You have not gone there. That's the point.
No, well, so, my lord, it is if the civil code in its testamentary division is having the majority shares of the company, and I come and tell the civil court, your majority shares are being jeopardized through your officers not taking appropriate action.
Then
Whether-
which should be the court you should approach?
My lord,
Then which should be the court you should approach?
that is, my lord,
Yeah, you give your answer yourself.
but then there is
You're
that
right.
finding.
You're right.
There is that finding.
It's not the civil court's right, Mr. Mitro. It's the rights of the estate. Civil court is a parens patriae sort of, is the guardian of those rights.
Of those
So-
rights.
So you then have to approach the guardian, despite the observation in the division bench judgment that no, the APL cannot interfere into third party rights, nor can the probate court or pass directions against the third parties. True, but if it affects the interest of the estate, from that perspective, you could have approached. But then also the finding of the learned trial judge, we are rather ad idem with it to the extent that it's not a question of a decision of the APL only. It's a majority decision of the board of the companies. It's an internal affair of the company.
But then here the majority's decision of the by majority directors have been described rightly as nominees of APL because I've given the particulars.
Yes.
Because all the erstwhile directors, it was full scale change after justice in 2019 or 2020. So it is the nominees of the APL. So kindly do not. My prayer will be: do not treat this as an internal affairs of the company. It's a director acting independently.
If you don't do that, then it's a matter for the probate court to decide.
But if it's
The testamentary court.
well,
to
as
decide.
I am
Probate.
not, well, as I am saying, I have no preference for.
You
either
have two
court.
components in your challenge, Mr. Mitra. One is the action of the company itself, as board of directors, as the majority has taken a decision. So it's a company affair, which is covered by 241, 244, and exclusively confines it to members. If you don't fall under that, then it's a cause of action arising out of the testamentary sector. So you have to go to the testamentary court. Then.
If I go to the testamentary court with the
Actually, you are neither here nor there.
that's the whole difficulty. If the division bench clarifies that, I can't be remediless.
What is the right which has been infringed that the civil court will interfere? Please crystallize that. What is the right which has been infringed?
My right
Under
is-
which act?
Well, the right is my right so far as the inheritance of these shares are concerned. Let's take it as an example, extreme case. If these companies had 200 crores of liquid funds and the board, who are under the control of the APLs, decide to donate the 200 crores to Ramakrishna Mission, can an universal legatee like we come and say that these companies' actions, again, I'm conceding there's an overlapping here. These companies' actions being controlled by the APLs is against the interest of the estate. Because shareholding will remain 100%. But the shareholding represents the
Aren't you
200
broadly
crores.
covered by a class action or any sort of representative capacity, anything?
Class action.
Has the company jurisprudence formulated anything in that regard?
245 is the class action provision, Lordship. That is also. But there is a that has not been certain.
And you are affected means that the estate is affected.
5%, I think.
Notify,
5%. But I am as a
No, you are not aggrieved. This is not a class action.
not a class action. Because here there are only 5 shareholders. Because all the shareholders are virtually parties here. Majority shares.
You are nobody to the company.
Yeah.
That's the difficulty, Mr. Mitra. You
I
are
am nobody.
collaterally not even quoted in a tertiary manner. You are affected.
I am nobody to the companies as of now, but I have a I have an interest in the shares, in the majority shares of the company. I have
At
an
best, you
interest.
can go to the testamentary court then.
But-
At best. Because you're right, you're claiming your entire cause of action for this suit is through the testamentary court.
through the bequest.
Through the will, rather.
The
through
will.
through the will, yes.
Through
bequest.
through the will.
Through the bequest.
Through the will, but I need reliefs against against the legally separate entities, but not factual, legally separate entities from the estate. Because estate represents this block of shares, but legally separate because of the company law jurisprudence is this company.
If the probate court cannot, the testamentary court cannot, can you, as universal legatees, probate court, the testamentary court is in season of the testamentary matters,
Testamentary
so called. So you
Well,
are claiming through the testamentary aspect of the matter.
Normally, it
Your
is the-
focal point is through your window of the affectation is through the will. So that's the subject matter of the testamentary court now.
of the
So
yes,
if you
of
have
the
a cause
estate.
of action regarding that the will, the estate is being mismanaged, it boils down to a testamentary action for which you have to go to the testamentary court.
Yes, but the,
But the appeal is not properly looking after the estate. It boils down to that only.
appeal is not looking after.
They should have done otherwise. I mean,
They should done
not have
otherwise. They should done otherwise. So my
You can
grievance.
seek an action against the APL also, or
Well,
whatever.
seeking
On
action
an
against,
interdiction there.
seeking an interdiction of the APL will again, Lordship, as my lord only said, this is a decision of the majority of the board. So APLs, if today is injuncted, whether that will suffice it, saying Lordship, it is this
So
is
rather UBS IB remedium sort of thing.
well, after all, the estate, after all, it is normal course. It is the same interlocutory court which takes up testamentary suit as well as other interlocutory.
That you cannot. Yeah. These are two different hats we wear.
Yes, two different hats. So it's once it is a contentious
that
cause.
is not very attractive.
Lordship,
that argument.
once it is a contentious cause, it becomes like an ordinary suit.
Same judges take up criminal matters also, so we cannot send them to jail.
Lordship, but then the 295, once it becomes a contentious cause, it follows the same procedure as a civil suit.
Yes, but still
So
it remains a testamentary
Yes,
action.
no
Because
doubt.
contentious, it's marked as a suit.
Yes, but
Nothing
there's suit.
else. It remains a testamentary matter, and testamentary matter is governed by succession. So it does not come under section 9 as such.
No, it will not be. I mean, not
We
a-
act
not a-
as civil courts, we act
Civil
in
procedure code
many
applies
capacities.
substantially.
In entertainers, as entertainers in YouTube, and in several other capacities. So, Mr. Mitra, that does not, I mean, appeal to us. That we then go to the testamentary court as the testamentary court.
My difficulty is
Subject to hearing Mr. Banerjee and Mr. Bachawat probably, because Mr. Bachawat has a secondary role to play here. He makes it very clear.
and Mr. M.K. Sharma.
I'm here to earn the free thanks to Mr.
Don't say that now. It's yes.
And the administrator is also there,
Yes.
who appeared on that date to
So very well. Mr. Mitra, you want to add
Yes,
whatever it is, complete your arguments. We're not against you right now. Not that.
no, I know
So, I
that.
mean, we have
Lordship,
understood what you are arguing.
Lordship, of course, has understood. Lordship,
Have we understood what you are
Lordship, so my points are these are yes, and the balance sheets I have shown.
very complicated?
Lordship, also the balance sheet, just take a look. The accounts page 650, it has remained the same, whether this requiring additional space suddenly 650, just see the
Yes.
649, for example, East India, 649,
Yes.
that is the balance sheet of East India. The profit and loss account is 650. Has
Yes.
Hammal got it?
Yes. What have you tried to
Income. Income revenue from operations, it is
Yes.
in thousands of 115 crores. Now, what is the breakup of this income? Schedule 12, note 12 is next page at page 652.
Yes.
The revenue from operations is dividend income
Yes.
and no other business. Lordship, see salaries and wages under note 14, employee benefit expenses, 3,43,000 is the total expenses salaries. And each of these companies have no running business. Suddenly, when it was never required, all of a sudden, that's the other question. There again, if the company is divorced from the estate, then in that case, it's the company's internal affairs. But if it is the company is being managed by the nominees of the officers appointed by the court, your lordships have a right. whether testamentary court or this court, I am not, to ask why do you suddenly need this additional space? And why do you need to go to 7th floor and not take an offer? Now, since this is offered, since no agreement is signed, why you don't have to, would you not be interested in the 3rd floor?
What is the window through which the civil court will enter? Testamentary court has something there. Yes, you're right. Because these are decisions as the APL committee members are doing this.
Well,
Company court, we are not the company court, and you are not the members of the
No, company
so
court
we
is-
don't company court does not have jurisdiction. We can understand that. But what is the window through which the civil court will look into?
it is a civil action. I'll put it like this: is a section 9 CPC. This
And
is
your
a,
right is through a will.
by right is under right may be derived under
Under a will, through a will,
Like-
whatever will.
like a derivative action. This is a double derivative. This is double derivative action.
Yes,
Double derivative action.
yes. Double derivative.
Double derivative actions also, there are judgments which says double derivative action can, because I am deriving my assets through 104 through estate, and
Double derivative, the decision said the double derivative action can be initiated where? Before which forum?
just check whether I should have double derivative actions. Let me just see if I have it handy here. এটাই লেখা আছে। This was a double derivative action. If you can get this judgment, I can send you. আমি তো airdrop করে দিচ্ছি। Whatever is a English court judgment আমার এখানে আছে। ঠিক আছে? এটা আনিয়ে নাও।
What has been held there? I mean, just the context. Yes.
I'm just reading out the head note.
Yes.
The claimant and the second defendants were participants in a property development joint venture carried on through a limited liability partnership LLP in which they are the only members with equal shares. Huh? দিতে পারো। Okay,
There's only one.
only one. I দিয়ে দাও।
So we can hear you.
No, I'll get it ready. Universal Project Management. The LLP owned all the shares in the first defendant company. A company incorporated as a special purpose vehicle to carry out one of the development projects identified by the joint venture. হয়ে গেছে? A disagreement arose in relation to the development. The second defendant incorporated the third defendant, a company wholly owned and controlled by him, and secured purchase of the development of under the same terms which had previously been available to the first defendant, which is the LLP controlled company. The claimant brought proceedings alleging the second defendant had pretended the third. There's too many defendants involved.
Too many tabs involved. So you see it in your own tab.
I want asking for that only.
You won't have this.
I know they won't give me a tap.
They won't. You have to keep a tab on the matter.
Airdrop করে দিন আমাকে।
পাঠিয়ে দাও,
Yes.
airdrop করে পাঠিয়ে দাও। ও আচ্ছা। I will just give it. I will just give it. Mr. Sharma's iPad will show up for sure on mine.
iPads may give a different version.
Yes, then
There are
Sharma is
different
there.
technology. iPad and Android are, this is
But আমি পাঠিয়ে দিয়েছি।
yes.
সৌম্য's iPad তোমার তো
একই সাথে।
পেয়ে গেছো তো?
হ্যাঁ, ঠিক, তোমার একটু double
Yes, so may I read? The claimant, and I do not know what is the outcome because this has just come to my mind. Maybe this will go
Yes, you are
against me.
taking a risk.
Maybe this is, I'm taking a risk.
That's why I bit my lips when I said asked you what happened there. I mean,
Well, I just
I
long
anticipated
back.
you're not sure of
Some matter I know.
it may go either way.
The claimant and the second defendant, they were participants in a property development joint venture carried on through a limited liability partnership, in which they were the only members with equal shares. The LLP owned all the shares in the first defendant company. So that is the company. A company incorporated as a special purpose vehicle to carry out the development projects identified by the joint venture. The disagreement arose in relation to the development. The second defendant incorporated the third defendant, a company wholly owned and controlled by him, and secured the purchase of the development on the same terms which had previously been availed been available to the first defendant. The claimant brought proceedings alleging that the second defendant had pretended that the third defendant was another joint venture entity and had thereby misappropriated a valuable business opportunity of the first defendant for his personal benefit in breach of his fiduciary duty to the first defendant. To the first defendant.
Your locus standi comes nowhere near
Like
their
here,
locus standi.
like the partner of the.
They were
of the
shares.
LLP.
They had shares in the
No,
joint venture.
partners had shares in the LLP, but partners of LLP.
yes.
LLP had shares.
The claimant also had. The claimant and the second defendant were participants in a property development joint venture in which they were the only members with equal shares.
In the LLP, they had equal shares.
Yes.
The LLP owned all the shares in the first defendant company. So the LLP owned all the shares in the first defendant. So the company which is concerned.
That is precisely what is happening here, because these companies, if you had shares in the companies, then this would apply to you, the analogy.
But
their LLPs were the architects of this cause of action in this matter. The LLP, one of them, I mean, the second
partner of LLP says I have a derivative
another company,
because
yes.
I have a right in LLP. LLP holds all the shares in the defendant company, first defendant company.
Yes.
Here I am saying I have a beneficial interest in the 100% shares. This 100% shares, shareholders are represented by the APL or officer.
Beneficial interest in that creates another layer in between. That makes it more remote. Your connection, I mean, the shareholders could have been in this position. This is the second degree involvement.
The shareholders are
second derivative. Yes, second degree involvement is of the shareholders.
Of the
shareholders.
Of
the company, the first degree is the company.
The company's shareholders.
Company's interest. Yes.
They have only one shareholder, the company LLP.
Yes.
LLP is the only shareholder of the company. LLP's partners.
All right, you say that.
That's the first paragraph. The claimant and second defendant were participants in a property development joint venture carried out through a LLP, in which they were the members with equal shares of LLP.
Very well.
Now, LLP owned all the shares in the first defendant company.
Very well.
So,
very well.
I cannot bring it same as mine.
No, it cannot be same, but understood. Yes.
So permission was granted to continue, and the outcome is a different matter.
Where did they go ultimately? Which forum?
Also, you can see the held grant.
This couldn't have been a civil court.
Granting permission, you see, like it is even today.
They went before the company court.
Let's see where they went.
Must be a company matter.
The derivative action permission to continue will not be. This was a derivative action suit. Let me see. It's to be a suit.
Second defendant, yes. Defendant, but how do they mention? I mean,
just a minute.
Their company matters may be mentioned as company suits, or I don't know.
No, but if it's under the Companies Act,
appears to be purely a company action. I mean, under the company jurisprudence. Section 260 of an act has been referred to. What is the act?
Claim. Applicant continue the claim.
Companies Act Section 260. Probably it was a company matter.
also, can you see paragraph 16? The ordinary derivative action was by 2006 a long established ordinary derivative
Section
action.
260 of the act has been referred to here somewhere. Section 260, that is of the Companies Act, which is evident from the head note.
Since my lords are rising now, we will
Yes,
check
yes,
it out
yes,
by
please,
the
please go
time
ahead.
before your lordship
Right.
come back.
Tap.
We will get the printouts in the meantime.
Yes, yes. এটা রোজ দুবার করে সই করে।
কি করছো রোজ?
Yes.
Interesting. Yeah, yeah. Like our civil courts, in fact, our division bench has also held that when Company Code when the Companies Act doesn't provide the remedy, then
Civil code can.
Section 9 is available.
Yes.
Of course, there's whether the civil code where I'm bringing the under that umbrella even testamentary code. So that remedy is available. Now, that is what is found in Z Invesco Delhi High Court, and our Calcutta High Court division bench is also held so. If the remedy is not available, तो Z Invesco আছে. But here, paragraph 44 onwards. Paragraph 44. I have come to the balance of the conclusion that 2006 Act did not do away with the multiple derivative action. My reasons follow. First, there was before a common law procedural device called the derivative action by which the court could permit a person or persons with the closest sufficient interest to litigate on behalf of a company. Closest sufficient interest. By seeking for the company relief in respect of a cause of action vested in it. Those persons would usually be a minority of the company's members, but it might, if the company was wholly owned by another company, be a minority of the holding company's members. These were not separate derivative actions, but simply examples of the efficient application of the procedural device designed to avoid injustice. To different factual circumstances. In 2006, Parliament identified the main version of that device, namely where locus standi is accorded to the wronged company's members, labeled it a derivative claim, and enacted a comprehensive statutory code in relation to it. As a matter of language, 260 applied Chapter 1 of Part 2 only to that part of the old common law device thus labeled, leaving other instances of its application unaffected. Applying the well-established relevant principle of construction, Parliament did not expressly abolish the whole of the common law derivative action in relation to companies, even though by implication, from the comprehensiveness of the statutory code, it did so in relation to derivative claims by members, like here 240, as defined of the wrong company. Beyond that, the assertion that the remainder of the common law device was abolished fails, because abolition was neither expressed nor a clear or necessary implication. Section 260 could so easily have been phrased to achieve precisely that result. Subsection 1 could have excluded the phrase by a member of a company and reintroduced it in a subsection 2 as a specific additional requirement in subparagraph A, so that it read under this chapter by a member of the company. Alternatively, the whole of the common law derivative action the companies could expressly have been abolished, as it was, for example, by 236 of the Australian Court. The right of a person at general law to bring or intervene. Neither Lord Millett nor any of the other academic writers who have concluded that the 2006 Act abolished multiple derivative actions have addressed a simple point of construction advanced by Mr. Lightman, Mr. Colin Hollington QC, and so on. And it may be assumed that the editors of Palmer's loose leaf must have applied the same or similar. I reach this conclusion with some relief. Not only does it address the manifest scope of a real justice, which the abolition of any derivative action by members of a holding company would have entailed, and as graphically described by Lord Millett in his article, but it ensures that the English company law runs in this respect in harmony with the laws of all of which have, albeit by different methods, ensure that injustice of the type described can properly be addressed. Now, our company law has held similarly in civil suits when where the issue came up, 430 excludes your right. Vikram Jairath for example, the division bench of Bombay High Court. In Invesco, Z versus Invesco. Lordship kindly comes, এটা কোনটা? এটা আমার সঙ্গে মিলবে প্যারাগ্রাফ, তোমার সঙ্গে আমার সঙ্গে মিলবে না প্যারাগ্রাফ না? Lordship paragraph 93, তো এসএসসি প্রিন্ট আউট, আমার এটা মনে পড়ছে।
হ্যাঁ, এটা কাজ করছি।
93 quotes 430.
93 quotes 430, yes. After that, 94. The aforesaid section provides for two contingencies. One, where a civil court jurisdiction is barred in respect of any matter which the NCLT or NCLAT is empowered to determine. Secondly, no civil court shall grant an injunction in respect of any action taken or to be taken by the NCLT or NCLAT in pursuance of any power conferred on them. Then, Lordship, in the context of 430, we draw useful reference to the following observations, 95, by the High Court of Madras in Selvaratnam's case. Fourth, Lordship, I am avoiding the quotation. Lordship kindly comes to paragraph 97 straight away. In the face of the absolute bar contained in section 430, we cannot appreciate how the learned single judge could have granted the present injunction. The scheme of section 96 to 100 makes it clear that the subject of calling of a meeting of a company has exhaustively been treated under them. So far as meetings of companies other than annual general meetings are concerned, the law is governed by 98, which kicks in if it is for any reason impracticable to call such meeting. 100 gives the right to the requisitionists of an EGM to themselves to call a meeting for consideration. I think I missed out the relevant para, Lordship. Well, I missed out paragraph 94. 94. This is what I want to show. The aforesaid section provides for two contingencies. One, where a civil court's jurisdiction is barred in respect of any matter which the NCLT is empowered to determine. Is empowered to determine. I am on that.
So you say if you are members, then you could not have approached the civil court
I would have
because
had to
it's
go
barred.
244 proviso leave.
But you have any other sort of interest, derivative or otherwise,
I have no.
then there's no bar, so you can approach the civil.
So the same effect is what asked Bikram Jayaratta. One paragraph Bikram Jayaratta. Our division bench has also held the same way.
This, I mean, does not hold anything either against you or in your favor. Just elaborated, quoted 430 and elaborated and held that civil court did not have jurisdiction, of course, in that matter. Because they were shareholders, probably.
Because they were shareholders. And this
Effectively held such and such total period of share.
One paragraph.
So this does not help you as such, neither does it go against you in a sense.
But section 430 reading. Can you give me one more minute?
Fact remains that you are a third party to the
But I have some interest.
companies.
I have
But
some.
you say you claim interest through, if this was one of the first tier companies where PDB had a majority shareholding, then might be you could have argued that your interest is claimed through the shareholder.
That's what I'm saying. This is that.
But this is not that tier. This is
No,
the
no.
second tier.
So this is the first year.
All these 5 companies, PDB had majority shares.
Yes. Lordship, that was what I was showing from page 500 and
right.
Page.
All right. So you say that by applying the logic of the English tradition, this
Page
universal
573.
project.
Page 573, the APLs only have given the breakup of the shareholding of the page 573, that is in the just that APL's decision.
Yes.
Of course, we because thereafter they went on to say that Birla Corporation is also part which we challenge. But if you see page 573,
yes,
I'll just show it once more.
Yes, I'll see it once more.
Let's start with the first company, page 573.
Yes. Oh, these are these 5 companies.
Yeah.
Oh,
even 8 to 12. First one is East India Investment, where PTB's estate has 72.47. Gwalior, that's another, that's
Yes, yes.
the second company has 50.43. 50.43 company again holds 8.97% in the East India Investment. Third is Baroda Agents, where the estate holds 11%, but the two companies which are controlled by the estate, East India and Gwalior, hold 24. So 59.75. Estate is directly controlling East India and Gwalior. And that is the defend numbers 8 and 9. And now at least these two companies are directly involved, and these two companies are also going to have their sharing the expenses. Now the other three, even though PTB's estate has 11%, these first two companies have 24 each. And that is why, my lord, in all these 5 companies where the estate could directly exercise legal rights through companies where the estate has
East India and Gwalior,
100%.
100%.
I'm sure.
There's no doubt
Now,
on that.
now comes Baroda.
And the two Punjabs.
The
Baroda
two
and the
Punjab. Let's take Baroda, for example.
Yes.
Baroda, the estate has 11, but East Indian Gwalior has
you have, yes.
altogether 50, has something like 50%, 49%. 11 plus 49 comes 59.75. In Punjab, East India, Gwalior, and Baroda has 93%. So these are the companies which the APLs can directly control through, and that is why, well, I'd given the share, the composition of the board was altered by the APLs. That is why, one paragraph volume 1
The difficulty, Mr. Mitra, is legally speaking, APL is representing the estate of the.
Yes.
of
My
the
lord's
state.
officers. My lord's officers.
Yes. Yes.
So APL is controlling these 5 companies also. So you kindly see volume to see page 15 of the in this compilation, page 15. That is why even before the real fight started with the APLs, 2 of them, I mean, that was not there earlier, litigation started. Page 15, paragraph 17. Till 2020, the 3 APLs were always represented because we also, but the other 3 directors, say East India, page 15, paragraph 17. Mohit Shah, Justice Shah, Sharma, Chakraborty. Then Harshloda, Pracheta, Krishnadamani. Now, Justice Shah, Sharma, and Chakraborty remained. Krishnadamani remained, who is the South Point, and in the place, Harshloda and Pracheta came 2 others.
Either the majority number of directors or equal with others. Like in Punjab produce Justice Shah and Shamul Kanti Chakraborty and 2 others. So 50-50 at least.
Punjab produced, Harshloda has gone. Ravindra.
Similar in both the
So
holdings and
basically
trading.
all the boards have been changed by the APS. So APS control through their nominees. This is the uniqueness of our company law. That a shareholder, like that the Vodafone says, majority shareholder has control over the management. Just one passage from Vodafone which you are carrying, which is recognized that the majority shareholder's right to control the management. That is a recognized legal right. Vodafone, 2012, 6 SCC, 613, paragraph, page 717. Page 717, paragraph 274. Shares, we have already indicated, represent conjury of rights, and controlling interest in an incident of holding. Conjury of rights and controlling interest is an incident of holding majority shares. Control of a company vests in the voting powers of its shareholders. Shareholders holding a controlling interest can determine the nature of business, its management, entered into contract, borrow money, borrow, sell, so shares in a company due to premiums or discount, depending on whether they represent controlling or minority interest. Control, of course, confers value, but the value. So here, I would say the controlling interest is with the court.
Here the decision was taken by the board of directors. Now, board of directors, these two APL members are there on the board by virtue of the shareholding of PDB ultimately. So we can derive it to that. So therefore, it can be said that it is through the shareholding of PDB that these directors took the decision ultimately, because they can sit there only by virtue of the shareholding of PDB.
Because they tried to come on Birla Corporation's board, other boards, which we resisted, and they could not because they didn't have the majority shares.
So ultimately, they are representing the estate of PDB in that sense.
And
the few claim an interest as
the number of directors, the minimum directors required, so they added sub-board directors. They are all representing the estate of PDB. That's why paragraph 213 and paragraph 199 of the judgment, these directors should act in the interest of the estate. So this being the position, I was submitting this bill. This is not a case where the interim order, because the initial interim order, though it was granted for 10, 17, 4 days extension, was called for, an affidavit was possibly called for, or else, Lordship, I had submitted to Justice Rao that in case Lordship feels that this is something we could not say that we forum shopped or we chose one court over that. There is genuine some degree of ambiguity, whether it be testamentary court or civil court, being because of the findings. If your Lordships feel today, if it's held, continue the interim order for 7 days, and we will file an application before the testamentary court. Because of the finding of division bench, you can't give orders against third party. That's also a general law, and the board having taken the decision. So, this was my.
Let us hear them then.
I'm very grateful to Bharat for being.
Yes, Mr. Evan.
They are in the same side.
Yes.
Supporting Mr. Mitra, I don't have very much to say because Mr. Mitra said it, I'll take it.
Your offer makes it commercially viable for them to approach you, not bill whatever the other one.
Right.
Your supplementary affidavit is on record also.
Yes, I'll tell you, Lordship, what had happened. When the matter was taken up, I had made a few short submissions, and the learned judge then asked me, look, have you offered them any space and what's the rent? So I said, they've never asked me. They've never asked me for any space at all. So the question of me offering doesn't arise. This comes as a bolt from the blue. And then I was asked for a rate. I said, look, I have no idea what the rate is. I'll have to take instructions. So the next day I came back and I said, look, this is the instruction, and I wanted to file an appeal. The learned judge said that judgment has been reserved. It's not necessary. So this is the
supplementary
situation.
affidavit was not filed.
No,
it's filed here before our court.
Possibly not. I don't know what my yes. Now I had indicated to the learned judge. I had told him the rates. So
you have instructions, and you can tell us also that
yes,
you stand by this supplementary.
Yes. And the other thing here is again a very practical thing. I'm not getting into the legalese of it, but the fact of the matter is this situation has continued for the last 20-25 years since the proceedings have not commenced. These are admittedly all not part of the MP Birla group of companies. But Birla Corporation is the flagship of the MP Birla group of companies, and these 5 companies are also not part of the MP Birla group. Now, I don't see any reason why they should be shifted out of the premises of a MP Birla group company and go to.
They are saying not shifting out. They say in addition.
But now, earlier, that was not the situation. This additional business came up later. I'll show your Lordship the objection required. Their objection was that apparently their employees are being threatened.
Yes.
Now that's something which was completely abandoned.
Now held that not borne out by the resolution.
Correct. So it was abandoned. My learned friends also didn't try to. So there are 3 different reasons they gave at 3 different times. So obviously the reasons to justify it are wrong. 2, it doesn't make financial sense. Number 3, these all belong to the MP Birla group of companies. There's no reason for them, let's say, not shift out to acquire additional space. In companies which do not belong to the MP Birla group. It's as simple as that. And your Lordship has seen their rival wings fighting. One group obviously belongs to not the MP Birla Group, and it's being shifted there. So it's more than meets the eye is all I can say. I don't want to go
Mr.
beyond
Bhagat,
that.
who is the beneficiary of the will of PDV?
Lord, as the company, I've never really looked into it. I've never bothered. Your Lordship will remember I was not a party to the probate proceedings.
Lodha.
An application was filed.
Sir, Lodha is
Hello.
the beneficiary.
Lord, yes, that's what they say, but I think there's a lot of charitable,
Others also.
in our will as well.
In our will,
Their earlier will, it is charity.
Lodha and Lodhis.
no, in
Lodha,
our
after
will, it
Lodha's
is
death,
charity. In their will, they are the beneficiaries.
No,
After Lodha's death. Charitable is their earlier will.
So, but that goes against you, Mr. Mitra, because why should it then be retained under the, what is the interest? What is the fun in retaining the lease? I mean, why sticking to the builder group, one of the builder groups, held by the builder groups? Because their interest is contrary to the will then.
Yes, contrary to will. So that's why I was saying this should.
So, if they stick to Mr. Bachawat's client, then one of the premises of argument is that because builder group holds this
MP Birla Group.
MP builder group.
MP Birla Group, which is the Priyambada Devi Birla's estate.
But then there is no sanctity to that ground because that you have to stick to MP Birla owned lesser.
No,
I mean,
no,
what's the fun in that?
Lord,
I mean,
not
that goes contrary to the interest of the will.
Lord, No, Lord, let me put it this way. Lord,
Lower rate,
lower rate.
commercial viability is a very important factor
Yes.
which is there.
Lord, given the fact that there are two warring groups, for it to shift out from the group where it has been there for the last 25 years or maybe 40 years, 50 years, to
Now
shift
they
out
don't
and
want
go
to
to a
shift.
rival group. Lord, I have a problem with the rival group. Your Lordship has seen. I was not a party to the probate proceedings. Lord, number of proceedings filed in the probate court, and they got injunctions against my general meeting, which ultimately your Lordships
But the
were pleased
universal
to hold.
legatees do not claim through the will then. You don't get through the will.
Lord, I'm a
No, not
company.
you. I'm sorry.
I'm a public
You
limited
don't get through
company.
the will.
I get to the will.
How much? I mean,
These so-called whatever the 70% shares in East India and the 58% shares
if the
in
will is
entirety.
probated,
I
the
get
letters of
it.
administration are granted.
Entirety.
entirety, whatever Mrs. Birla had at 78 and 50, and through that, I will be getting all those shares.
That is by virtue of devolution of interest through inheritance or succession.
Mr. R.S. Lodha gets it. R.S. Lodha dies in the
R.S. Lodha gets through the will.
to the will. R.S. Lodha dies intestate. So section 100. So I am the. So that's when I was replaced as the plaintiffs in the suit, and the suit converted from probate to letter of administration with the will annex. And 104 says that if it is that if the legatee dies, his heirs will get it. So it will not go back to the if the legatee dies after the demise of the testator or testatrix, then the legatee's heirs will be getting that bequest. Whatever.
Legatees heirs are the Lodha group.
My client. All the plaintiffs. Meenakshi is the daughter, Aditya and Harsh Lodha.
Oh, sorry, right.
So the
Yes.
three.
Yes, you are the Lodha. Yes.
Three
So-
claimants.
Right. All right. Very well, Mr.
So,
Patel.
this is one part, seeking to shift out. Two is the commercial aspect of the matter. Number three, as I was pointing out, I am not concerned with the disputes. It's a public limited company, lakhs of shareholders, not mutual funds, government institutions. But this fight into which I was dragged by filing an application in the probate court, not ex parte orders of injunction obtained against me. Ultimately, I was relieved. It was said, look, you can't have a right over the tertiary tire companies at all. Now, I don't want to be dragged into it, but the fact of the matter is one group has continuously litigated against me in various forums. Now, the one other thing which your Lordship has to see perhaps are not many of the directors of these so-called tier 1 companies or the seventh floor owners are those that Daga, Damani, that lot. Not that.
But Mr. Bachchat, you cannot argue on those.
I'm
we cannot
not.
hear you on those.
I'm not.
because
I'm not. And one legal.
in the scope of this suit, you don't have only
No.
you have to say whether you offer
That's
a
all,
better
that's
price.
That's all. That's all.
Do offer a better
And as far as the legal point, interesting legal point which came up, again off the cuff. My gut feeling is this. Your Lordship has also put it this way. Where there's a right, there must be a remedy. Now, the remedy as I saw it. I may be completely wrong, but today the APL represents the estate. Now, the APL is now in the tier 1 companies in two capacities. But first as representing the estate, but secondly as a director. And that's where the anomaly lies in trying to figure out whether it is not to be a not company action or whether it's to be a probate action. Now, given anyway, fact of the matter is not one group will ultimately end up being the owner of the entirety of the shareholding, one group, whichever it be. Now, if not the directors of the company, or rather the APL qua directors of the company or their nominees, commit a wrongdoing, qua directors, but then the action may be one way. If on the other hand, you allege that their wrongdoing is as APL.
But we have to see who is wronged. Wrongdoing in what sense? Against the interest of the company, these 5 companies, or the interest of the estate?
Correct.
Two wrongs we are
Correct.
talking about.
That is the exact point. Your Lordship has hit the nail on the head. So, if it is wrongdoing against the company, it may be said that one set of remedies lies. Now, to say that a company action would be barred per se in any situation may perhaps again be a fallacy, because it is a common law right also. Apart from statutory rights, common law rights to file a derivative action or any such thing has always been recognized. It is just that, if you want a special relief under the Companies Act before the NCLT, then you have to fulfill the conditions. But to say that a suit will not lie, perhaps may not be correct.
All right.
A common law right is there. Of course, I have nothing to say on this. But the rates are mentioned in the affidavit, and
Almost
they're
half.
substantially lower.
Substantially low at least.
And the rate at which they are going is a substantial jump again. And
100 times, Mr.
it's a huge jump, almost that. And the other thing is, it does not appear that they took any quotations of what other rates are available, and that is also, they never asked us at least, will you offer us
As
more
lesser,
space?
you don't have any right to say anything.
No, I don't. But I'm simply on this, the way the order has been turned against me, as if I did not offer him space. That's all. But I was asked, look, are you willing to give it? What is the rate? I said, I don't have instructions. So that's all I say. But if quotations had been taken, maybe they would have found better rates.
Yes, Mr.
And
Manager.
in the same building on the same floor is always an additional. Normally one would pay a premium. If I have an office here or a house,
Unless
and
you
I
want
find,
the view also.
of course,
That is the only thing I can
But-
think of.
but-
Because otherwise,
but
going to the 7th floor from the 3rd floor won't help.
well, in this case, I think that's the only thing.
Logistically easier if you have on the same floor, obviously.
But and in this case, I think
You have to
the
push
only
instead of-
thing, the only thing that the APL probably has to do is to take the view, because as Mr. Mitra has pointed out, these companies have no business. Simply collect the income, put it in, and then, from what I understand here, pay it out to one of the rival claimants at 100-time higher rent. It goes to them. That doesn't make sense.
That
Doesn't
may
make
be the
sense.
actual reason, but whether we can, how far we can go into it.
Yes, that's a different thing.
Mr. Mojumdar, you're for the APL, the majority APL.
No. I am for the third, MK Sharma, defendant number 7. I take your lordship directly back to, my lord, the letter which I had written, dated October 25, 2024. My lordship will kindly take the letter for once.
Do any of you read Terry Pratchett by any chance? Terry Pratchett, he's a writer, he's an author.
Yes.
The entire concepts go topsy-turvy. Day is night and night is day. At the end of the story, I mean, you get confused what is day and what is night. So now Birlas are owned by Lothars. Birla companies, the companies were named as Birla are owned by Lothar.
Ah.
And the MP Birla group and the other way around. So at the end of the matter, we'll be utterly confused. And instead of hitting the nail on the head, we feel like hitting our head on the nail. Just confused. MP Birla now is yes, controlled by Lodha, and
Yes.
I don't know what is controlled by.
The rest of the Birlas are still.
And Birla controls the litigations, probably.
That will be nowhere.
Yes,
I
Mr.
take your
Mojumdar, yes.
lordship back to the letter which I had written. Kindly take the letter for once.
Give the page number.
Well,
boss.
I think page 961, volume 2.
Yes. 961, yes.
Kindly take the first paragraph for once.
Yes.
I refer to the board meetings of Gwalior, Webbing and East India held on 23rd October 2024, where your good self and Mr. A.C. Chakraborty, this is addressed to my lord Justice Shah,
Yes.
my lord, the third member, about a significant proposal to lease additional space of 1852 square feet situated at East Wing 7th floor in Birla building at an exorbitant rent of so per month so, which will automatically increase by 15% at the expiry of 3 years. There is also a proposal to pay substantial deposit of 11 lakhs. So, this is the proposal which was considered on 23rd October 2024 with not less than 24-hour notice to me. I am a member of the, I'm a director and also member of the APL. I just there is a prologue to this.
You are a director in two of the companies.
Yes.
The
these
East India and Gwalior.
East India and Gwalior. That is why I am writing in respect of these two companies.
Oh, acha, right.
Your lordship will find from the first sentence itself.
Yes.
Kindly take the third paragraph. Second paragraph. To my specific query, whether the companies will vacate the premises made available by Birla Corporation, it was clarified by Mr. Chakraborty that it is intended to retain the space of Birla Corporation and the new lease will be over and above the space currently available.
This is a joint lease in a joint tenancy in respect of all these companies.
Yes.
Joint tenancy.
Yes.
Good.
Well, perhaps they have annexed the agreement.
We'll look into that. So there's one agreement, joint tenancy.
Now, there is a proposed deed which they have annexed. Well, kindly take one now, the third paragraph. There has not been any material change in the size and scale of operations or number of staff members which may warrant leasing of additional space. Well, actually, a meeting was held on 31st August 2024, which I placed before the Honorable Single Judge. On 31st August 2024, a discussion was held that it was alleged that some members of the staff of this company are facing threat. There is a threat perception. So far as the office which is at on the third floor of this Birla building. Now, my lord, so that was the main reason for which this kind of step was sought to be taken. Now, my lord, after that, your lordship will not find from these minutes, or my lord, in fact, the minutes of meeting held on 23rd October 2024 has not been circulated to me till date.
And the learned single judge has also disbelieved that ground.
Yes.
In specific words.
Yes.
That has not been substantiated.
Yes. Now, kindly take. So, first ground was threat perception. The decision which has been taken on 23rd October 2024, my lord, does not speak of threat perception at all. Your lordship will find it from the agenda note annexed to the supplementary affidavit. So, my lord, it is only in the case of additional space. Now, kindly take. I also stated at the board meetings that there were no competitive courts or benchmark used to determine the fairness of rent and revisions if there was a justification. For it, I have therefore, for the aforesaid reason, dissented from the proposed resolution. If that be so, this is where the offer or the proposal of Birla Corporation now comes into play. Birla Corporation was never approached. Now, Birla Corporation has given a competitive rate, better rate, if and when compared to the rates given by the proposed, the intending landlord. Now, in my most respectful submission, shifting of registered office of companies belonging to Ravel Birla is clear attempt to hijack the investment companies. Now kindly take the third paragraph. There is no cogent reason given by the board, notably two joint APLs for shifting of the registered office of investment companies, which have been operating from the fourth floor of Birla building for the last several decades, spanning the lifetime of MP Birla and Priyambada Devi Birla at a very nominal rent, permissive usage basis. Now it will be 100 times the expenditure which was used to be incurred for the purpose of renting of commercial space is concerned. It's 100 times. Or more or less 100 times. So, the question is that this kind of decision, it should not only pass the test of commercial expediency, but also pass the test of the interest of the estate. Since in my most respectful submission, the interest of the companies, tier 1 companies, get subsumed in the interest of estate. if we take a pie chart, this is one big slice of pie, so far as the interest of estate is concerned. Now, we'll kindly come to the next paragraph. The only reason for the purported relocation of the registered office has been that our employees are feeling threatened. Well, this was the earlier meeting,
Yes.
which is ex facie, concocted and misleading. There has been no complaint of any threat of any kind in the past which has ever come or been brought to the notice of the joint appeals. Even the office of joint appeals is functioning from the 4th floor of Builder building. And Ms. So-and-so and the secretary, who is also employee on the payroll of one of the investment companies, have been attending his duties and sitting in the same floor, have never complained of any kind of threat or pressure created on him of any quarter. My lord, I put the question to myself, my lord. I pointed out to Justice Shah as the third member, in his capacity as the third member of APL. And I also registered my demur, so far as the decision is concerned.
That resolution of 23rd October is a part of this entire papers.
No, it has not been circulated to us.
Very.
Circulated to you.
To me.
Yes.
No.
You're aware of it.
No.
Anyway.
No.
It's not a part of the record.
Not a part of the
only
record.
that.
Only
Going
the
to the
agenda
rest
note
like-
has been circulated,
Very well.
and it's circulated on 23rd or 22nd of October. But the board resolution has not been circulated.
But you did not attend that despite having notice.
No, I attended that. That is why I registered my demur.
All right. So in that meeting also you had,
Yes.
which is what you were
Yes,
stating.
that is what is stated.
Right.
That is why I informed everybody that this is the outcome of that meeting.
I also stated means in the meeting.
Yes.
I stated at the board meetings, right?
Yes.
Very well. Yes.
Well, then comes the next paragraph. Taking on rent the office space at an exorbitant rate and spending money of 70 lakhs and odd for renovation, plus renovation of the space at the cost of investment companies, a wasteful expenditure, and will definitely amount to depletion or dissipation of the assets of the estate of Pirambada Devi Birla. Considering the fact that the two joint appeals are claiming that the investment companies to be part of the estate. It's a derivative right, man. But the participation in the board is a derivative right as a being member of the APL. Now, my lord, the two joint APLs have already squandered. I'm not getting to that. The two joint APLs are also treating Birla Corporation to be part of. My lord, this is the other part. Now your lordship has dealt with that in the other judgment. So, my lord, my case before your lordship is that, my lord, really would not have been. It would have been prudent to get offers from, if there is any. First of all, there is no requirement of additional space. I make it very clear. Even if assuming, though not admitting, there is requirement for additional space, then, my lord, quotation should have been taken from, my lord, the other landlords, namely, my lord, Birla Corp, who is your existing landlord. Because, my lord, it will be in the best interest of the company and best interest of the estate. Well, these are my responses.
Yes.
Lord, just want to understand, my lord, who are the really the person, my lord, who made submissions. My lord, the plaintiffs claim, my lord, to be universal legatees in respect of an estate.
Yes.
For which, my lord, testamentary proceedings are pending. One is, my lord, Birla Corporation, who is really a landlord, who has a tenant, which are, my lord, these 5 companies. And the other one, my lord, is a minority APL member. Why I say minority? Because, my lord, quite naturally, my lord, he is opposing the decision. The majority has taken, my lord, a different decision. Let us, my lord, first see, my lord, the civil suit he files. Now, my lord, as I understand, my lord, in law, if you do not have locus and you do not have a cause of action, then the law can't give you that. You will have to come to court and show how you have a cause of action. The plaintiffs today say, my lord, they are not shareholders of this company, of any of these 5 companies. So the action is by a non-shareholder of incorporated companies challenging board decisions of those companies. Because Mullah, these are Mullah, the submissions which we made, and Mullah, I think Mullah, on the question of maintainability, I'll show that paragraph. When I just will, I'll also consider the other points raised, but at this moment, I'm not passing an ad interim order of injunction. So Mullah, the proposition which they advance is that a civil court will have jurisdiction to stop decisions taken by board of directors of incorporated companies at the instance of non-shareholders. That's what Mullah, the proposition Mullah, is being advanced. Now, Mullah, what is the decision being taken? The board has come together to say that, look, we have 5 companies. We have this space at 4th floor. We are looking for additional space. We want 1852 square feet, which we find is also available on the 7th floor. We are taking that space. And 5 of us will share the rent in whatever proportion we have decided. This is Mullah, the decision. Now, very important, and which has not been told to my lord, the existing lease with Birla Corporation Limited has expired on Mullah 31st March 2024. There are letters on record to say, please extend, and we are also giving 1 year rent so that you don't throw us out. Till Mullah, the filing of the suit, there is no response to that. There is no response to that. Who's Mullah? Mr. Ranjan Bachawat's client. It's only during, and Mullah, that Mullah, if required, Mullah, whoever was there will put it on affidavit to say only in rejoinder, Mr. Mitro said, and this was a submission to court, saying that, oh, they have not asked Birla Corporation Limited whether additional space is required or not. In that context, and this is what, because we were all present in the hearing, the judge said that is not relevant. Why should a tenant go and ask whether any further space is available or not? It's a decision by the tenant to have an additional space which they think they require. In that context, my lord, this came up, this affidavit was not, my lord, before the trial court. The question didn't arise because that was not an issue. And my lord, I'll straight away, my lord, kindly see, my lord, page 55, the letters which
55 of the stay application.
Of my lord, the stay application. Volume 1, my lord. Paper book, my lord, not stay application, I'm sorry, my lord. Volume 1, my lord, which they have. East India, my lord, this is on behalf of East India. This is further to a letter dated 15 March 2024. Second. Further to a letter containing check number dated 15 March on State Bank, amounting rupees 19 towards rent for the year starting from 1st April to March 25 for the office space. From our records, we have come to know that the said check has not yet been encashed yet. Therefore, we have transferred amount of 19,000 and such. We are requesting you to renew a tenancy and execute a tenancy agreement for letting out of office space at 4th floor building for a further period of 5 years with effect from 1st April 2024 to 31st March. You request to share the bill receipt for the payment made. You are requested to share a draft agreement for renewal of the tenancy for a further period of 5 years with effect from 1st April to 31st March 2020 and experience eliminates formal execution. This is Mullah to Birla Corporation, then Mullah sees 56.
These were annexed to the plaint.
Yes.
Yes.
56, 57 are Mullah those 3 letters. No reply to this, no renewal. And this is Mullah in May.
What is the pleading in the plaint on these? They must have pleaded something in this, the context of MN.
Mullah, kindly come to.
Facts have been recorded. Para 7 probably.
Very interesting, Mullah. The pleading, I'll in fact show, Mullah. That is also, I would have shown that. But kindly, Mullah, come to.
Para 7 maybe.
Yes, Mullah, page 7. Absolutely, Mullah. Before that, para
6 also.
Yes. And kindly see 7. Now, who's saying that universal legatees are saying this? Irrespective of execution of formal agreement, the said companies are made payment of the rent from 1st April 20 till 31st, particularly the payment of rent for the period surcharge received by BCL are given herein below. and then what is given. Above facts have been recorded in letters written by said companies, being the respondent 8, 9, 10, 11, all whereof as answered, chairman, board of directors, efforts. I am very confused. Now the universal legatees, all this while, when we argued the other matter, we were told, I'm sorry, hands off to Birla Corporation Limited.
Irrespective of execution, here it should be irrespective of non-execution.
Yes. Yes.
In a sense.
Yes. Yes.
Right. Very good.
So, I am very confused because, in the other matter, we were told, no, sorry, hands off. The APL and the estate have no rights in respect of any of these companies. Now, I find Birla Corporation Limited coming and espousing the cause of the estate. And I'm surprised because the learned judges also held, this is the market rate. Now, Birla Corporation Limited decides now, when the suit is pending, to actually give it at a lower rate at the instance of universal legatees.
Who said it's a market rate?
The learned judges noted, and that's what in the, because there were two meetings, board meetings, 31st August 2024, where one of the directors, Mr. Sharma, went and said, this is his statement. The board considered and said, sorry, we need additional space, we are taking it. And again, 23rd October also. But now, we are on the question as to the cause of action itself. And this was a submission before the learned trial judge also, saying that if you are coming as a non-shareholder in a civil suit, I'm sorry, you cannot come in. Because we have to look at the larger proposition of law. What you're saying is really dangerous. A non-shareholder to a company who has no right, no connection in that sense, will come today and challenge a decision taken by the board of directors with regard to its affairs. Knows under section 179 of the Companies Act, board takes decisions. So far as management and affairs is concerned. This squarely comes within its management. I want additional space. I really do not have to justify that to start with a non-shareholder. And if you're a shareholder, of course you have a cause of action, subject to what the Companies Act says. And I'll show Mr. Mitra's judgments. I'm sorry, in fact, Z goes against him. And the other one also, I'll try and explain why that
but
double
Mr.
derivative.
Banerjee, one other aspect is there, whether we should pierce the corporate veil here, because the APL majority, we are quoting, majority APL members, they are there in the board by dint of their being APL members.
I'm grateful.
Which in turn is representing the estate of PDB, where they are universal legacy.
Yes, that will now go to there in the testamentary. Because what are they saying? Today, that's why the double derivative I have to explain. Double derivative was where the LLP had the entire shareholding in the company.
Yes.
The others had 50-50. LLP was controlled by the other side. In that context, they say LLP is the wrongdoer. Who's in control of the company? Therefore, we cannot institute. Now, here, sorry, calling the APL wrongdoer as a corporate body, perhaps doesn't come within the question of double derivative at all. If you think APL is a wrongdoer, then you will have to go to the testamentary court. Where, in fact, the testamentary court has said that in view of this, majority will really prevail so far as the APL is concerned. So, in my humble submission, this two cause of action, and which also asked him repeatedly, you can't have two mixed cause of action in that sense. If you come as a shareholder, if you come as a non-shareholder, I'm sorry, you may be out. Civil court cannot have jurisdiction. And if you say that I want to protect the interest of the estate, which seems to be the line which they're saying, oh, I'm an universal, then you have to go to the testamentary court. And if the testamentary court said that, no, sorry, you can't really interfere with the internal management affairs of the company, then that right is already sealed. You can't do indirectly what you really can't do directly. This is quite accepted position of law. So by coming to court and saying, oh no, court, you must give me a cause of action. You must give me locus. That is what seems to be the
testamentary court at best their argument could be, Mr. Banerjee, we suppose, subject to what you say, that no, the APL, the majority APL members, they bypassed the normal course of action by not taking a decision between the APL members. and directly participating in the BOD meeting and then doing their thing.
That
Then also that would go
Yes.
to the testamentary
correct,
court
correct.
and take corrective action against the APL members as APL members, maybe.
That's right. That will be again an action against the APL.
Yes.
Now the civil court,
That
just
would
because
be one of their ways of bypassing that rider that you cannot interfere into third party.
Correct.
Not as directors, but as APL members, they may have a cause of
they're
action.
also because it
They're
can't-
functioning.
we are before the civil court, high court, that's different.
Hmm.
It could have been anywhere. Today, the cause of action could have been anywhere.
Yes.
So, they could not have gone and complained to any court.
We are to act as a civil court and see whether civil court
That's
has
right.
got.
That's right.
We cannot look beyond that.
Because today,
In this
Mr.
matter.
Mitra's submission, and he also, to be fair to me here, he also made that submission before the first. Said, give me liberty to go before the testamentary court. And we said, we opposed. We said, no, there's no question of giving him liberty. It can't be that today you'll get a blessing from this court to say that you have a cause of action. If you have, you'll go there. If your complaint is with regard to the APL, I'm sorry, APL is under the jurisdiction of the testamentary court. You'll have to go there. It cannot be anything else.
And as board of directors, you have no locus standi.
Correct. Because that's what you're doing. And today, all these decisions, I don't understand. Birla Corporation Limited all of a sudden comes up without and says, no, I'm sorry, I shall not offer you less. I have not renewed your lease. I have kept you from 31st March 2024 till October, I've kept you hanging. Now that the litigation has come up and you want additional space, and nowhere, it says, that we are shifting our space or we are giving that up. It is the stand of the board of directors of incorporated companies.
You, Mr. Banerjee, appear for which of the companies?
I am 8 and 10. One is a tier 1, one is a tier 2 company. If that is relevant at all.
Yes, that is very relevant. 8 and 10.
8 and 10.
All right.
So what is that right you espouse is very important. Because all this, and that's why, I wanted to show, if required, we'll show the division judgment as well, where said, because we wanted interference in the companies, will recall, in the division judgment. We were told, no, sorry. We means, the APL wanted, we also wanted, as also legatee to say, the APL should. The division said, sorry, no. APL will have to go through the provision because they are now the guardian of the estate.
Yes.
Whatever decision the APL takes is with regard to the shareholding of Mrs. Builder. If they falter, if you think there is a problem with the APL, you will really have to, that liberty has also been given. So all that can be bypassed by filing a civil suit and saying it is part of the estate, and we are challenging the commercial wisdom of the board of directors. It is really, if I look at from a company point of view, it is really an interference with running of the company straight away. And as a general proposition, it's not whether it's a universal legatee coming under only someone's will, because let us forget the names. And if you look at the proposition, this is really the proposition. Now, in the judgments, I'm sorry, I can also kindly look at what they asked for in the petition, which is at page 29. What is their really aim to filing this petition? That is also clear from prayer A itself. Page 29, this is the petition.
Yes.
Your petitioner therefore most humbly prays the Lordship for receiver and or special officer be appointed director to the following: to immediately make an inventory of all records of the respondent 8 to 12 situated lying at registered office at 4th floor building and be in symbolic possession of all the records.
This is the application. Where is
Yes.
the complaint?
No, this is the petition. I will show the prayers in the plaint as well, but this is the prayer. And then B is injunction restraining furtherance of the decision or arrangement to obtain leasehold right in respect of such. This is directly interference with the board decision. I'm sorry, my lord, under the company jurisprudence, my lord, if I put my argument in question form, is it possible under the company jurisprudence for a civil court, my lord, really to pass an order at the instance of a non-shareholder in a company? Even a shareholder can't get this in a civil suit.
No, a shareholder can't get. Mr. Mitro argues that a shareholder can't get in view of the bar of
My lord,
340. But others who are interested, who have derivative interests, so-called.
no, derivative, my lord, is also of a shareholder. My lord, derivative only means,
If you go by that judgment.
my lord, Foss and Harbottle, my lord, derivative only means
Yes.
when you're suing on behalf of the company because wrongdoer is in control. That's why,
All
my lord,
were members of the company.
Correct.
Yes.
That's
That
why
is-
the common law gave them a right, because otherwise, my lord, it was thought the cause of action for the company can only be pursued by the company. Derivative, my lord, will recall, my lord, when the suits were done, it was always shareholders on behalf of the company.
Yes. Yes. Complete third parties, no.
Absolutely.
Not in those judgments.
Yes, yes. That's what I'm saying. So, my lord, you have to have a right. And your right, my lord, today, my lord, that will mean any other legatee will come and file a civil suit, ignore the testamentary
Or
court.
maybe any person, suppose any person claims an interest in the assets of a company. He can file a civil suit tomorrow and he can seek an injunction on a decision of the board of directors by saying that I claim an interest in that property.
In the asset directly,
In the asset.
not through the company.
Not through the company.
Correct.
That also can be done.
Absolutely. Absolutely.
Derivative. Because right, very well.
Absolutely. But here, my lord, that is not the case.
No.
Because you are now, you have a really a
Their
guardian
claim
who's.
yes, their
That's
claim has a testamentary reflex.
That's right.
Yes.
That's it. My lord, absolutely correct. As a cause of action, yes, of course, I can come and say, no, sorry, that property is mine. You can't deal with it or you can't do this.
And
But-
I'm not a shareholder in the company, not a member under the Companies Act. But in common law action, I can.
But I claim a right, my lord.
I'm putting this question for Mr. Mitro also because you'll have to.
Because, my lord, I'll show, my lord. So, my lord, I am showing, my lord, only, my lord, the petition to show, my lord, what they wanted. My lord, the plain press.
Yes, those are quoted in the.
Yes,
we
page, my
saw
lord,
that.
25, my lord, it is
First
there.
one is declaration that the
Yes.
resolution is bad. I mean, challenging.
So,
that.
decision of the board is, my lord, bad.
Yes.
And, my lord, Mr. my lord, Sharma's letter. Lord, 61. Again, my lord, he writes, if, my lord, as a member of the board, he can only complain, my lord, to the board if the board is considered. Again, my lord, he has no cause of action as a director. Because that will mean, my lord, any dissenting director, my lord, today, my lord, will have a cause of action. Because, my lord, to also accept or, my lord, the submissions of Birla Corporation and Mr. Sharma in support of Mr. Mitro's client, they will also have to show how they're aggrieved. Because otherwise, it's not that, my lord, will permit, my lord, everyone to come and make a submission. Because my submission is they have no cause of action. Today, the court will not allow submission to be made on behalf of the plaintiffs who also have no.
M.K. Sharma can at best be a witness in the suit. If the suit is ultimately
Yes.
maintainable. At best a witness in the suit probably.
But he can't have a cause of action.
No.
Because neither as a director
He's
and
not a
nor.
party even to the suit. How can he have a cause of action?
Absolutely. So, my lord, in support also, my lord, he shouldn't be heard. That's my submission.
Oh.
Because he must show, my lord, his cause as to how, my lord, is supporting the plaintiff.
Yes.
Even Birla Corporation Limited, my lord, should also come and say, my lord, how he is supporting the plaintiff. They are universal legatees. It's not that, my lord, they are concerned, my lord, with Birla Corporation Limited. Because that's not how they have come to court. So both these parties, my lord, it shows, my lord, how, my lord, this is worked out. But I'm not going into it because we are more on, my lord, corporate. I'm not getting into this, my lord, necessarily, my lord, into this Birla Lodha angle because perhaps it is not required at this stage. I'm sure, my lord, when we ultimately file affidavits, whatever, my lord, we have to show, my lord, on that aspect, my lord, we'll show. But because that is the factual aspect which we have to show, whether, my lord, they're interfering with, my lord, our conduct of, my lord, the company, you know, that is not an issue here. And that is why I'm not addressing, that's a different issue. Now, my lord, kindly, so, my lord, this objection letter at 961 is neither here nor there because he does not have a cause of action either as a director, because he's a minority director, part of the board. The board collectively has taken a decision. That's 179. As also, if he wants his grievance as an APL member, then also the majority has gone with the board and said, very well, we think you must have an additional space of 1852 square feet.
Yes.
And for that, he will necessarily have to go to the testamentary court. Now, quickly, just to show the judgment, first see Z. I don't know why it was cited. Z actually goes against what had happened. Z had 17%. One of the
Yes,
shareholders.
I am also not sure why it was cited because it.
C is the.
That I told Mr. Mitra as well.
Yes.
We told Mr. Mitra as well.
Invesco had 17% shares in Z. They wanted to stop one of the general meetings of Z.
Yes.
Which was requisition under section 100. And in that context, the court held, if can quickly show paragraph 97.
Because the very first paragraph, the third paragraph says the appellants collectively hold.
Yes. And the
starts
trial court had granted injunction.
And here it was held that civil court does not have injunction. This is not directly on the proposition. I mean,
directly not on the proposition, but whatever the proposition is here,
that
goes against him.
Maybe, yes.
Because it held that civil court did not have jurisdiction to stop.
Does not go either against him because his proposition was probably Mr. Mitra's proposition was that non-shareholders also have a right, have a cause of action before the civil court,
This
which is not dealt with
so
here at all. This starts with shareholders, ends with shareholders.
Correct. And it says civil court doesn't have jurisdiction.
Obviously, it doesn't have.
Correct, doesn't
430 is there.
That's right. So, that is paragraph. I made a note, 97, 112, and 127.
Yes.
And so far as the other, this double derivative.
You're going to say jeopardy. Yes, derivative.
That's would be quite a different. Well, actually, we are in double jeopardy. That's correct. I'm so grateful.
For you.
Yes. No, double jeopardy because there he went and resisted.
Testamentary. Yes.
Testamentary said, no, you don't have any right.
Maybe triple, because company code is still waiting for it. Yes.
And I admired the way Mr. Mitra also wanted leave to say that please observe, we will go to the testamentary court.
But will not.
To that, we immediately stood up and said, no, you can't, please don't do that because that will be taken and then gone to that.
Is that observation, you want to take advantage of that observation of the division bench? Obviously for that.
Yes.
That third party.
No, that's what the division, till the division bench looks at, stares at us. We can't go anywhere. Even if the division bench held that you could interfere with companies, then also you have to go there. A civil suit will not lie. Because then you're really, it's then setting up one court against the other, the civil court against the testamentary court.
Yes.
That's what's really happening. In this universal project, I've already explained in my para 44.
Mr. Banerjee will come back after recess, you'll finish it off. Even if you have a different matter somewhere else. Let us finish this off. That will ensure that you are short. That will ensure that you are brief in your arguments.
I can be very brief. Give me 2 minutes. I'll finish.
You don't have 2 minutes. Come back after this. With your 2 minutes, we know the meaning of it.
I won't.
We are sufficiently aware of that. I've been a part of the division bench. I know the 2 minutes of all of you.
Let me put it this way, I won't eat away. I won't eat away from my Lord's lunchtime.
I can assure Mr. Banerjee.
You can eat away from our lunch, but you cannot eat away from our lunch time.
I can assure Mr. Banerjee
That's more precious than the lunch.
that no other court will be sitting at 1:59. So he can come and do this matter and then go wherever he has to go. So he doesn't have 2 minutes. He can take
In the morning, I've been here only.
so nothing to worry.
That's a very good one. Yes. এগুলো এরকমই থাক এসে নো থ্যাংক ইউ Yes, Mr.
Now, my lord, the 2 minutes, my lord, won't, my lord,
No.
now, my lord, it won't apply. My lord, I was trying to, my lord,
No, but anyway,
but no, my lord, I was just, my lord,
yes.
my lord, kindly, my lord, take, my lord, Mr. Mitra's judgment, my lord, the Chancery Division, the Universal Project Management. And may I just, my lord, distinguish it, my lord, with regard to the cause of action. And I think, my lord, we've gone through, my lord, some of the judgment. I think, my lord, the head note actually accurately, my lord, represents, my lord, or, my lord, sets out the fact. So, my lord, just show that head note itself. The claimant and the second defendant were participants in a property development joint venture carried on through a limited liability partnership in which they were only members with equal shares. The LLP owned all the shares in the first defendant. A company incorporated a special purpose vehicle to carry out one of the development projects identified by the joint venture. A disagreement rose in relation to the development. The second defendant incorporated the third defendant, a company wholly owned and controlled by him, and secured the purchase of the development on the same terms which had been previously available to the first defendant. That is why my lord's question whether it was the, if you had a right to a property, then you could have. My lord, kindly look at this then. The claimant brought proceedings alleging that the second defendant had pretended that the third defendant was another joint venture entity and had thereby misappropriated a valuable business opportunity of the first defendant for his personal benefit in breach of his fiduciary duty to the first defendant. Then now kindly see. Since that claim was solely vested in the first defendant, the claimant applied under section 260 of the Companies Act 2006 for permission to continue the proceedings as a double derivative action, a substitution of multiple derivative on the first defendant's behalf against second and third defendants. It was common ground that prior to coming into force of the Company Act 2006, derivative actions relating to companies were creatures of the common law, and that the ordinary derivative action by which a member of a company was exceptionally permitted to litigate a cause of action vested in the company when the company was unable to do so had been wholly replaced by statute derivative claim provided in Chapter 1 of Part 2 of the 2006 Act, which conferred locus standi only upon a member of the relevant company. Two things very important, and I think perhaps my lord had already noticed it, and that's why my lord had the derivative action is always on behalf of the company. That is why in the middle, my lord will find, since the claim, my lord finds that placitum E, since that claim was solely vested in the first defendant, the claimant applied under section 260 for permission to continue a double derivative on the first defendant's behalf.
Yes.
So my learned friends, cause of action which he tries to base on this is actually, with the greatest respect to Mr. Mitra, is misconceived. It's not conceptually correct. Your claim will have to be then.
This is an independent claim that he has.
Yes.
Independent of the interest of the company.
Correct.
That is what you are.
That's right. Because otherwise, my lord, he doesn't come in. Independent claim, my lord, doesn't, my lord, come feature, my lord, or my lord, come into, my lord, this aspect of the company at all. That is why I said, my lord, a common law right, perhaps, my lord, he doesn't have a cause of action. As a non-shareholder to a company's action, because, my lord, in a Companies Act, my lord would have seen 179.
Yes.
The board of directors of a company shall be entitled to exercise all such powers and to do all such acts and things that the company is authorized to exercise and do. And what is one of the limitation? Provided in exercising such power or doing such act or thing, the board shall be subject to the provisions contained in behalf in this act or in the memorandum articles or any regulation not inconsistent therewith and duly made thereunder, including regulation made by the company general meeting. Then provided further, board shall not exercise any power or do any act or things which is directed or required, whether under this act or the memorandum, otherwise exercised done by the company general meeting. then no regulation made by the company general meeting shall invalidate any prior act of the board and would have been valid if that regulation had not been made. Then for board of directors shall exercise following rights also specifically. So today, as board exercising power, he cannot call in question that. He doesn't have the right. And very fairly also he submitted when asked us if the board resolution otherwise illegal. He said no. And even if it was illegal, question would be whether he can challenge it or not. And then there is also section, this is different. 179 is the one which exercises power with regard to the board. So my submission is therefore this double derivative concept does not help him. He is really not suing on behalf of the company. That's also not his case. His case is he's coming in as universal legatee.
Yes.
His case is I want to protect the interest of the estate. Estate means shareholders. Now, again, how much right the shareholders have in the assets of the company is also a questionable. Then we are moving into areas 55 Supreme Court, Bacha Gazdar, all that principles will come in as to how much right, because no shareholders do not have any right in regard to the assets of a company. Lifting the value of Vodafone assets, saying that you can't lift the veil. Other question fell from the court, and this I'll try and tie in with the Vodafone judgment, which my learned friend also cited. He relied on para 274. This is 2012 6 Supreme Court cases 613. This is a general statement of law. I don't think there is any difficulty with regard to this. Shares we have already, page 717. Shares we have already indicated represents congeries of rights, and controlling interest is an incident of holding majority shares. Control of a company vests in the voting powers of its shareholders. Shareholders holding a controlling interest can determine the nature of the business, its management, enter into contract. Correct. Nature of the business, its management, enter into contract, borrow money, buy, sell, or merge the company. So shares in a company may be subject to premium discounts depending on whether they represent controlling or minority interest. Control, of course, confers value, but the question as to whether one will pay a premium for controlling interest depends on whether the potential buyers believe that one can enhance the value of the company. Again, this proposition of law, is neither here nor there, because that's the controlling interest in tier 2, yes, majority, but tier 3, through the tier 2 companies it is held, but then all vests, and the court has ordered in the APL. Because there are rival groups. And today, what my learned friends are trying to do is exactly contrary to what the court has already ordered by saying this right vests with the APL. You cannot override the APL except when you make an application there saying, now sorry, APL is not looking after my interest, you ask them to go. But that is not the cause of action here. So, not being able to make out that case, whether they can come with a substantially inferior case of questioning the decision of 5 companies, decision of the board, and then say you do not follow the APL wishes at all. Because this is exactly what they're trying to do. My lord, in the case of, my lord, 5 companies which has already decided by way of their board of directors, and where, my lord, the APL are, my lord, members of the board. They are filing a civil suit saying that ignore one of the members, and this is, my lord, also the instance of one of the members of the APL. Sharma writes to them saying that, look, decisions have been taken. You are the universal legatee. Decisions have been taken in this company where ultimately you may or may not get any right. And that is why exactly, my lord, the APL is there to control, my lord, and to look after, my lord, the interests of, my lord, the estate. My lord, this lifting the veil, that is, my lord, perhaps, my lord, may not be done, or, my lord, at least the law says, my lord, when, my lord, it's a question of tax evasion, when there's question of, my lord, a fiscal irregularity. That's where, my lord, one would really lift the veil. Otherwise,
or a criminal intent maybe.
Criminal,
Instead of
correct.
PMLA and other.
That's right.
Yeah.
Because otherwise, my lord, if lifting the veil, my lord, was successful to us,
Veil would be of no use. Always lift.
yes. And my lord, not only that, my lord, we would have, because my lord will recall, my lord, in the original litigation, we still, my lord, the estate still claims 62%, my lord, in Birla Corporation Limited. And that was, my lord, the majority of the argument, which is, my lord, the 4th tier or, my lord, 4th tier company.
Yes.
So if all veils were lifted, then, my lord, we would have had, my lord, a control. The APL would have had a control, my lord, straight into Birla Corporation Limited. And that was resisted by saying, sorry, you cannot. So that is why the argument of BCL also, my lord, is the Birla Corporation, my lord, is surprising that it chooses now to come in and take, my lord, sides with regard to universal legatees, my lord, trying to restrict the decision, my lord, in other companies. And to talk about the estate, my lord, they have no business. They themselves say that I am not part of the estate at all. My lord, in Vodafone also, my lord, there is a discussion. If, my lord, just this is, my lord, again, my lord, for really, my lord, I won't say, my lord, relevant academic purpose, my lord, the look through is, my lord, paragraph 83. That's, my lord, lifting the veil, my lord, was also being considered paragraph 83 onwards. And, my lord, will find, my lord, it is really the income tax.
Yes, in a different context.
Yes, yes, in a different context. And now, my lord, kindly come back, my lord, to my lords, the division bench, my lord, which still is, my lord, holding the field, and, my lord, it was quoted, my lord, in the impugned order as well.
What about the SLP against that division bench? Pending. No interim order.
No,
Refused, my lord, interim order specifically refused.
to us or to you?
My lord, to my learned
Them.
And you have not preferred in SLP?
My lord, we have preferred only for a separate part.
I just wanted to know this excitement.
Has to be. There are so many parts.
Clarifying the part which your lordship
That's not a
asked.
crime.
I don't
Till
know.
now, that's not a crime. At least before then, this
That
bench.
matter is-
Definitely.
No, my lord, quite naturally, my lord, people, my lord, will, of
No,
course, my lord,
unless
we agree.
Birla Lodha matter is challenged, the judges
Exactly.
lose status also.
Exactly.
The judges passing the order which is not challenged. Our order is not challenged before the Supreme Court. Anyway.
I just wanted to excitement. No, refuse.
No. But that was below the belt, Mr. Banerjee. You have not preferred any appeal. Let them prefer. You have preferred an appeal. Stay was refused.
Yes, of course.
Let us stick
My
to
lord,
that.
let us also, my lord, go that he has also preferred an appeal. My lord, kindly come to.
Lifting the veil goes, yes. What
Yes,
else?
my lord, kindly come to, my lord, page 3. Oh, sorry. No, আরো আছে 460 আগে একটু দেখাই। My lord, huh? My lord, 213 at page 458. Very important, my lord. 213, my lord. That's finding, my lord, as it stands now, my lord, is very important. Page 458 of, my lord, the paper book.
Yes. Yes, got it. Go on.
The steps taken by the APL.
Give us half a minute.
I'm sorry, my lord.
Please. Page 458.
my lord, this is, my lord, the judgment, my lord, which at present, my lord, holds the field so far as, my lord, the testamentary. This is Kumar. This is, my lord, where, my lord, the division bench, my lord, with regard to my lord,
Discussed in the
yes.
past.
Sorry, my lord,
Yes.
my lord, 213. The steps taken by the APL in registering its nominees as members of the companies where the deceased testatrix held shares in consonance with and in the ratio of the shareholding rights of PDB in each of such companies is perfectly justified in law. So, my lord, my learned friends now are really, my lord, it's a challenge to, my lord, the decisions taken by these directors. The APL through its nominees may very well decide which way the votes of the testatrix shared should go and how they would exercise their voting rights and election of directors. The nominees as such shareholders may participate in shareholders meeting and decision making process of the tier 1 companies and thus mold the course of action and business decisions of such companies. Since the said tier 1 companies also shareholder other companies in secondary and tertiary tiers, the APL through its nominees may also decide how to go about asserting the interest of the estate of PDB in the second and tertiary tier companies through the tier 1 companies action as shareholders of the latter companies.
Mr. Mitra probably insinuated that this is not a business decision as such because the business is investment. You don't require an office and all. That was one of the hints, probably. This is not a business decision as such.
If a set of companies,
you are siphoning the funds of the company, sort of.
All that, my lord, is
no, but that was our
yes. Those allegations have to be made. It's been made. But if a set of companies, my lord, I'm sorry, my lord, may I just siphoning off, my lord, 70 lakhs, my lord, to finance? I don't understand. Birla Building money will go to Birla Building, and we are taking the estate only whatever, my lord, that 4 lakhs a month shared between all these companies. All that method we have to do. Someone has to do. And it's the APL who's citing. That means casting really imputation on the APL. Because APL nominees are there. I don't know what my learned friend is submitting. What is his suggestion? If he's really submitting that, kindly see. Where's the question? I thought it was red herring since wanted ask me that question. Siphoning, is it a credible case to link, to say
you pay 100 times the rent you are paying? Because
we want the space there. We want 1852. And kindly has seen the uncertainty. Why did Birla Corporation Limited not respond from 30 May? First letter was 15 March 2024. Till Mr. Mitra submitted and suggested in the course of hearing in rejoinder. And not, that's why, not one whisper, in the plaint.
Yes.
He has, his case is not that you have space available in Birla Corporation Limited is offered or they are willing to offer you, why haven't you taken at a lesser rate? It's only in rejoinder, this submission was made, orally. To say that, oh, Birla, why don't
now they have put in a supplementary affidavit.
No. If today, I only look at it this way.
Commercially, it's not viable, let's say.
If commercially, these companies think, I think, let's dealing, with the greatest respect, this siphoning of, I find it, quite, if I may, I don't want to use the word ridiculous, but, quite tenuous, to make that submission. That monthly rent of 4,59,000 shared between the 5 companies is now the greatest way how the APL will be involved to siphon of money to build a building. I'm so sorry, I find it extremely tenuous. If not ridiculous. Because that's the rent. So the gist of the matter is today these 5 companies have thought we want some additional space. We are looking for additional space. There's space on the 7th floor. We are going to get it. At according to them, the market rate. Why should the give more?
The question remains how far we can go into that commercial
Absolutely.
decision,
Absolutely.
commercial prudence of the.
My submission would be, my lord, not at all. My lord, the court really shouldn't, because that will, my lord, be micromanaging, my lord, as to, my lord, the decision of the board.
Yes.
To say, no, now you get 3 rupees less. Sorry, the court, now civil court, we are saying, no, you go for 3 rupees less.
Yes.
And though you may not like or like Builder Corporation, and because Builder Corporation now come up, I shall force you really to go to your ex or to your landlord.
Ex-landlord.
Ex-landlord.
Yes.
But till landlord, my lord, because, well,
Just
still
ex.
not renewed the lease.
Right.
So therefore, my lord, Builder Corporation also cannot come and say, no, I'm insisting now
Yes.
that the court, you direct them to accept this. Because what they in fact, my lord, are doing, my lord, we have a space, my lord, I've also, my lord, space this side. My lord, there's Builder Corporation office there, and they're giving us space, my lord, on the other side now, which, my lord, is not convenient. But I'm not again going into it, because then, my lord, it will be again micromanaging whether, my lord, that's right.
Yes.
That is why, my lord, I stayed away from whether, my lord, it's a better off deal, whether, my lord, it's a not a better deal, whether the space which is being given is the right space or it is in one corner. Because that will really open up, my lord, into a question of, my lord, the board's directors, the decision, my lord, being examined. And, my lord, another question, my lord, if the rate is really, my lord, the market rate which we have got, why is Builder Corporation Limited giving it lesser price? Why is, my lord, favors being done, my lord, to the universal legatees at the instance of universal legatees? All these questions will come up. Same, my lord, if the same logic, my lord, what is, my lord? If they say, my lord, we are paying higher rent, lesser rent will also hurt the estate. But I don't want to go into all these arguments.
The Builder Corporation Limited is not a part of the estate.
We say, my lord, it's part of the estate, 62% shareholding.
That has been turned down by the division bench.
Correct. Correct. But, my lord, if it succeeds, APL will have control. My lord, my endeavor is to show, my lord, all that is really, my lord, not relevant. The aspect which they try to bring in, saying, oh, it's siphoning off, you're trying to now benefit a builder company. I do not understand. This is, my lord, a commercial decision, my lord, which has been taken by the board. At that time, Builder Corporation never came around to say, no, sorry, we are really very sorry. We did not renew lease for the last 7 months. We are putting pressure on you. Now we are so happy that we will give it to you at half the price.
Maybe Builder Corporation is now managed primarily by the.
It is.
There's obviously, and
quite
that is
obviously,
by the
that we all know.
But we cannot go into that probe.
Correct. And that is why I'm saying, my lord, this offer, counter offer is my lord, really legally, my lord, not sustainable. And this siphoning of, my lord, I've not understood. 4.59 per month shared, my lord, goes into. Therefore, you will have to finance this. Litigation is, my lord, really, my lord, according to me, my lord, too much, my lord, really, my lord, too. And not there, my lord, it's there, my lord, any particulars given that this is how, by paying rent, money, my lord, will be used. Now, my lord, coming back just to this judgment, my lord, of the division bench, 213 I've shown, then, my lord, kindly sees how, my lord, is also directed how the APL will function. At 217, paragraph 217, page 460. Issue 3.2. And this was, my lord, only issue, my lord, I had argued, so I was very happy. I took full credit, my lord, for whatever, my lord, we.
Yes.
The very composition of the APL brews conflict of interest. Since 2 of the members represent 2 warring factions and have left no stone unturned to show their true colors in that regard. Thus, in view of the discussion above, the only way which APL can function effectively is for the 3rd member, who is necessarily a retired nominated judge, to act as arbiter in case of conflict of decision between the other 2 members of the APL. In case there is no resolution, the 3rd member shall exercise veto power. In case of major decisions, which decision major for this purpose shall be decided by the 3rd member, APL may seek appropriate orders from the testamentary court. In case of major, which decisions are major for the shall be decided by the 3rd member. That, my lord, discretion and jurisdiction also, my lord, is given, my lord, to the 3rd member. So APL may seek appropriate orders from the trust. APL must also keep in mind not an adjudicatory but merely representative estate of the deceased. Thus, the order of the learned singer modified to above and liberty is given to the APL and the parties to approach the testamentary court, taking up the letter of admission if need be and when there are serious doubts. My lord, I have now two submissions on this. First of all, my lord, if it's a APL grievance. Now, I am not saying that this matter should go to the testamentary court, because as soon as I make that submission, they'll say, please record that and send us to the testament. I'm saying you have no cause of action. But in the event you have a grievance against the APL, you will have to go to the testamentary court. And if, I'm sorry, my lord, this must be I'm repeating it, my lord, if the universal legatees through the APL, because that's what, my lord, their representative have, my lord, any grievance, then that grievance will have to go, my lord, to the APL. To the testamentary court. If the APL is not.
These universal legatees are otherwise parties to the letters of
Yes, Malad, they are the ones, Malad. Mr. Lodha, Malad, Harshvardhan Lodha.
Lodha group.
Yes. Malad, after Mr. R.S. Lodha passed away, Malad, because
all of them.
So they're all parties to that proceeding. And they also contested, Malad will recall, Malad, it's contested by everyone.
Yes.
And their contest was also that you cannot interfere with the affairs of the company at all. Because Mr. Lodha, of course, Malad, controls Malad Birla Corporation Limited. So that's quite naturally, Malad, that the prayer. And Malad, we had also, Malad, I don't want to again, Malad, because Malad, perhaps, Malad, it is not relevant so far as this matter is concerned. So, Malad, I, Malad, conclude, Malad, by submitting that in both instances, either, Malad, by way of a share, by way of, Malad, a civil court, and as a not a shareholder, you don't have a right. And if you're coming in as a universal legatee and your complaint is with regard to the running of the estate or anything to do with the estate, it has to necessarily go, Malad, before, Malad, the testamentary court. Malad, I think, Malad, those are my submissions, Malad. And Malad, the learned judge, Malad, has directed, if Malad looks at, I'm sorry, Malad, just one thing, Malad, in the impugned order, it's an ad interim order which was, Malad, turned down. So, Malad, if it is at all, Malad, held that, Malad, we were in the wrong, Malad, the decision will be set aside. Malad looks at, Malad, after recording submission, Malad, from paragraph 21, Malad, really, Malad, the findings are there. Malad has already, Malad, noticed. Then 25, the companies have taken a decision for additional space as per the requirement. Because any, Malad, interdiction, Malad, or, Malad, any injunction on this, Malad, will mean that, Malad, that is being doubted. Neither the plaintiff nor defendant 14 can raise any objection for additional space. In the meeting, minutes of meeting dated 31st August, category mentioned, rate being charged is in line with the rental for commercial office and central business of Kolkata. And the rents will be shared by 5 companies as per ratio mentioned in the minutes dated 31st August. Then shares held by estate of Sansa, late Priyanka Devi Birla, are already available in the affidavit assets estimated suit. Plaintiffs cannot restrain the companies from their day-to-day business. This seems to be, Malad, really, Malad, the ratio on which, Malad, the learned singular refused, Malad, the ad interim order. Plaintiffs claim that they're the universal legatee. Plaintiffs find any misappropriation of funds. This, Malad, I find extremely tenuous. This is, Malad, would be used as a way.
Yes.
And, Malad, to say, oh, 1,000 times rent, 100 times rent. Any misappropriation of funds or alienation of the estate deceased, plaintiffs can bring the same to notice of the testamentary court. Plaintiffs cannot ask for any injunction against the companies for their day-to-day affairs. And then, Malad, kindly look at 728. Though the defendants have raised several contentions with regard to the maintainability of the suit filed by the plaintiffs, Malad, which we had raised, because we say, Malad, there has no locus. But this court has a view that the question of maintenance can be decided only after filing of affidavits. The defendant companies are in need of additional space, and the proposal for additional space discussed in the board meeting, majority members of the board have approved the proposal except defendant number 7. Considering the above, this court finds the plaintiffs have not made out any prima facie case and balance of convenience and inconvenience in favor of the plaintiffs, and thus interim prayer is refused. Defendant directed to file affidavit. Malad comes up, Malad, on the 4th of December. And Malad, just Malad, in one of the decisions, Malad, which went up, Malad, sham sell and par, my lord, though we had got it, but my lord, I'm just putting the proposition, my lord. It says, my lord, if it's an ad interim order, if my lord, the learned judges exercise the discretion, my lord, the division bench, my lord, will really, my lord, be slow, my lord, to well, I don't think, my lord, I think, my lord, submission, my lord, enough not to, my lord, say. My lord, those are my submissions. My lord, I'm extremely grateful, my lord.
Yes.
My lord, may I have my lord's leave, my lord?
Yes. By the clock, 30 minutes you took. You said 2
My lord,
minutes.
because my lord, it would have finished in 2 minutes. My lord, if my lord, I had stayed back at 1:15, my lord. Now, my lord, now, my lord, since I had to come back, my lord, and miss, my lord, others, I thought might as well, my lord, finish my submission, my lord.
No, the other matter
All, my lord, gone now.
gone now. Which no. You must have some matter somewhere in the High Court throughout the day.
That is, my lord, different.
Oh, yes. Yes.
Tribunal, my lord, difficult to go.
There are half a dozen
Tribunal
people
difficult to
waiting
go.
to pounce on him and take him away.
Yes.
My lord, I think Mr. Thakkar is also there, my lord, after he.
Oh, achha, you're for a different set.
A different company, my lord.
Abhi theek hi bolche.
For a different company. Lordships have.
Please conclude by today so that we can
Yes,
pass
I will
out.
not take my. I'll take 2 minutes, my lord. Your lordship, this is an appeal.
But Mr.
as-
Banerjee, before leaving, sorry,
I'm so sorry.
Mr. Thakkar and Mr. Banerjee, we cannot pass our order today because you have cited that we can pass our order only on the next day when we are sitting in this bench, that is next Wednesday. Till that date, we'll be requesting you not to effect any transfer. Because it will render.
Then, my lord, kindly do not pass any order.
That is what
Very
why
good.
we are.
We will, my lord, instruct, my lord, our board, my lord, not to enter, my lord, into,
Please
my
do
lord,
that.
till, my
Please
lord,
do that.
my lord decides on
Please
it.
do
Very
that because we won't pass any interim order that
Very
will be
very good.
prejudicing probably.
Very good. I'm great. Who's that instructing advocate Pulala?
Next Wednesday we'll be passing
Yes,
on
yes, well,
positively.
we'll
Yes.
I'm grateful.
I appear for the defendant number 9, which is Gwalior Webbing.
Right.
Very brief, my lord. This is an appeal, as Mr. Banerjee indicated in his closing submissions. Appeal from an ad interim order.
9 is one of the so-called
So-called
first
proposed.
year.
No, my lord, I'm not aware. First, I'll put it as this, my lord. I don't want to give it the flavor of Birla.
What is the name of the company?
Gwalior Webbing.
All
It
right.
is an investment company.
Yes.
It is one of the companies which intends to take on lease the premise.
Yes.
Now, my lord, this appeal has been heard at length, my lord. Appeal from an ad interim order. Your lordships have taught us that unless the order is shown to be patently perverse, this is an exercise in discretion. Unless the order is shown to be patently perverse, the appeal court usually does not interfere. So that is the high test, my lord, but the appeal has been heard at length. Your lordships have been very patient. Now, my lord, I will only want to show one or two paragraphs from the division bench order of 2023 and an earlier judgment by which the administrator pendentilite were constituted.
Yes.
To show what was the scope of the authority of the administrators and to demolish this argument, the lordship has seen that to give this a testamentary flavor. There is no flavor, testamentary or corporate. And that is all that I want to show your lordship, and I'll be very brief. Well, the section which has been relied upon, 104, kindly have 104 of the Succession Act, please, my lord.
আচ্ছা বই এখানে আছে।
This is the only provision of the Succession Act which has been pressed into service to show that the plaintiffs have a right to sue. May I hand over? My lord, I have. Lord, first and foremost, the plaintiff appellants have to establish before your lordships that they have a right to sue in present time.
Yes.
They have a right to sue. That is the first test. Now, my lord, to make out that case, the argument is that I am a universal legatee. And by reason of that, and by reason of 104 of the Succession Act, I am entitled to maintain a suit. Now, 104 reads, my lord, if a legacy is given in general terms without specifying the time when it is to be paid, the legatee has a vested interest in it from the day of the death of the testator, and if he dies without having received it, it shall pass to his representatives. This section nowhere provides, my lord, that the legatee is the legal representative of the testator.
Yes.
That is specifically provided for in section 211. The executor or the administrator appointed by court is the legal representative. What this section merely provides is the right of enjoyment of the property from the date of death, not the legal character. Kindly see 211, please, my lord.
Yes.
The executor or administrator, as the case may be, of a deceased person is his legal representative for all purposes.
211 read with 213 probably.
211 read with 213, but 211 is not sufficient for our present purposes. Legal representative for all purposes, and all the property of the deceased person vests in him as such. He is the legal representative, only the right of enjoyment. And this, my lord, read with, kindly see 236, please, my lord. This is just relation back, nothing else. It's like plain amended will relate back to the date of institution. Kindly come to 236, please, my lord. I'm sorry, not 236, 336, please. 336, please, my lord. So 104 has to be read with 336.
Yes.
The assent of the executor or administrator to a legacy gives effect to it from the date of death. 104 read with 336, assent given relates back to date of death. So there is, the estate is after demise, legal representative executor, after probate, executor gives assent to legacy, relates back to the date of demise. So the estate is not in limbo, so to say. The succession is a complete chain, there is no vacuum. So for the present proceedings, my respectful submission is they have no legal right to sue, because it is the administrator appointed by court under section 247. Now, if your lordship sees 247 once, please, my lord, the appointment of administrator pendentility.
Yes.
Pending any suit touching the validity of the will of a deceased person, or for obtaining or revoking any probate or any grant of letters of administration, the court may appoint an administrator of the estate for such persons, who shall have all the rights and powers of a general administrator, other than the right of distributing such estate, and every such administrator shall be subject to the immediate control of the court and shall act under its direction. So the administrator pendentility by statute is the legal representative of the estate of the deceased, not the universal legatee. The universal legatee only has a right of enjoyment till such time as the probate is granted and the assent to legatee is given. Nothing more, nothing less. Now this, my lord, is reinforced by the earlier division bench decision of our court, if your lordship kindly has, the decision of 23rd August 2012, which starts at page 88, please, my lord.
Yes.
23rd August 2012. Kindly come to page 118, please, my lord. I'm not troubling lordship with the arguments. Kindly have the ratio. 118, please.
Yes.
We have heard the learned counsel for parties at length. The third paragraph on that page, the penultimate paragraph. We have heard the learned counsel for parties at length and considered the authorities cited. The jurisdiction to appoint and grant administration to APL vests in the court of probate and no other court where the necessity for the grant is made out. The position of an APL is similar to that of a receiver, with this distinction that the APL represents the estate for all purposes, except distribution, whereas the receiver does not represent the estate nor the parties, but simply holds the estate for the benefit of the successful litigant. So here the argument was that APL is a receiver. The Honorable Division Bench negated.
The plaintiff wants a receiver now.
Plaintiff wants a receiver. And the estate represents the estate for all purposes. Yes. So anything, any harm caused to the estate, any benefit to the estate, the action is to be carried out by the administrator pendentility. Then if your lordship kindly sees 119, considering the fact, the last paragraph, considering the fact that the joint administrators appointed by this court will be required to administer property of the deceased, including the shareholding and stocks held by the deceased in various companies, with the assured objects of its protection and preservation, it cannot be said that the joint administrators would be mere spectators if they are expected, and are permitted to collect dividends accruing out of these stocks and shares, there is no reason why they should not be eligible and entitled to other privileges incidental to the ownership of such shares and stocks according to the exigencies found to exist as representative, your lordship kindly sees, representative of the beneficiaries. So the administrator is now the representative of the so-called universal legatee. Till the matter is finally decided by the court and in their capacity as APL, nothing prevents them to exercise all the rights, powers, and privileges incidental to the ownership of the shares and stocks, except that of distributing such estate to the legatees, beneficiaries, which is required to be finally determined by the court. Therefore, even though they are appointed by the court as APL, nothing prevents them in their capacity as representatives of the beneficiaries.
No, but the beneficiaries may have a grievance against the APL,
Correct.
but
Now-
then they have to go to the testament.
That is what this court, that is exactly what this judgment says.
That is the law.
That's the law. So, my lord,
If it's against
A-
the APL,
yes.
yes, APL, then it has to be before the.
So, my lord, no case here is made out of there any grievance against the APL. Kindly see the cause of action of the APL. Against the APL, if any case is made out, and if at all any relief can be granted by the civil court.
No, the principle of ubijus ibi remedium comes,
Yes.
may be argued here, Mr. Thakkar, because the division bench has said that if the probate court cannot pass any orders against third parties.
And
Companies are third parties.
yes.
On the other hand, the APL, if they have a grievance against the APL, I mean,
Yes.
this is the APL has bypassed that by taking a shortcut, by not taking a decision formally, but directly operating as the directors and recording a resolution. So no decision was taken. If the APL decides to do that directly without taking a resolution, bypassing their role as an APL,
Yes.
then what can they do? Because they can't go to the testamentary court because there is no formal decision of the APL. They cannot challenge that. The damage has already been done according to them, so-called damage. So they can't go to the testamentary court, nor can they go to the to any other court. Then what can they do? So that's why they've come before the civil court, because they are not members of the company. So they don't have a right under 241 or 242 or
Yes.
whatever.
Now,
That is what is the underlying theme of their argument probably for coming to the civil court. Although that may not itself ipso facto justify, there is an answer to that also.
Well,
Let us hear your answer to
yes.
that.
Now, my lord, this order which I was placing, with this judgment which I was placing, if your lordship, my lord, provides that, if your lordship kindly turns to 120, can you please turn to 120 of this judgment, my lord?
120, yes.
We do not want to discuss the last but one paragraph.
Yes.
We do not want to discuss the various facets of such exercise of rights of ownership of shares by the joint administrators, as we think it better to leave it to their best discretion and wisdom and according to the exigency found here. In such an event, it would be always open to the parties, if they are aggrieved, to approach the probate court, which has appointed a committee of 3 persons as joint administrators, who are subject to the immediate control of the court and shall act under its directions. We have to accept such exigencies of such rights and powers in APL, and the court which appoints APL has every right to give directions to the joint administrator regarding the property as a mode of equitable relief. So, these are the widest.
Right.
Whether there's a decision, where there's no decision, APL is not acting. Now, what they claim, what is their case at the highest? The APL, there's an act of omission on the part of the APL. They ought to have
any functioning of the APL. If they have a grievance, they can go to the testamentary.
So this, whether the decision has been taken or not taken, they've omitted to take a decision. They've acted contrary to the interests of the beneficiaries, acted contrary to the interests of the estate. It's the testamentary court which exercises absolute control.
But
And
then
this
the
al-
testamentary court, according to the division bench, cannot pass any order against the third parties.
No, Malan. So the order,
So the resolution remains.
no, Malan, the
damage has been done means that the APL has functioned as directors and taken an action.
So, my lord, here, if the APL in its capacity as director, the APL in its capacity as not as director, but if the APL in its capacity as representative of the estate has permitted a resolution to go through, the APL will be directed to reverse the resolution. They are the representative of the estate. And
It's the board resolution of independent companies.
No,
the testamentary
no,
court.
my lord, not as
Now it's a board resolution.
now it's a board resolution of the companies.
Precisely what is hitting.
Now it's a so, my lord, the APL represents, according to them, APL
What
represents.
remedy can they get before the testamentary court in this for this cause of action? Tell us that.
Mala, they would have a right to have directions given to the APL to exercise their majority voting power to undo the decision which has been taken. The APL will act as the representative of the estate. The testamentary court cannot give directions on the functioning of the companies, is what your Lordship's division bench has held by the 23 order judgment. Now, how the APL is to act for the protection of the estate, that direction can obviously be given. If the testamentary court of the court would be satisfied that the decision which has been taken is not in the interest of the beneficiaries. Your Lordship kindly takes the division bench order of 20 of December once, please. My lord, 2 paragraphs. My learned senior pointed out from paragraph 213 onwards. If your Lordship would kindly have paragraph 211 and 12 once, please, my lord. 213 onwards or placed before your Lordship.
What was the page number, Mr. Red?
Page 458. (457), if your Lordship kindly starts.
Yes.
Issue 3.1 is discussed. Now, if your Lordship kindly comes to 211, we are required to distinguish here between the rights directly flowing from and incidental to such ownership of shares and those which are remotely derivative from such ownership and not proximate. The former are subject matters of the estate and the APL can exercise those, but the latter, that is the remotely derivative rights, cannot be thrust by the testamentary court or the APL on the respective companies which are independent juristic entities. We are not deciding any illegality or irregularity of the said company's affairs. Thus, the concept of lifting the corporate wheel does not arise. The rights of the testatrix over the companies of the different tiers were coextensive with the rights as owners of the shares of the tier 1 companies and incidentally with the rights of those companies as shareholders of the other companies. The APL cannot interfere with all internal affairs of the companies of all the tiers with the blessings of the testatrix.
These are not German for this matter, Mr. Tucker, because the APL treated those companies to be companies where they have control and they have been appointed as directors.
Yes.
So there's no
So,
comms on these.
So, my lord, your lordships have held that
Yes.
if what the APLs cannot do now, that is interfere with the internal affairs of the company. This is what, my lord.
On the basis of remotely derivative rights.
Yes. What the APLs cannot do, that is interfere with the internal affairs of
They
the
have done it because in this case they have been acting as directors and they have taken a board resolution.
So, my lord,
they are taking decisions on the internal affairs,
So-
but they have a right to do because this is not remotely derivative.
this is not
This is direct.
This is
That's why we said these paragraphs are not German.
no.
for
So
it.
why I'm
They already acted on that premise.
So, my lord, all that I'm trying to show from these paragraphs is this, my lord. What the APLs cannot do,
Yes.
the rights which your lordships have not given the APL. This
So the
is
APL has done in this case.
no. APL has done.
APL has appointed nominees as directors.
Correct.
Themselves nominees.
So, my lord, that is rights flowing from the share as the rights of the ownership of the shares.
You are saying what the APLs cannot do, the court, the civil
What-
court can't do.
No, what the APLs cannot do, a person who's one rung away from the APL, who does not even have the representative right which
Why
the
to say the APL can't do because
No,
the
no.
APL has done.
so, my lord, that the APL
Has
Kindly-
this is internal affairs of the company.
kindly bear with me, my lord. What the APL has done is exercised the rights of a shareholder to appoint a board of directors.
True.
What the directors have done is taken this resolution. Kindly bear in mind the difference between the two entities. One is the rights which the APL exercises as a shareholder and constitutes a board of directors. Now the decision is taken not by the APL but by the board of directors of the company, and they are the only decision-making authority in the company.
But they remain APL members all the same. They are components of the APL. also.
The board is not constituted only of the APL. The board has several other members also who are the
In your company, APL is the majority. The number
APL
of
may be
directors-
majority, but if your lordship sees the cost title, the
3
individual
versus 2. In your
Indivi-
company and Mr. Banerjee's company.
individual
One of the Mr. Banerjee's company.
well, that is the matter of constitution. But if your lordship sees the cost title of this proceeding, all the individuals
You
there.
cannot disown your APL hood
No, my lord.
merely because you are directors.
No, I do not disown my APL role. I am not the APL for the first. I do not disown. All that I say is this is a decision by the majority of the board, in which one of the APLs is also a member. Mr. Sharma is also a member in the board of
Maybe.
these companies.
Yes.
So, my lord, this is an
No,
exercise.
other directors have also.
Other directors have
agreed.
also participated.
Yes, right.
There, so, my lord, this is the decision making is being done by a democratic
All right.
process of the board of members. Now, if that internal affairs of the company, your lordships have said the APLs are not entitled to interfere. That is a decision-making process of how the company is to function. The APLs are not allowed to interfere in the day-to-day management. In that case, Malad, the question which I ask myself is, can somebody who does not even have the legal character of an APL call into question those very decisions? With somebody who has a superior representative interest, both by statute and by the orders of this court, has been declined. So these litigants or these plaintiffs are one rung lower than the APL.
Yes.
What the APLs cannot do, perhaps, these litigants cannot do, and they do not. This is what APLs cannot do, Malad, is your lordships have held this.
All right. All right.
Now, Malad, one more interesting fact is this, Malad. Since the APL has come forward to make submissions, the decision to take additional space was not taken at the board meeting of 23rd October. The decision to take additional space was adopted on 31st August. Kindly have, Malad, the minutes of the meeting of 31st August, which is referred to. August, the decision to adopt additional space is taken. Neither Birla Corporation comes forward, nor Mr. M.K. Sharma says that please approach Birla Corporation.
That was a board resolution.
Yes, that was a board resolution. And then, Malad, places were identified over a period of time from 31st August till October. Birla Corporation nowhere in the picture. Mr. Sharma nowhere in the picture bringing alternate
So
accommodation.
Sharma must have been a party to that.
Yes,
31st
very
also.
much. এই দাও ভলিও ওয়েবিংটা দাও ভলিও ওয়েবিং আমাকে দাও
Record probably.
Well, it has been referred to in the learned single judge's order 31st August.
Oh, acha.
ভলিও ওয়েবিং আমাকে একটা দাও দিয়ে দিয়েছি আপনাকে Now, my lord, kindly come to 14, please, my lord. Status of the company's office space at Birla Building, last but one page.
Yes.
Status of the company's office space at Birla Building. Kindly permit me to place this, my lord, because a lot of this. Board was informed that Birla Corporation Limited is the owner of the office space at Birla Building, 4th floor. Company occupies part of the office space with all its fitting and furniture against payment of rent to BCL. Arrangement has been continuing since 73. Terms of the said arrangement, a company has been possession of and continues to occupy. This arrangement was recorded formally in a tenancy agreement dated so-and-so 2019, which has been drawn up by the parties whereby and whereunder company has been occupying said space. Then kindly see the next paragraph. The said agreement was entered for a period of 5 years from April 1, 2019 to 31st March 2024 at an annual rent of 16,500, which is to be paid at the beginning of financial year latest by so-and-so. It is also stated that the terms of the tenancy include the period of tenancy. Before the tenure, now this is very important, before the tenure of the formal tenancy agreement was to expire on 31st March, the company had made a request in writing calling upon BCL to renew the tenancy agreement. However, despite receipt of the said letter seeking renewal of such agreement, BCL has not given any reply till date. Along with the said letter of request for renewing the tenancy agreement which was issued, the company had also made over checks of any. However, till date, BCL has not encashed the said check nor replied to our request. Since the company neither received any communication from BCL nor the check was encashed, company by way of NEFT has transferred the entire rental amount to BCL. After having transferred such amount by way of a communication, we had also intimated BCL. Till date, BCL has not reverted with such communication and the situation continues. Now, the landlord is very actively offering space. Now, it was informed, now kindly see, it was informed that the staff members of the investment companies, trusts and societies having their offices in the said space are being subject to various types of intimidation and threats on daily basis. Private security guards are being placed at the entry point by BCL. It was also informed that the entry and exit is also controlled by BCL because the keys to the entry gate are in the possession of BCL. Recently, they have also installed CCTV cameras inside the area which is occupied by our company and monitoring our movements. The management sought advice and guidance of the board to protect the rights of the company. One of the suggestions of the management was to file suit for declaration of the company as rightful tenant of the above mentioned space. The board noted that it is a common past practice to let out properties belonging to one entity of the group to other entities at a very nominal rent. For instance, a huge property of one of the investment companies at New Delhi is let out to one of the listed companies of the group at a nominal rent of 10,000. The chairman and some of the members expressed deep concern regarding the present position. Now kindly see, Shri M.K. Sharma advised that status quo be maintained since nobody is seeking to throw us out. He was very much present. After discussion, it was decided by a majority that further legal advice be sought to protect the interest of the company and, if required, appropriate legal proceedings be initiated. Now kindly see, my lord, it was also decided that keeping in mind the growing need for additional office space, the management may also identify and finalize additional suitable space for the office need of the company on rental basis. 31st August. Suit is no steps taken. Mr. M.K. Sharma is their nominee. The cause of action is on the basis of the letter written by Mr. M.K. Sharma to the other members on 23rd August. But from 31st August, when this resolution is adopted, no steps taken by the beneficiaries. And on the last day of the vacation, they come with a 7-volume paper book and seek an ex parte ad interim order. 15th October notice clearly said that now, since we've identified a space, now we need to. So this is, my lord, the conduct of the plaintiffs and their supporting respondents. Those are that's
Minute, I am appearing for the respondent number 11 and 12, Millet.
He's just left out one sentence. Thereafter, he paid by NEFT in May.
read that.
It has been not.
I read that.
Rent has been paid. Rent
It has been?
Rent was paid by him in the month of May and accepted for full 1 year. It
That was probably
continues till-
stated in their plaint also.
It's written in the resolution.
Correct.
My lord,
correct.
that's
So,
in the resolution.
my
They
learned
did
friend
not
made it
encash.
Plaint also you have,
Yes.
it has been stated.
My lord, in
my
the
learned friend, but
I-
on the
I-
basis that a check was sent and not encashed. I'm saying
my
he
learned
paid by
senior friend
NEFT.
did not
NEFT.
hear me when I
That's
placed the resolution in the discussion. The check was sent not in cash, money sent by
Millet.
letter sent.
Yes.
Still
Millet,
no.
two things, Millet. I'll be very short. I adapt Mr. Banerjee and Mr. Thakkar, but Millet, two things I need to point out, Millet. Millet, I am representing the respondent number 11 and 12. Now, if your lordships would kindly come to page 12 of the petition, Millet, your lordship will find that in respondent number 11, admitted position is the late PDB did not hold any shares. And Millet, at paragraph 14, your lordship will find that the estate of PDB in that Punjab Produce Holdings Limited is restricted to 0.08%
Yes.
of shareholding. Now, Millet, just before I started submission, Millet, Mr. Thakkar, Millet has pointed out paragraphs 211 and 12, if your lordship has seen those. Now, Millet, only one thing I would like to point out from there, and also it is the plaint case, Millet, that the rights which these legatees are trying to enforce are restricted to the shares of late PDB. That is the plaint case which has been running here. So today, Millet, when it comes to the shares, Millet, because your lordship was of the view that the APL has already formed the board. That is not the case, Millet. The APL and not all the APL members, a few of the APL members have been inducted in the board on the basis of, Millet, the shareholding or the cross-holding, which would have allowed late PDB to exercise in that fashion. But, Millet, there is no complete control on, Millet, the board. The board is to function on its own. But that protection has been given to all these companies. But your lordship has seen in paragraphs 212 to 214 of the December 2023 judgment. Now, other than that, the single judge has also quoted paragraph 217 and 218 in his judgment, where the single judge's order was modified by the division bench, allowing the parties to approach the testamentary court, taking up the letters of admission if need be and when there are serious doubts. Today, the plaintiffs are before your lordships, they have identifying themselves as the universal legatees. They are making out a case that one of the APL member did not accept or did not support this resolution. So, there is a dispute at the maximum with the plaint case is running, that there is a dispute between the APL members. Now, your lordship, I don't know whether that has been placed because I joined a bit late, your lordship would be aware that there is already a special leave petition which is filed by these legatees because, my lord, the division bench of December 2023 did not say that it needs to be an unanimous decision, but a majority decision of the APL. Now that is still pending. Today, my lord, the APL, whether they had taken a decision, the APL or the board of directors, is very important to be seen here. I am a company, my lord, where there is no direct control. Both the companies. I am functioning through an independent board. My rights are flowing from the Companies Act 179. My lord, I know your lordship's view on 430, my lord, I've understood. But my lord, I would like to point out a small thing, my lord.
What is
If
our view on
something-
430? What is our view on 430?
Well, no, your lordship said that since they are not members, 430 may not be applicable. I'm trying to
430 is not.
counter.
Oh, acha. No. That was the argument of Mr. Mitro, in a sense.
But I'm trying to
Anyway,
counter that.
whatever. Yes.
I'm
What
just
is your
trying to
answer to
counter
that?
that because I'm taking the point of 430. I'll point out why, your lordship. My lord, what cannot be given directly cannot be done indirectly.
Hmm.
Today, my lord, let us just forget about the Birla matter. What is the suit for? The suit is a shareholder or a prospective shareholder, may I put it this way, of a company challenging the decision of the company to take additional space on rent. So, my lord, this has always been a settled proposition, my lord. After Adi Gazdat to my lord, Inox, everything. Shareholders' rights are separate from the company's rights. If this shareholder, my lord, had the right to overcome such resolution, then he would have had the right. But he doesn't on the face of it.
They are not shareholders.
My lord, that is what I'm trying to say, my lord. If they are not shareholders, my lord, they are coming in as universal legatees on the basis of shares of late PDB. So what do they say? As legatees, they would get these shares. Even, my lord, the rights of PDB flows from shares. Let us say
Yes.
PDB was alive. Let us say PDB was alive.
Right.
Could she take a decision of opposing this resolution? That is what the APL is also doing.
Yes.
So today, my lord, it is basically an action by a shareholder maximum. I'll take the non-shareholder later, my lord. Of a shareholder challenging a resolution of a board of directors under section 179. And then, my lord, may I just put it this way? If the Companies Act do not safeguard the interest of a non-member vis-a-vis the business of a company, my lord, then, my lord, a non-member has no right in the running of a company.
That is what was the statement of the court, to which Mr. Mitra answered to the contrary.
But now, may I? My lord,
Yes.
that is why also, my lord, I will come to the maintainability, my lord. Your lordship will kindly see 430. Section 430.
We have seen 430, Mr. Rai.
My
What is
lord,
your answer?
therefore, my lord, the second limb of section 430,
Yes.
I think, understood that there could be some mischief, my lord, prevents any injunction from being granted with regard to any of the actions taken under this act, be a member or a non-member.
True.
My lord, I am fortified by your lordship's judgment where this reads perimetry of the section 34 of the Surface Act. My lord, in Asha Agarwal, your lordship has held this also.
Single
That
bench.
injunction cannot be granted. I'll just ask my...
Single bench.
No, division bench.
Oh.
Division bench, my lord.
Yes, then
But
I have.
section 34 of no civil code in Surface Act and the language here is perimetry. Your lordship has held, even if a suit is maintainable, injunction cannot be granted with regard to any action taken under this act.
Provided
my
it's
junior-
covered, provided it's covered by the said statute.
Now,
And
my
if-
lord, I'm coming to that. My lord,
If
an act,
the authority has the power to grant that relief, then definitely civil court can't.
yes, obviously.
Their tribunal has the power, so
No,
civil
my
court
lord. My lord, with humility, my lord, I
Yes.
humbly say, my lord,
can't.
this takes into contention, my lord, but what kind of cases can injunction be passed? This is what I'm trying to join with my learned friend on the other side. Can a non-member, leave aside, my lord, PDB and Birla, my lord, can a non-member challenge an action of a board of a company? That is the question.
Hmm.
And if he says he's a member, he'll have to go to NCLT. If he
Then,
doesn't have
yes.
the shareholding, that is his bad luck. That is what, because earlier we used to do, my lord, your lordship, my lord, class actions, we used to do referential capacity, but that is now over.
So
After the
therefore, you say
amendment in 2013.
since the Companies Act specifically precludes non-members from challenging, therefore they don't, that right cannot be carved out by
No,
coming
that cannot be
before
carved out.
Very well.
My lord, because, my lord, with humility, my lord, the company is running on the basis of the shareholding and
Yes.
the shareholders having appointed the management. Now, if there's a person who's not a part of that shareholding,
But
then
that cannot
how
be an
can that
absolute,
person?
that cannot be an absolute proposition, Mr. Rai, because suppose an individual, a third party who has no nexus with the company,
My lord,
has a cause of action against the company itself
but I do not say
as
that,
a
my lord.
juristic entity, then also civil court can't pass
No, no,
injunction.
no, no, no. Their civil court will have.
Then that cannot be an absolute
My lord,
proposition.
no, my lord, what
Any
my
such a-
proposition, absolute proposition is in respect of any action under this act.
Mr. Rai, if you have a company and your company, the board of directors of your company takes a decision that they would sell off my property. I am the owner of a property. Suppose that palpable wrong is done, then I can definitely approach a civil court and get an
Yes,
injunction
my
against
lord, your
the
lordship
company
will
and
approach
and upset
in
the board of
injunction suit.
obtain an injunction regarding the board of directors.
Yes, but that is an
resolution also.
injunction suit which does not, my lord. My lord, your lordship kindly appreciates.
I can seek a declaration also. I am the owner and injunction. So that
Yes,
cannot
my
be an
lord, that is
absolute
what your lordship will
proposition
seek.
because
But that
there is
does not.
yes,
That
complete.
is what your lordship will seek, but that will not be an action which challenges the vis-a-vis management of the company. I am as a whole challenging, my lord, there the action of the company,
All
not
right.
the management.
All right.
That is why I say, my lord, absolutely, it cannot be a proposition that third parties cannot go against company. I'm not saying that, my lord. I am saying any rights emanating to a shareholder or on the basis of shares, where there's an action by the board of management under the act, my lord, there, my lord, you cannot approve.
Right. Right.
That is what I say, my lord.
Very
And my lord, the last thing, my lord, your lordship has seen, my lord, Mr. Thakkar has also shown, my lord. My lord, kindly sees the petition only once, the prayers.
Yes.
Other than being injunction, my lord, there's a prayer for receiver.
Yes, receiver. Saw that.
With regard to, my lord, taking control of documents.
Yes. That is the
Of the
first prayer in
company.
the application. That is
In
the
the
first prayer in
application.
the application.
Yes, that's the first prayer in the application, my lord.
Yes.
My lord, this cause of action, which my learned friend's client has sought to make out, my lord, emanates from his rights as a legatee. That is what he says. If that is the case which he's trying to run, my lord, then, my lord, he is trying to safeguard his rights as a legatee, and according to the division bench order, he has to go to the testamentary jurisdiction. And that liberty has been granted, and the single bench has come to that conclusion. So therefore, my lord, I say, first of all, no injunction can be passed. And these prayers, my lord, if required to be passed, are to be before the testamentary jurisdiction, paragraph 217 and 218, my lord. And in my case, my companies, my lord, your lordship has shown the shareholding. So today, if my lord is of the view, my lord, kindly, my lord, if your lordship is of the view that these resolutions have to go, though the resolutions have not been challenged intentionally, but the effect is that
No,
the
but
resolutions have to.
till now we are not of that view, but you are, if you can convince us, yes, definitely we will.
My lord, my lord, we always have to take all points.
Then alter the resolution, if you can convince us.
My lord, alter the resolution. My lord, that is what I was about to say, my lord.
If you are of the view that the resolution should go, we are still not of that view.
My lord, that is what
you are almost convincing us.
No. My lord, then it's better for me to keep quiet, my lord.
No, sir. Please complete.
No, my lord, I was only submitting.
So you're right. Yes, we get your point. Yes.
If they are trying to take the resolution at hand, they have not challenged the resolution.
Yes.
But they are trying to challenge the action of the company. That is what. But I just want your lordship to think about kindly, it does not take me amiss, to think it as a regular suit without the Birla thing being there, the PDB testamentary jurisdiction coming here. If that is taken, my lord, what is the suit for? And if now we include the shareholding of PDB, would that be covered by the division bench order for them to go to the testamentary jurisdiction?
Yes.
So these are my submissions, my lord. I'm very grateful.
Yes. Yes, Mr. Mithun. Yes, yes.
The Banerjee's submission,
Hmm.
that Mr. Banerjee's submission was that had our contentions been accepted by the division bench, then the then the testamentary court could have controlled the board. This was his submission, paragraph 78 of the division bench judgment. Page 78, page 349, where he was appearing not for these companies, but for the defendant caveators in the probate proceeding. That was his submission. I am reading out paragraph 78. Mr. Ratnakar Banerjee, the senior advocate appearing for respondent number 3, that is one of the caveators, submitted that, or as we call billas. And in addition to what has been stated in the written note submitted on behalf of the third respondent, page 349. Page 349. In addition to what has been stated in the written notes,
yes,
Ratnakar Banerjee, senior advocate appearing for respondent number 3, submitted that in addition to what has been stated in the written notes submitted on behalf of the third respondent, in order to avoid overlap, the third respondent is adopting the written notes filed on behalf of respondent numbers 1 and 2, which is submitted the cross objections filed by the respondent against the judgment of the learned single bench should be allowed for the reason to protect and preserve the estate of the ultimate beneficiary, which is the paramount duty of the testamentary court, and the testamentary court can pass orders against third parties in exercise of powers under section 347. It is submitted that as contended by the second respondent, the decision in 16 SCC online has the application for the submitted that the company trust societies form part of the estate of PDB and MPB group. If this submission was accepted, then he cannot, well, if he has received these instructions from the company today to make these submissions, which was the submission made by the caveators, then in that case, I would say every more reason, Lordship, some protection is required. Lordship also sees in this connection, page 512, the same minutes where the APL committee found that 100% shares are held by the page 512, paragraph 3. Mr. Ratnakar Banerjee, senior and both learned counsel for the defendants referred to in a charge statement on record indicating the tier-wise broad structure and control of the MP Birla Group companies through the key companies and statement of promoter shareholding, etc. Kindly omit paragraph 4, kindly come to paragraph 5. For 4 is all those quotations, paragraph 5, page 513. Mr. Banerjee and Dr. Saraf further referred to and relied upon the observations made and findings given in several reported decisions of the Company Law Board and Calcutta High Court from 2005 onwards, stating that the estate of late PDB Birla through cross and chain shareholdings in the companies in tier 1, tier 2, tier 3, and tier 4 and the trusts and institutions hold 62.9% Birla Corporation. And the major part of the estate of late Premada Birla consists of controlling power over the MP Birla group of companies, which is a valuable asset of the estate of late Premada Birla. That's the estate. Now, apropos, this was accepted at page 531. Paragraph 38. This is accepted by 2 of the APMs. Third one, Sharma dissenting. Paragraph 38. Having considered all the relevant facts and circumstances and having considered that the major part of the estate of Premada Birla consists of direct and indirect holding through chain and cross holdings in various companies, controlling interest in several MP Birla Group particulars, particularly the companies with the percentage of shareholding set out in the chart annexed and Annex X. APL committees of the considered view that the pendency of the probate proceedings over the Calcutta High Court in relation to the estate of late Mrs. Birla is necessary for the protection and preservation of the estate of late Prem Brother Birla. To see that all 3 members of APL are nominated on the board. And these are the 5 companies who are here now, who have implemented. There can be no dispute that the estate of late P.D. Birla has directly or indirectly majority shareholding in all the above companies. And APL committee will get weightage on the board of the above company. This will ensure that in case Mocha is unable to attend. Now, these board directors are now instructing Mr. Banerjee and Mr. Thakkar to argue that these companies are dehouse the APL. It is an independent board and has no right to, and this is independent of the estate, the internal affairs of the companies. Now, Lordship, even more alarming is, Lordship, paragraph 26 of the judgment under appeal. Paragraph 26 of the impugned order. When Mr. Abhatosh Majumdar placed the letter and showed that this was the reason, as regards the contention of defendant number 7, that the defendant companies in their board meeting stated that the staff members of the investment companies, trusts and societies having their offices in the said space are being subjected to various types of intimidation and threats on daily basis. And thus the defendant companies have...
That was not accepted by the court.
No, but then they then showed the minutes of 23rd of October to say that was not a relevant consideration at all. They did not show the 31st August because Mr. Majumdar said...
There are 25 records, 31st August meeting.
Yes, but the minutes are not shown. Minutes are not shown. Minutes are shown of the 20...
The court says in the minutes of the meeting dated such and such, it is categorically mentioned at the rate. That's a finding of the court.
Yes, in the said minutes, it's categorically mentioned that it was also decided that the keeping in mind the management may also identify and finalize. So, but then this is not...
Must have seen it. Otherwise, this is a specific recording.
As per the minutes, the above matter was discussed, but that is not the reason for acquiring. Now, Lordship kindly sees at that meeting, what we find now, the minutes have come, there was no decision taken. It was only decided that let's take legal proceedings, appropriate legal proceedings. The decision taken was to take a legal advice be sought to protect the interest of the company, which was given by Mr. Abhatosh, Mr. Thakkar. This is the last page of the minutes, just above paragraph 15. After discussions, it was decided by majority that further legal advice be sought to protect the interest of the company, and if required, appropriate legal proceedings be initiated.
Maybe, Mr. Mitra, that was regarding the other limb, because there was another allegation raised that there was harassment by the BCL people.
Regarding that,
this was regarding that, but
it was also decided,
yes,
that keeping in mind the growing need for additional office space, the management may also identify and finalize other additional suitable
all
space.
right, yes.
Now,
yes.
so far as this is concerned, Mr. M.K. Sharma has written, you have not shown any comparison of rates. So he did not get alarmed, and he did not write to the parties to the suit that that this may happen. And if I had come at that stage, this would have been grossly premature. They were only considering the options. But then next meeting, 23rd of October, without considering any other rates, as Mr. Sharma's letter records, no APL decision on whether to take this property on rent or not at this rate. Now, this is finalized at the board meeting. So that is when he objected. And today, that decision, Mr. Thakkar said the majority, the APA, if we approach the testamentary court can direct the majority shareholder to reverse that decision. Majority shareholder can never reverse the decision of the board. He has to call an extraordinary general meeting. That is 21 days notice. After the meeting, the board will be changed, and if in the meantime not signed, they may So that reversing the decision, I have to come to my Lord's court. My Lord. And yes, then it was all part of it. And Mr. Anirban has of course argued shareholders can't overturn management decisions. This is correct. They can do it in a very circuitous manner that they can change the board, etc., etc. So,
Yes.
but this is a humble submission that this is, I cannot go any other court straight away. Civil court jurisdiction is not expressly ousted in this case. So, my Lord will kindly consider continuing the interim order that was granted on 30th of interim order copy the 30th on 30th, Lordship. I will just hand up the order that was passed on the 30th of.
Mr. Mitra, we have requested Mr. Banerjee and Mr. Thakkar, and we'd also make that request to Mr. Rai, that they don't take steps in terms of the resolution till 30th of the 20th of this month, next Wednesday. We'll be passing our orders on next Wednesday. We will not
This
be
was
passing
the interim order that was subsisting.
we won't be
Lordship.
passing an interim order right now.
No, I
Because
mean
that was the interim
what
order
I'm saying is this
subsisting
was the interim order subsisting.
in
So I'm
connection with this
handing
appeal.
No, but that was
For
not
4 days.
continued
Don't
by
pass a
the.
fresh interim order in the appeal, but we have heard both of you and we have requested them. They have agreed to that they will tell their clients not to do anything in the till 20th.
Of course, if they said so, there's no question of passing.
Is passing any identity
No,
order in
no.
an appeal in connection with an identity order.
I'm not. No. Well, all I showed was
Since
that
you have
was,
heard the appeal itself,
no,
that's why.
all I showed was that was the order subsisting.
Oh no,
So-
definitely.
so
You're
for that reason, not for.
No, just one clarification. 31st August minutes was before the learned single judge matter. It was played by Mr. Obrotosh Mujumdar. Paragraph 11 records.
The learned trial judge refers to it
Yes,
also
it was
elaborate.
placed by Mr. M.K. Sharma. Paragraph 11, your lordship will find it.
It has elaborately it has been
Yes,
dealt with by the
Submissions were made on this 31st August minutes. 11, paragraph 11 of the impugned.
Mr. Banerjee kota judgment, Mr. Duto judgment said. Mr. Banerjee cited sorry, you cited Universal, Vodafone and
Z. Mr. Mitra cited
Vodafone,
Z.
and Universal Project.
Z Investco.
জিএর কপিটা পাচ্ছি না।
Great. ওটা তিনটা।
আর একটা জাজমেন্ট সাইট করছেন তার একটা কপি থাকে। এর একটা রাজনৈতিক কপি পাচ্ছি না। ও পেয়ে গেছি। পেয়ে গেছি। আমি পেয়ে গেছি হ্যাঁ থ্যাংকস এইটা একটু স্টেপল করে পাঠিয়ে দেবেন। সাকসেশন একটা সময় পাঠিয়ে দেবেন। আচ্ছা না সাকসেশন থাক। ঠিক আছে আমি এগুলো সব ওদের on contest without, however, any orders to cost. Impugn judgment and degree dated such and such is accordingly affirmed. Pending interlocutory application stand disposed of. Interim order vacated. Formal degree be drawn up.
Grateful, Lordship.
Sorry.
No, grateful, Lordship.
Yes.
However, you argued well.
Mr. Mukherjee, my learned brother wants to say something to you.
You argued well.
I'm so
You argued
grateful.
very well, actually. I want to add a very to that.
I'm
Not
so
just
grateful.
because your client has lost, but really you argued very well.
I'm so
We
grateful,
were
Lordship.
in a dilemma.
Thank you, Lordship. for giving me the opportunity.
Yes.
Grateful,
পরটা আচ্ছা এই দুটো এবার চলে যাবে যেখানে যাওয়া ওই দুটো একসঙ্গে ঢুকে নে। হ্যাঁ not today. Not today. এখন কি থাকবে না হয়তো not today, next.
In the morning.
এটা হয়ে যাবে নিয়ে ওদিকে না থাকলে not today করে দিন item 4 not today এটা item 4 not today হয়ে গেছে
We have the appellant, my lord, in this matter, my lord, I appoint in senior minister Prowal Mukherjee, my lord, praying for short password in his own way, my lord, maybe.
pass over
Great.
এটা কোনটা দিচ্ছেন পাস ওভার হলো যে not today yes Ms. Joseph. You are for the appellant
I'm praying for not today.
why
My senior is not well. Advocate on record is not well.
who is he
Mr. Asabuddin.
what happened to him
He is suffering of fever, viral fever.
একটা অর্ডার রেকর্ড করে নিন ওখানে বসে করে নাও শুভ্র on the prayer of the respondent the matter is adjourned for the day দুজনের নামটা রেকর্ড
Let it appear.
pardon
Let it appear next week, my lord. Tomorrow I have some problem, my lord.
on the prayer of the respondent the matter is adjourned till November 18 2024
Let it remain in that list, my lord.
Whatever
In this
position.
position, my lord.
whatever position it will be yes next how many applications are there if we call every matter every day
I beg to appear on behalf of the respondent.
Respondent.
By Mr. Mukherjee.
today we are not dismissing for default because there was a doubt whether we could reach them none appears for the appellant at the time of call although the respondent is represented through counsel let the matter stand adjourned for the day
Grateful.
not today same not today Not today.
I'm for the appellant, my lord.
Yes.
My application for stay, my lord, of execution of decree, my lord, passed by the learned city civil court, my lord. But in the meantime, my lord, decree has been executed, my lord.
Oh.
Partition has been time. So appeal has been impact.
That matter, yes.
Yes, my lords, I am just for the records had served the notice according to
Yes,
my
my
lord's
lord, got the notice. my lord.
direction.
No, we directed him to
Yes,
file
yes.
the receipt also.
My lord, got the
So,
notice.
what is your thank you? What is your instruction?
My appeal has been infectious, my lord. Do not want.
No, the appeal you want to proceed with the appeal and
But that instruction he has not given me written, my lord. But she has, my lord, informed me over phone, my lord, not to proceed with the appeal further.
not to proceed with the appeal. Very good. Yes. একবার বলারও আছে প্রথম দিন ভট্টাচার্যের ভুলটা তোমার হয়েছিল ভট্টাচার্যের নামটা ডাবল ওয়াই দিয়ে দাওনি আমার তোমার এখন আমি যেটা চলে যাচ্ছিল তোমার অর্ডার সরে যাচ্ছে Counsel for the respondent files a receipt indicating that notice of pendency of the appeal has been served on the learned advocate for the appellant, which is kept on record. Full stop, next para. It is submitted by learned counsel for the parties that the decree, the impugned decree, comma, against which the appeal has been preferred, comma, has already been executed in due process of law. Full stop, next para. Accordingly, learned counsel for the respondent contends that the appeal has been rendered infructuous. Full stop, next para. Learned counsel appearing for the appellant, comma, on instruction, comma, submits that the appellant does not want to proceed further with the appeal. Full stop. Accordingly, FA 10 of 2024 and IA number CAN 1 of 2024 are dismissed for non-prosecution without an order as to cost. Thank you. Thank you. In.
All matters will
You want to do any matter? One matter was passed over because it was prayed for, we passed it over.
Why the audience side is was going on?
No, that's why Mr. Bhattacharya, we are not even passing any order.
Yes.
If you can bring your other side, if you want to do the matter.
Other side. There is no other side. Yeah, I can.
But in open court, we have said not today. If somebody was watching,
Yes.
Mr. Bhattacharya, that is a difficulty. So that's why we are not doing not passing any adverse order, because we appreciate that nobody could anticipate whether that matter. No, we are not doing anything adverse unless both sides are present or something like this. Yes, who is appearing in item 14? You are appearing? No. This is item 14 or 13? 13. Item 13 defective রয়েছে
Personal compensation.
হ্যাঁ defective রয়েছে বলছে from the office report, it appears from the report of the additional stamp reporter dated November 12, 2024, that the appeal has been filed out of time and hence defective. Full stop. It is seen from the records that no application for condonation of delay has yet been filed. Full stop. Next para. Accordingly, the appellant is directed to file the appellant is directed to take steps for seeking condonation of delay in preferring the appeal within a week from date. Full stop. The matter shall next be listed on November 25, 2024 under the same heading. Insurance company কি বলবো বলুন ওরাল পেয়ার হলে আমরা করে দিব হ্যাঁ এটা ওই 25 তারিখে থাকবে কিন্তু এতক্ষণে তো ওদের দেখা উচিত ছিল অ্যাপেলেট সাইড লিস্ট রান করছে none appears for the parties at the time of call. The matter is adjourned for the day. অনেকক্ষণ টাইম দিয়েছি।
My lord, I'm for the opposite party.
Yes.
My lord, Advocate Shohini Chakraborty is the English as senior counsel. Shohini Chakraborty. So I am praying for release on his behalf.
Yes.
I'm for the appellant.
Yes. In view of one of my relatives, in view of the relatives of one of us within bracket Bhattacharya J, bracket closed, appearing for one of the parties, comma, the matter is released from our list on personal ground of one of us, bracket Bhattacharya J, full stop. Liberty granted to the parties to seek an assignment before a different division bench. Sorry. Yes. None appears for the parties at the time of call. Let the matter stand adjourned for the day.
Lord, 17, my lord, I'm for the appellants. Now, in this matter, my lord, the appeal is arising out of a matrimonial suit, my lord, which was decreed on admission. Lord, thereby granting a divorce in favor of the petitioner respondent.
Decreed on admission?
Decreed on admission. There was an application under Order 12, Rule 6 for judgment on admission filed by the respondent.
Yes.
And my lord, that was allowed. And a decree has been passed. If my lord sees the impugned order, my lord, it is at page 67.
Refer to the internal page, you have the memorandum. Refer to the internal page of the order. So why are you challenging it?
Lord, a matrimonial suit on contest cannot be decreed on admission.
Yes, but why did you give this?
Lord, the admission. Lord, kindly seize the admission.
Yes, show us that.
Seize my in the stay application, Can 2 of 2024.
Give us the page number of your
annexed my
so-called
written
admission.
statement.
Which paragraph of the written statement?
Yes, I'll tell your lordship. Note the written statement is at page 32. Note the admission is at paragraph 38. That is, my lord, page 46. Lord, I'll
আমাদের স্কলারশিপ নয় সেটা লিখতে হবে এটা সেট করতেই হবে তাহলে এই ডিগ্রিটা ওদের ভ্যালিড ডিগ্রি সরি which page?
Page 46 of the written statement. Internal page 15.
Yes.
Paragraph 38. It is, my lord, I'm reiterating the facts. It is submitted that since the petitioner does not want to lead conjugal life with the respondent.
You are right that without 13B, divorce degree cannot be granted like this.
Yes, my lord.
But I mean, why are you preferring a challenge? You have already, you also wanted a divorce.
But there is a separate provision under 13B. And
yes, but why are you preferring the challenge? What is your cause of action? You
because-
wanted a divorce also.
Yes, my lord, I want a divorce, but my lord, not in favor of the petitioner. My lord, that was a mistake on the part of the learned advocate. Why I say, my lord, that was a mistake? If my lord sees the written statement, the grounds I have made there, my lord, I have denied and disputed all the allegations made by the petitioner therein, who is the respondent in this matter, the husband. And my lord, I have made counter allegations as well.
So you say if this is taken as a judgment on admission, then the allegations are also deemed to be admitted.
Yes, my lord. And my lord, I'll forever carry the burden of social stigma with me.
True. ঠিকই বলছে জাজমেন্ট অন অ্যাডমিশন হলে প্লেনটা তো অ্যাকসেপ্টেড হয়ে গেল itself a 2-minute appeal. Give a notice, will dispense with
I'll serve them.
paper books. We'll hear the appeal on the materials. You have annexed the plaintiff statement.
Yes, my lord. All the records, my lord, I have
Oh,
annexed.
these are all the records.
Yes, and the order sheet as well.
Server notice come back 2 weeks after, we'll hear out the appeal, dispose of the appeal
Fine.
itself. The present first appeal arises out of a judgment on admission passed by the learned trial judge in the context of a divorce decree filed by the respondent husband. Full stop. Next para. The appellant stroke wife has made out a strong prima facie case on 2 counts. Colon. Next para. First comma. A divorce decree cannot be granted on the admission of one of the parties unless the paraphernalia as stipulated in section 13 within bracket capital B of the Hindu Marriage Act are complied with, and the court is satisfied that the concession given by the parties is not collusive. Next para. Secondly, comma, in view of a conjoint reading of all the paragraphs in the written statement of the appellant wife as a whole, comma, it is evident that she controverted the allegations made against her by the respondent husband in the plaint, comma, whereas a judgment on admission simpliciter would entail a social stigma for the appellant wife, inasmuch as all the allegations made against her would be deemed to stand admitted. Full stop. Next para. Keeping in view the short conspectus of the appeal and that the matter arises out of a matrimonial suit, comma, which carries an implicit urgency, comma, we are inclined to fix the appeal itself for hearing without directing formal paper books and stroke or the records. Full stop. Moreover, comma, we find from the stay application filed by the appellant that the plaint and the written statement, comma, which are the only German documents in the present case, comma, have been annexed thereto, and as such, comma, no further papers or the records are required. Full stop. Next para. Accordingly, the records, calling for the records are is dispensed with. Full stop. Next para. The appellant shall issue shall serve a notice on the respondent indicating that the matter shall be listed, that the appeal shall be listed for hearing on December 28, 2024. Full stop. Next para. Formal, all other formalities are dispensed with for the present. Full stop. Next para. The application for stay bearing can 1 of 2024 shall be listed along the application for stay. What is the other application?
Lord, that is section 5. There is a
Oh,
55
acha.
days delay.
Wait. Section the there was a delay. Then we cannot fix the appeal for hearing. আচ্ছা, যা বলেছি তাই, on such and such date, comma, along with the connected applications. Full stop. প্রথম সেন্টেন্সে করে দাও. So the appeal has been filed out of time, comma, in view of the brief issues involved, comma, we are inclined to take up the application for condonation of delay, comma, stay application as well as the appeal together for hearing. এটা দিয়ে শুরু করো। আর যেখানে সার্ভার নোটিশ বললাম, সার্ভার নোটিশ অফ দি অ্যাপিল, একটা জায়গায় বলেছি অ্যাপিলেন্ট সার্ভার নোটিশ অফ দি অ্যাপিল। দেখো থার্ড লাস্ট প্যারাগ্রাফে কোথাও আছে অ্যাপিলেন্ট শ্যাল সার্ভার নোটিশ অফ দি অ্যাপিল। দুটো প্যারাগ্রাফ আগে। ওইখানটাই সেন্টেন্স শেষ না করে কমা দিয়ে along with copies of the memorandum of appeal and can 1 of 2024 as well as can 2 of 2024 and file an affidavit of service on the next returnable date. File the memorandum, both the cans on the respondent service and file an affidavit of service on the next returnable date, and you can either annex a copy of server copy of our order, or you can indicate that The appeal and the application shall be taken up for hearing together. What is the age of your clients? Client? Approximate? From your stay application, you can check.
30, I guess.
30?
But I'll just confirm.
40. Time in your life. No, actually,
No, that is
actually,
why
the
I
matrimonial suit.
made
That's
that
why you are fixing the appeal along with lock, stock, barrel. Lock is the section 5, stock is the
30,
stay
30.
application, and barrel is the appeal. Yes, next.
Yes.
Yes, sir. What is your case?
My lord, matrimonial.
Section 5 has been filed.
Yes. I am for the respondent. Lordship, the matter is like this. Husband, wife stayed in the same house. At the time of filing also same house. Admitted in the plaint, in the cause title that in the same house. But someone has been served in no other address than in own house. A report given that I have gone to the house, not received. By 3 days, ex parte degree given. Now, after obtaining the ex parte degree by the husband, served the notice on my brother, saying that this has been obtained. From the date, my date of knowledge is the service of the decree upon my brother. If your lordship kindly takes up my can 2, I will show 3 pages, lordship.
You have not filed any section 5?
Yes, I have. Formally, I have. But then my date of knowledge, if your lordship.
Where is the section 5? It's not appearing in the list.
Can 1 is the section 5, lordship.
Section 5. Take it. Oh, yes. No, sorry. 1 minute. Can 1 ta কোথায় একটু দেখে দিন, sir? Can 1 is application for appropriate direction.
Can 1 is condonation of delay, my lord.
Can 1 is an application for appropriate direction and or necessary order of injunction, temporary or permanent. This is this Madhumita Sardar versus Dibyendu Sardar?
Yes, my lord. Yes, my lord.
Yes. Can 1 আপনারটা তাই?
May I hand over this to your lordship?
আপনারটা কি? এই can 1 টা দেখি। এটা তো অন্য ফাইল, অন্য ফাইলের can 1। So we'll treat this as a.
And my lord, before my lord takes up the matter, the appellant before my lord has already filed an application under Order 9 Rule 13 with a Section 5 before the trial court. And this is the copy. May I hand over a copy? Order 9 Rule 13 is pending and it is supposed to appear on.
That's the easier option for you. So we'll adjourn it for some time. Then take your chance there. If you lose that, then the appeal is always open.
Then lordship, what I'm saying, there my scope is very limited.
No, but it's easier for you
My
because
here my point are 2 that whether
you have to choose one of the remedies then. Because this is not review, that is not review.
May I hand over the copy?
Either you choose your remedy because you cannot take a chance.
Appearance is 22nd of
Difficulty is if you lose here, then Order 9 Rule 13 is not barred even then. But for the self-same relief, no.
Lordship
We'll either adjourn it, choose your remedy. Order 9 Rule 13 is there.
Lordship, then
Order 9 Rule 13 court is more liberal. You can get it set aside. Why the appeal?
Facts here is very strange.
And in any event, this is with a condonation of delay. So
There's
When
also
is the date fixed for that?
Order 9 Rule 13 is fixed on 22nd of November 2024, my lord. May I hand
Notice
over the
vacant.
summons? May I? With the
Vote is vacant.
Do it. We'll adjourn it till we'll put it in the
Vote is
December
lying
month.
vacant, my lord, as I am told. And second thing is, why did I file this appeal? Because Order 9, Rule 13 is not a continuation of the trial. So he is entitled to remarry. So I have to, if I want to stop him from marrying again, I had to file
In
this
Order 9
appeal.
Rule 13 also you can make that prayer. Definitely you can make.
I have to
Resting-
make the prayer. Here, if I file that appeal, if your lordship only condone the delay and then you lordship post it for any other day, then lordship, in that case, I am protected. Otherwise, how the degree fraudulently obtained against me, lordship can see, we both stayed in the same house.
But
In-
he already has notice of the appeal.
He has
Now
the
he has
notice of the appeal, but formally the appeal is not there. So lordship has, unless lordship condones my appeal, the appeal is not there. Lordship.
What is the ground taken in the condemnation? Appeal?
Lordship.
But there is only one copy.
Can I, to want to down?
May I hand
No.
over my copy?
No. Then we'll ask for the records to be corrected. We'll take it up day after tomorrow. On
Monday or
Definitely.
yes.
When the matter is taken up, when the matter is taken up for hearing, it transpires that Can 1 of 2024 is missing from the file, whereas Can 1 of 2024 in respect of an FMET having similar number has been tagged with the file. Full stop. Let the records be corrected by the officers of the court at the earliest by placing the application bearing Can 1 of 2024 filed in connection with FMET 324 of 2024 to its original file, as well as tracing out Can 1 of 2024 filed in connection with the present appeal and tag the same with this file. Full stop. The matter shall be listed, the application shall be listed on November 18, 2024 under the heading applications. Please take this back. Order 9 Rule 13.
An affidavit of service be taken on record.
You have filed it. Affidavit of service filed today be kept on.
I'm just.
আপনি নিজে একটু এটা ইয়ে করে দেখবেন ওটা যাতে ঠিক জায়গায় ঢোকে বিজুলির উপর শুধু নির্ভর করা যাবে
This is my appeal, my lord, against an ex parte ad interim order. I have, my lord, suffered.
I'm not sure, my lord, if there's determination.
appeal has been admitted.
No.
Then we don't have determination. It has to go before the current bench. Justice Standen probably.
Miscellaneous appeal.
Order 41 we don't have. Order 41 in connection with everything, FMET, SAT goes to some other bench. We have the hearing determination.
Oh, hearing determination, not.
And the architect of the mischief is him, not Mr. Chatterjee.
No, এইটা কিন্তু
You.
হ্যাঁ
We do not have determination to take up
I think, so it is
order
post
this.
admission, possibly
Order-
post admission.
determination to take up order 41 matters.
এখানেই আসতে হবে কারণ এটা শুধু তো
Oh,
2021 onwards. Full stop. Next pair accordingly, let the matter go out of our list with liberty to the parties to mention before the appropriate bench having determination. Justice Standen.
both order 19 and 20, my lord.
19 and 20.
Yes.
20 টা call করে দিন, same order.
But well, why this distinction? Any
In fact, I mean, I didn't know my advocate would have got confused, and I also got confused.
Same order, same order, same
Same
order.
Grateful, man.
Lord, item 21, I'm appearing. Lord,
By that expression, Mr.
item
Kormakar,
number-
what is the
item nu-
mischief you have done?
Lord, item number 11. Lord, my fault, I could not be here. Lord, there's some misunderstanding. Someone stood for the appellant and said, my Lord, that this has become infructuous. Lord, I am for the appellant.
What?
In item number 11,
We passed an order saying it's infructuous.
Lord, I am told, my Lord,
It's a
somebody
Produt-
appeared. Yes.
Ganguly probably.
Yes, my Lord, Raja Hela, the matter's name is Raja Hela. Lord, there, my Lord, I am for the appellant. And Mr. Miss Shohini Chakraborty was appearing for the other side. Now,
No,
my
Miss
Lord,
Shohini Chakraborty other side, we have released the
that is-
matter.
Lord, that I'm not saying, Lord.
No,
the
one matter
problem
we have
is-
released on the ground of Miss Chakraborty.
Lord, item number 11, Lord, perhaps submission has been made that it has become infructuous. That's what I am told. I should have been here.
কোনটা
Lord.
করেছি ইনফ্রাস্ট্রাকচার কোনটা করলাম?
One matter has been withdrawn.
হ্যাঁ সেটা একটা ম্যাটার উইথড্র হয়েছে সেটা তো no no
Lord, I was for the appellant. Eviction suit, Lord.
Yes, eviction suit.
Directions were passed for depositing occupational charge. What I was asking
No, it was said that the execution has been effected. I mean,
my instructions are to press for the appeal.
yes, we precisely asked for that and we directed a notice to be given to the appellant because we wanted to ascertain whether you want to resort to 144.
Yes,
I mean,
I will be doing that.
That was the precise reason we directed to give notice. That notice was taken on record. Somebody appeared and said, I also have instruction. 11 কি অর্ডার নিয়েছে 11 এর ফাইলটা দেখান তো এতক্ষণ ধরে শুভ্র নিয়েছে You'll get a good spanking from me.
I was told, Lord, I'm sorry.
And come prepared with a board on your behind.
Extremely sorry.
Oh, item 21, my lord.
21 yes.
Has been served, my lord. My lord, one time appeared for my lord, respond number 1, 4, 5, and 6, my lord. Now, my lord, I lost contact with my client, my lord.
Lost contract. Then we'll allow the appeal.
But as soon as I get my lord, I wrote a letter to my letter.
As soon as you will get
this paper book, my lord, I wrote a letter to my client, my lord, asking to contact.
You got the paper. As soon as you got, not get.
Because of your lordship only, my lord. I have seen the video, my lord. He was trying to do the matter.
You have seen what video?
My lord, in YouTube, everything is available, my lord, now today. So, my lord, as to lordship directed to serve us, my lord, so we get that, my lord. Now, my lord, give me 1 week's time, my lord, so that, my lord, I can.
For that, so much trouble, yes.
But he was not representing all the respondents.
You are appearing in this matter also?
Yes. But he was.
Yes, yes. What is your case?
He was not, Lord, appearing.
What is the matter about, Mr. Korma?
Lord, this is with respect to, Lord, a partition a declaration and partition suit, Lord, dismissed on the ground of.
The appeal is otherwise ready for hearing.
Yes, yes.
So you want to come prepared on next Monday?
Next, my lord, Thursday, my lord.
Lord, may I file the affidavit service pursuant to your lordship's direction?
We'll keep it next Thursday for hearing of the appeal then.
And Lord, once may I go through the file of this matter, Lord?
Yes, yes, absolutely.
Yes, there are directions, my lord, to substitute service also there, my lord, paper publication.
Yes, those have been done, my lord. Paper publication has been.
Learned counsel for the appellants submits that the appeal is otherwise ready for hearing. Full stop. Learned counsel for the respondents seeks an adjournment. Full stop. Affidavits of service filed today be kept on record. Stop. On the prayer of the respondents.
1, 4, 5, and
sorry. The matter is adjourned till November 21, 2024. Come back on that date. Be prepared with the appeal.
Yes. May I go through the file, my lord, once?
I file take to একবার inspection দেবেন তো সাইড দিয়ে ওনাকে সাবধান লেগে যাবে sometimes utter confusion here so wait for 5 minutes maybe we'll call the list and then go through the file
Lord,
that will do not the lower court records
not the lower
oh আচ্ছা তাহলে দিন দেখেন yes call on the next one call 22 ফাইলটা একবার দিন তো দেখি ডিসমিস অর ডিফল্ট করা যায় ও সর্বানন্দ অ্যাপে কিছু এটা yes what about Mr. Rai
Lordship, he is coming, Lordship. He is on legs, Lordship, in court number 13,
coming from where
39, Lordship.
yes what is the matter what is the matter Mr. Sorry continue your argument now the judgment
Asutosh Mondal was the father, Lordship, of the appellants and the Lordship dependent.
Yes.
He died, Lordship, 3 sisters and 1 son. Now, Lordship, 3 sisters, Lordship, allegedly, Lordship, executed deed of sale, Lordship, in favor of the dependent number 1.
Yes.
Now, the plaintiff number 1 and 2 is the sister, and plaintiff dependent number 2 is another sister, Lordship. Now,
one point taken by you was that Fakir DW1 had admitted that the execution and registration took place on the same date.
Same date.
But that's not their case in their pleadings.
No.
So that there's a contradiction there. And
another point, Lordship, was minor. At the time of
Plaintiff number 2 was minor, which is
Minor.
also evident from PW2 evidence. If we tally the dates, it is seen that she was 18 at the time of execution of the deed, and plaintiff number 2 was younger sister.
younger
So must have been younger.
must. And Lordship,
These
now
are the 2 points.
2
So
point,
place the
Lordship.
judgment.
Now Lordship, I'll place the judgment, Lordship.
Yes. Let us dispose of the appeal before Mr. Rai comes.
Lordship, Mr.
Yes.
Rai is late, Lordship. I'm late by.
Yes, yes, quick, Mr. Rai, finish the matter. We have already heard the matter, only the judgment remains.
Yes, actually. Where can you turn to page 131?
Yes, 131. District Malda, yes.
So, what the facts which are narrated
2 points have been taken by Mr. Chanel, Mr. Rai. Those are the 2 points we'll argue on. There's a discrepancy, date of execution and registration. Pleadings says different dates, but evidence says same date. And one is plaintiff 2 was minor, which is borne out by PW2 evidence. If we tally the dates from the evidence, we will see that she was 18 and plaintiff 2 was her younger sister.
Another thing, my lord, the 3 executors of the deed
Yes.
are all illiterate. Whether, my lord, the burden of proof regarding the execution of the deed lies upon
You
the...
say that was not discharged.
That was not discharged.
Admittedly illiterate.
Yes.
3
that-
attesting witnesses.
No, the executants. of
3,
the-
sorry, 3 executants.
3 executants. What are they? What are they? Yes. Yes, my lord. If your lordship can turn to PW cross page 91. If your lordship may kindly turn to page 97. So
Yes.
far,
97.
paragraph 7 is a specific that I am an illiterate woman, my lord, at
This
the
is a
bottom.
part of what? Affidavit in chief.
Chief of PW1.
PW2.
PW2. Oh.
Yes.
At the bottom, my lord, you'll find
She herself says.
yes, and the cross, page 101. Nothing has been stated, so 102. Specific question was put forward at the top of the 102, my lord, you'll find.
Yes.
At the top, the question put forward. And it is LTI is there, my lord. There is no
Yes,
dispute regarding this, all the LTIs are there. And apart from that, there is nothing to that aspect. So, what the literacy of the woman and knowing about the execution of the documents. And there is.
But she also says she cannot say the contents of her.
Yes.
আমার তো evidence-টাই চলে যাবে।
You don't want to explain after explaining me, I would.
Your advocate drafted her chief.
Then all of the DW1 will find what.
No, but
it is something, my lord. If he says that I am not aware about what is there in the evidence chief, well, then everything goes, my lord, without any saying.
But that is PW2. There are other PWs also.
PW1 is also there.
So what about PW1? You said
Yes.
all of them are illiterate?
Yes, all the 3 LTIs are there. Only 3 executors, my lord, can consider the deed itself. My lord, it will suffice the purpose, my lord. Because I'll draw your lordship attention to what the deed is concerned. That your lordship find at page 162 of volume 2, my lord. Because that is the crux of the matter. Volume 2, my lord, is the same. 162.
Yes.
The same day.
According to the plaintiff, this is the deed executed, my lord. All are, my lord.
Oh, they put their signature.
These 3 LTIs are there at top, evaluationally considers.
Yes.
And all are been identified by one
Gopal Mondal.
Gopal Mondal.
Gopal Mondal, we hope, is not the purchaser.
No, he was the witness. And the plaintiff says that I do not know about who is Gopal. That has come, my lord.
What? What?
Uh,
Plaintiff says
I don't know who is Gopal and Vibhuti. Thank you. Was it put forward? Now, my lord, can you turn to this? So, what the literacy is not disputed by the plaintiff
Replace
also.
only of PW2 you have.
Yes,
Oh,
my-
achha, all are there.
Same, my lord. Now, my lord, can you turn to? Before judgment, I want to draw your lordship attention about the DW1 evidence that your lordship find page 119. And you turn to page 121.
What were the reliefs claimed in the suit?
For partition and also for declaration that deed is void is not.
Oh, that was the primary relief, yes.
No, the trial court dismissal suit another ground that
No,
all the co-sharers are not made parties, the defective parties.
No, the defendant, they also laid evidence.
Yes, yes. Well, page 121, the chief of the DW1, my lord.
Achha, very well, yes. 121, what is there?
Page, the highest market value of our share settled rupees 6,000, my lord, will find from the top I am reading.
Yes, yes.
And same was duly registered on 23rd March 1989. My lord got.
Yes.
We also put him in.
Para 8 we have seen difference in dates.
Yes.
That has been placed by Mr. Khan.
Now, my lord, can you turn to the cross-examination portion? 125. It starts from 125.
Cross is. Yes.
126.
126.
If your lordship may kindly consider, Vibhuti Mondal is father-in-law of my brother. I have shown to you a Vibhuti. One is Vibhuti, one is Gopal. Witness of the deed. So the nexus I want to prove to your lordship, this is the nexus. Now I'm going to turn to 127.
One of the identifiers was Vibhuti.
No, witness. Identifier was Gopal. Was also witness and also identifier. But Vibhuti is one of the witness. Now I can turn to 127. This is the main prosecution I want to place.
Yes.
So for the market price, it your lordship find. I know that the market price, when I got it from the middle portion of the cross-examination, at Jongipur is rupees 10 lakhs to 20 lakhs per katha. And entire property are sold at rupees 6,000.
Yes, but this is the at the present tense. This is adduced in 2018 and the deed was of when? 2004 probably.
89.
1989.
And 6,000 rupees?
Yes, yes. If the current price is this.
Per katha. And entire property are sold rupees 6,000.
What was the total property?
Total property is, my lord.
1 or 2 bighas.
Yes.
We don't know. There is no evidence to that effect regarding what was the market price then. 1989 and 2018.
Yes,
in between. We
can. Last portion. I do not know whether or not Gopal and Vibhuti are present during execution of the sale deed by plaintiff.
Who is DW2?
Younger sister who is elder sister who is supporting the plaintiff. Sorry, my lord, defendant number 1. And according to her, she is one of the, as per the deed, she is one of the executant.
No, but Mr. Rai, if she is the elder sister of the plaintiff, then father-in-law of her brother means father-in-law of the plaintiff's brothers also.
Yes. Defendant number 1. Father-in-law of the defendant number 1.
Oh.
My brother, may I clear to your lordship?
DW2
is the sister of defendant number 1.
Oh, no. She was sister of plaintiffs.
No, 3 sisters. 1, 2 out of them. 2.
But defendant number 1 is your brother.
Defendant 1 is the brother. Defendant number 2 is one of the executant who happens to be the elder sister.
Yes, but then she says that Vibhuti Mondal is father-in-law of my brother.
Then
defendant number 1.
Defendant number 1. So the nexus between the person who have got the beneficial interest and the person who have identified. Yes. And Manat Kali consider the evidence that I do not know whether or not Gopal and Vibhuti were present during the execution of the cell deeds by plaintiff. On the contrary, this person, one is identified the LTI of all the persons, executors, another is the attesting witness. Now, my lord, can you turn to?
But she does not say that she was present at the time.
Yes, she is the executed. What are the executed?
Oh, she's one. Right. Sorry. Yes.
On this aspect, my lord, can you consider how the so there is no evidence so far the PW1 is concerned. DW1, no, DW1, DW1.
Read over and explain. Nobody says also in evidence.
No, it has not been said also. No question was put forward, but from the deed itself, it appears, my lord.
No, you won't put forward any question, obviously.
So not put forward.
You won't give him that opportunity.
Because I said that there is no execution on my part.
You won't give him that opportunity by putting the question in cross. But he did not also clarify the situation in his chief. Neither DW1 nor DW2.
DW1, that's why, my lord, I am drawing myself. DW1, page 104. My lord, can you turn to page 104 once? And turn to page 112, the cross-examination. Last portion. Dispute arose related to suit property after the date of registration of the deed in my favor. My lord will find after that. Last but second answer. I never told my sisters of purchase of suit property.
No, they of their own did it.
Now, one can consider the written statement. I have approached the husband of the sister was
Page number of the written statement. We will take a note here.
That portion, my lord. Page 49, my lord, paragraph number 11. Page 50, second paragraph. Nalisi সম্পত্তি ওইরূপে ভোগ দখল করা করে.
Page 50.
Page 50. That is the internal page 4 of the written statement. Second paragraph. প্রকৃত বৃত্তান্ত after তাদের অংশ বিক্রয়ের প্রস্তাব দিলে দুই নম্বর বিবাদী তাদের অংশের বিক্রয় 1 নম্বর বিবাদী তা খরিদ করেছে সম্মত উভয়ের আলোচনা দিতে নালিশি সম্পত্তি তাদের অংশ সর্বোচ্চ বাজার মূল্য 6,000 টাকা ধার্য হয় তদ অনুযায়ী গত ইংরেজি 20/3/1989 তারিখে বাদিত হয় এবং 2 নম্বর বিবাদী 1 নম্বর বিবাদী.
No, but this is not contrary. He says that the sisters gave the proposal. He says নালিশি সম্পত্তি এইরূপ ভোগ দখল করতে থাকাকালে 1 নম্বর বিবাদীর ভগ্নীগণ অর্থাৎ 2 নম্বর বিবাদী এবং বাদীদ্বয় নালিশি সম্পত্তিতে তাহাদের অংশ বিক্রয়ের প্রস্তাব দিলে 1 নম্বর বিবাদী খরিদ করিতে সম্মত. That is in consonance with his.
But if you logically turn to 113 once.
Yes, 113. He says they offered. He is consistent. I never told my sisters for purchase of suit property. I cannot say the date when my sisters offered me to sell. There is no contradiction there. He did not say that he.
And my lord, can turn to 115. Mr. Shanal also in shown to your lordship that only 115 last but one. Only for once I had visited the registration office. That is only single day.
Yes, yes. Yes.
And so for 117, my lord has gone through all the documents that the deed was taken on the same date.
115 to 117 we have marked.
So I am not disturbing your lordship. And he also said that I'll ask for expert opinion regarding genuineness of the signature of the deed, but he did not. That is 118 at the top in the cross-examination. It was the specific case mentioned by PW1 that I'll. At the top, my lord. I shall not ask for expert opinion regarding genuineness of the signature of the deed. It is not a fact I have deliberately shown the value. It is not a fact plaintiff have not executed sale deed in my favor.
Now, why should he ask for expert opinion?
Because
You are challenging them.
yes, my lord, I am an illiterate lady. If it is his burden duty, my lord, if kindly consider, my lord,
Whoever is challenging, is their word. And it was LTI, not signature.
that is what, my lord, I am submitting. If the LTI is the illiterate person, then burden duty upon the person who got the benefit to prove.
Regarding read over and explain, why should you ask for expert opinion regarding genuineness of signature if there is no signature at all?
No,
LTI will obviously be done. But LTI, you should have asked for
exhibition.
Yes, yes. What is your plaint case, Mr. Rai, that you had affixed the LTIs?
No.
You had never affixed the LTIs. Then read over and explain does not come in. You had to get the LTIs examined by expert.
The read over and explain, my lord, that
said you did not execute. Or
I did not execute.
You did not even say your LTIs were taken on blank paper.
No, nothing.
Therefore, you had to challenge. You had to seek appointment of an expert.
That is what, my lord, I am submitting. If your lordship kindly consider.
If it was a case that it was not read over and explained, you were duped into it, then we could have understood.
Apart from that, if I say I did not execute the document, and it appears from the documents itself that yes, the person who was saying that the date of execution and other things, which is not in.
No, but that is very weak then, because Mr. Rai, if there is a document where there are certain LTIs, you say those are, I never executed the documents. If you never executed the document without saying anything further, that I was, there was some misinterpretation given to me or something like that.
Character of the
Then,
document.
yes, you have to show that those are not your LTIs. That is the only thing you have to show. These are not my LTIs. Take my LTIs and see, ascertain whether those are my LTIs. If those LTIs are yours and you don't take any other plea in the plaint, then it's established that your LTIs were there. It's contrary to your plaint case then. Your plaint case is I did not execute.
I did not execute. Paragraph 2, page 2.
It will be belied. The entire plaint case will be belied. Then you did execute the deed. Paragraph 2, let us see, yes. Recently there have been various. Where have you stated?
Paragraph 2, page 2. Paragraph 2, page 2. Page 2. By false falsification.
Then
it is not the case regarding the
taken two cases. One is false personation and second is ineffective without consideration.
Yes, the documents is without consideration the character of the document. But character of the document counts when I admit that some documents either by way of power of attorney these
But
documents.
read over and explained is a secondary consideration.
Yes, read over and I am not on the my lord can consider a document purported to be a sale document which the plaintiff relies upon. From the evidence, I can satisfy that the documents which has been executed and registered does not conformity with the evidence of the defendant.
You are the plaintiff, the burden of proof is on you, meaning
Yes.
thereby that if neither of the sides do not lead any evidence, then you have to succeed. Now, you say in your plaint that I never executed, by false personation, somebody else executed.
Yes.
If that be so, won't you be asking for ascertainment of those LTIs? If you don't seek, then you don't prove your case that it was not your LTI. Your case is not proved, even if there was no representation from the defendant's end. It was an ex parte degree.
So
Then
the
also you
burden-
had to prove.
The burden of proof lies upon me, the initial burden.
Yes. LTI you should have at least, or you should have taken a different case. You should have
character of the
incorporated
documents, I
one
cannot
line.
understand the,
You have
the
never
garb of
stated
power of attorney, they have.
that blank paper signatures were taken, that would suffice.
But it is not the case there, my lord. It is a specific case of false certification.
False personification. Anyway, otherwise it's a very good case because you have pointed out so many discrepancies. Very well, false personification. You may say that DW2 doesn't know whether Gopal
because
or Vibhuti are present. So they are the identifiers.
They are the identifiers and the witness.
Then identification is also at jeopardy. If that be so, personation may come in.
False personification, my lord.
All right. Let us see.
That is the only thing I can satisfy your lordship regarding the execution and the mode of execution. That is apart from that. So what the other things are concerned, it is very feeble.
But if your LTI is approved,
now, can you consider the judgment, my lord? না যশের 5 মিনিট আর সময় আছে।
Yes.
135.
Yes.
Man, can you turn to page 136?
Yes, please.
Issue number 3. This is a non-gender necessary party, my lord. It appears from the written statement filed by the defendant number 1 and from the written statement filed by the defendant number 2 that the co-sharers of plot number such and such and plot number Moja are necessary parties to the suit. In spite of such disclosure in the statement, plaintiff did not take steps for add the co-sharers of the said plots as parties to the suit. Rather, PW1 stated in her cross-examination that she will not make any other person in the present suit. This is the one point, my lord, that I'll argue. Now, my lord, so what the traditional view of whether a suit will be barred if the consequences of relief are not been paid, the declaration portion can be given or not. Can be
No, this is regarding non-joiner of parties.
parties regarding partition, because I paid for partition of my half share.
Yes.
That is why, my lord, it is a non-joiner parties. It is stated that some other co-shares in those plots are there. I have not been party.
Even if you seek a declaration of a share, the other co-owners are necessary parties. All co-sharers have to be included.
So for my declaration, my lord, whether, my lord, my declaration is subject to right of partition. Declaration of title, my lord, can you consider it is a dispute between the who have raised
You are seeking declaration of a share.
share pursuant to the declaration that the deeds are
But
not
aren't the other co-sharers necessary party? Won't they suffer if your share is declared without hearing them?
No, because my father's share has not been disputed. My lord, can you consider it is a dispute between the brother and the sisters. Others have not been agreed by any sort because there is no.
No, but Mr. Rai, you are not seeking, you are seeking in respect of a property. Suppose you are seeking in respect of the entire room. Your father might hold, say, 1/3 share. You are not seeking interest between yourselves. You are seeking your share in respect of the entire room, where other co-sharers are also there.
Subject
So your father's share also may be disputed by them.
No, that is why, well, if I say that if there is a dispute to that aspect, I could understand. There is no dispute regarding my father's share.
No.
Any
Declaration, if you seek a declaration of your share, definitely all co-sharers have a right of hearing. You cannot say I won't impede all the co-sharers because only one of the co-sharers raised a dispute.
No.
One of the co-sharers might have raised a dispute, Mr. Rai. Others might not have, but they may very well come in the suit and dispute your share, even your father's share.
that if you logically consider
impediment of what sort of argument is you need not impede all the co-sharers.
If the cause of action matter for the purpose of filing of the suit based upon the fact that my brother refused to give or entertain the partition, then I could have understood.
You are asking for a greater relief than that. You are not seeking a relief only against your brother. Even if you seek that relief against your brother only,
then I have
also the other co-sharers are affected. You very merrily collude with your brother and get a decree that you are entitled to 1/3 share, he is entitled to something else, and the other co-sharers, they don't get a chance of no opportunity of hearing. They may dispute your entire title, both of your title. They may be totally in the dark. They may not know you.
So the partition suit matter, the others are
even declaration of share, because you are declaring a share which would affect other co-sharers. If there are other co-sharers on board, they may very well be totally in the dark. You say that my cause of action is against my brother, who resisted who asserted contrary title. Other co-sharers might be very well there. They don't even know you or your brother. You get a decree against your brother merely, and you don't impede the others. And the share is declared in respect of the entire property, just because you say that your brother is the only person who raised the objection. Maybe entirely a myth. The other co-sharers have a right to know. Declaration of share you cannot get. So
whether this can be a...
We'll record your argument, non-joinder
of necessary parties. It is not the non-gender parties, the non-gender necessary parties suit might fail. Whether the court can...
Other co-sharers you say are not necessary parties.
Yes. Issue number 4, if you logically consider.
Not necessary parties, why? Because they did not raise any objection.
Regarding my father's share at any point of time. Because it is my case that my father used to possess that portion of land, and after that my brother along with us used to possess the same.
They might not have raised objection because you did not raise the question of your father's share before them. All of you, my learned brother and I are parties, are co-sharers in respect of a property. I file a suit against my learned brother and get a decree I say that only he objected, so I get a decree against him, 1/3 share. I get 1/3 share, he gets, say 1/6 share, he gets 1/6 share, and I merrily go off with a decree. You don't even know
Then
that this is
whether
happening.
does degree to that extent will be binding upon the
What
rest of
extent?
other
Other-
questions.
You may come, if you knew that we were filing a suit and getting a decree, you might have come and said, no, their father did not have any title at all. Who are they? They are strangers to the property. You don't get an opportunity even. Anyway, record your submission.
Page 138, issue number 4
For what does it say?
says that the limitation, the deed was executed 2013, the suit was filed subsequently. It is a specific case that on the very date, the date I have mentioned, and there is no challenge or no question was put forward to me either in cross examination and in WS that yes, it is known to on such and such that there is some incident occurred, and from there it could be easily revealed that knowledge was there. So in absence of the same, my lord, I find
We'll start from page 138 tomorrow. We'll continue. Hard in part for further hearing tomorrow.
May I?
Yes.
Out of item number 13, my lord was trying to keep it on the 25th of November, my lord. I was struck, my lord, certainly my list for my lord.
What have you done?
Well, this appeals against a workman.
What have you done today?
I was stuck in other court, my lord. It certainly list falls, my lord. Yes.
Maximum not today.
Well, no, my lord has kept it on 25th of November, my lord.
Whatever we have done in open court, now you cannot change that.
There is a fear of attachment of the entire bank account. That's the critical.
26th of 25th
of November.
Somebody paid for time must be.
Nobody was there, my lord. I was appealing.
No, cannot be. If somebody was not there, we are just making not today.
My lord was kind.
No, Mr. Bhattacharya, we cannot
No,
do
it
that.
was fixed on 25th. No order was passed. I have asked for my lord's officer also. My lord.
No order has been passed. Has to be an order. Don't say without knowing.
My lord, in the next item, my lord, I am appealing for the respondent.
Which matter?
In the next matter.
When it is called on.
Only thing is that my learned advocate on record is joined in his family marriage out of the city. So
Entire family is marrying.
No. Family. Kindly, my lord.
Come back to when you take up the matter, we'll do
Well, I am
take
for
up.
the appellant in this matter. It will be placed on next week, any day.
You have no objection to this.
On Monday, will it? Monday? Monday, my lord, you will not come back. Wednesday.
Family marriage, so
Wednesday.
Give us a date.
Any date, my lord. Yeah,
Next matter to call করে দিন একবার বোর্ডে দেখিয়ে দিন. Next matter is 23.
23.
I will call করে বোর্ডে দেখি. ফাইল দিতে হবে না, শুধু বোর্ডে দেখিয়ে কল করে দিন. When should you keep it till?
Well, I'm praying for the not this week only. Any day, my lord, in the next week. In this
Monday,
week,
Monday,
you come back on Monday.
then?
After Monday, my lord. You come back on Monday only.
On the prayer of the respondent,
Then Tuesday, my lord.
the matter is adjourned till November 26, 2024. Tuesday.
26, no,
Tuesday.
26.
Oh, today, yes. Sorry, today we are on 19th. Sorry, 19th.
19.
November 19th, 2024.
All right. Get full.